I wonder if I understood the gentleman correctly in that I understood him to say that if we specify these acts in our accusatory pleading, the evidence to be adduced at the trial is restricted to those items which we...
Of course, and that's the whole purpose. And what you want to do is give a man no chance to know what he meets and then bring in anything you happen to think of. And it's not constitutional, and it's not fair, and just because you're a congressional committee, you can't just tear the Constitution up and throw it away.
From Washington, NPAC brings you videotaped gavel-to-gavel coverage of the House Judiciary Committee proceedings. Tonight, the impeachment debate, July 26, 1974. Here is NPAC correspondent Jim Lehrer.
Good evening for Paul Duke and myself. The House Judiciary Committee spent 4 daylight hours leading up to its first test vote tonight on articles of impeachment. And in the beginning this morning, it began by arguing over and then voting down a motion to delay the proceedings pending the results, as based on the results of the Supreme Court decision on the Watergate tapes. This was voted down, and then the committee turned to its major business. Article 1, a proposed charge of obstruction of justice against President Nixon.
And it became clear as the committee began its debate today that the Republican defenders of the president would fight every half inch of the way, employing a variety of parliamentary and debating devices in an attempt to delay the impeachment process, in effect to try to hold off an impeachment resolution from reaching the House floor. But it became equally clear that those supporting impeachment had welded a strong majority and could continue to hold that majority, despite the Republican objections that were voiced from time to time about the language employed in the first article of impeachment, the article that charges the president with an obstruction of justice. I think it was interesting today, Jim, that for the first time we saw the committee in action as a congressional committee can really be, and that is we saw wrangling, we saw acrimony, we saw members clashing with one another.
And we saw the basic issue joined in this daylight debate, the daylight session, which was the Republican position was that the wording of the articles of impeachment as proposed by Paul Sarbanes and supported by a majority of the committee were not specific enough. And that was countered, of course, by, that's the Republican charge, and that was countered by the basic majority rejoinder, which was that the article of impeachment should be general, and then there would be other things attached to it, through summaries, through everything. But that basic argument follows throughout the day and throughout the night, and you will see the beginnings of it and go right on through to the dinner break.
And now our colleague, Carolyn Lewis, who has been the on-the-scene reporter for the deliberations, is standing by at the Capitol. Carolyn?
I would sum up this day as an introduction for the general public, an introduction to the niceties and the mysteries of congressional procedure. Here was a chance to look at the way that the gentlemen talk to each other, saying the distinguished gentleman, will he lead, will he yield, will he give me time? An introduction to the way a chairman keeps control over his committee and yet has no control. Peter Rodino wanting very much to get to a vote, a final vote on the article of impeachment tonight, but not being willing to change the rules or to bend the rules, allowing each member to have his 5 minutes. So I think this is a day that really, as far as the general public was concerned, the viewing public was concerned, offered a glimpse into the way Congress works and the way 38 members, very individualistic, worked to bring themselves to some sort of vote. They did get to a vote tonight, as you both said. It was not a major vote. It could be considered a test vote. But the day proceeded in a very interesting way and certainly was revealing of the process that goes on in a congressional committee. Back to you, gentlemen.
All right. Thank you, Carolyn. And now let's go to our videotape replay of the day's events. The committee spent its day debating 2 separate issues, but was able to complete action only on the first item, and that was that motion to delay any committee action until it has made an effort to get the tapes that the Supreme Court ordered the White House to turn over to Special Prosecutor Leon Jaworski. In the first hour, Congressman Dennis urged the passage of the delay measure, telling his colleagues, get all the evidence you can. Democrat John Seiberling disagreed, saying such a move would only give the president an opportunity to delay.
In hour two, the debate changes to the Watergate case. Republican Joseph Mariziti said if offenses were committed, what were they, when, and where did they occur? Paul Sarbanes countered by saying the offense was continuing policy, and members may reach varying conclusions about when it was begun.
In the third hour, there were more questions about how specific the charges should be. George Danielson said the president had a wealth of information to use in his defense. Charles Wiggins contends the charges have to be specific because much of the committee's raw material is ambiguous and confusing.
And in the fourth hour, Republican Charles Sandman branded the draft impeachment article a miscarriage of justice because it was so vague the president would not know what he was being accused of. Also in this hour, Democrat Jerome Walde attempts to detail some specifics and concludes the president lied to the American people in statements made after the Watergate break-in.
And now let's go to the hearings themselves, as Chairman Peter Rodino prepares to start the third day of debate.
The committee will be in order, and pursuant to the rule, we will proceed to the consideration of the proposed articles of impeachment.
Mr. Chairman.
Mr. McClory, for what purpose?
I have a motion at the clerk's desk, which I have distributed among the members, Mr. Chairman.
The clerk will read the motion.
Mr. McClory moves to postpone for 10 days further consideration of whether sufficient grounds exist for the House of Representatives to exercise the constitutional power of impeachment, unless by 12 noon Eastern Daylight Time on Saturday, June 27, 1974, the President fails to give his unequivocal assurance to produce forthwith all taped conversations subpoenaed by the committee, which are to be made available to the district court pursuant to court order in U.S. versus Mitchell.
Mr. Chairman.
Mr. McClory.
I'm offering this motion, Mr. Chairman, to defer the conclusion of our proceedings for a period of 10 days, unless we get, providing that we get assurance from the President by tomorrow noon that the 64 tapes, or 63 of the 64 tapes, which the President has ordered to, or which the Supreme Court has ordered to be made available to the District Court, to Judge Sirica, are also made available to this committee. Now, the reason I mentioned 63 is that 63 of the 64 tapes which were involved in the Supreme Court proceeding were also requested by us. We subpoenaed those, and the President has failed to make them available to us. It's my understanding that these contain highly relevant materials, highly relevant information, which can be valuable to us in coming to a fair and full decision with respect to this impeachment inquiry. And it seems to me for us to conclude our proceedings without having available to us, or at least without having tried to make available to us, this additional information would not be consistent with our important role here. I might say, Mr. Chairman, that I would press more vigorously for this if I had some assurance that these tapes would be made available. I might say that Wednesday, following the Supreme Court's decision, I communicated directly and personally with Mr. McCahill, who is the Associate Attorney with Mr. St. Clair, and urged him to make this material available to us and give us some immediate response. Also, I watched the TV press conference of Mr. St. Clair and waited anxiously for Mr. St. Clair to make some offer to make the materials available to our committee, which the President is now compelled by the Supreme Court order to make available to the District Court. I didn't hear any such commitment on his part. And I have the strong feeling that there is no intention to provide the materials to this committee. I think, nevertheless, that this motion should be made, this opportunity should be offered, because later I expect to offer an article which would suggest that the President should be impeached on the basis of his contempt of the Congress in failing to respond to the subpoenas that we have directed to him for relevant and necessary materials which we require for a complete conclusion of our inquiry. And therefore, Mr. Chairman, I move the adoption of the motion.
The gentleman from Texas, Mr. Brooks, is recognized for 5 minutes.
Thank you, Mr. Chairman, and I rise in opposition to the motion and would point out that this order by the court is a very narrow order, which is restricted to a criminal prosecution. It provides only for in-camera inspection by the judge. There is nothing in this decision that gives any assurance whatsoever that this committee would ever receive any of these tapes. This committee has written to the President, has written again, has subpoenaed the President, has subpoenaed him again. He has refused to send us this and other material. We stand ready to receive any of these tapes or material now and have been ready for some weeks. I want to say that we have been eminently fair to the President in this regard. This order does not give any assurance of the committee receiving any additional information. I don't think that the public would appreciate the delay of this important proceeding. I would be opposed to it, would ask the members to vote against this motion for delay.
Would the gentleman yield to me?
I'd be delighted to yield to my friend from Illinois.
I want to agree with the gentleman that there is nothing implicit in the court's order which would indicate any obligation on the part of Judge Sirica to provide us with the materials. As a matter of fact, the Supreme Court indicates that they should be used for the sole purpose of aiding for the benefit of the defendants in the Watergate cover-up trials. But I would also indicate that we can provide the same kind of in-camera mechanism through our counsel with the cooperation of Mr. St. Clair to see that no national security information is divulged, but we only would be interested in the relevant materials regarding the subjects of our inquiry.
I yield the balance of my time.
Mr. Chairman, I recognize the gentleman from Illinois, Mr. Railsback, for 5 minutes.
Mr. Chairman, I have some questions that I would like to put to the gentleman, my colleague from Illinois. What I wonder about is it not a fact that under the Supreme Court order that Judge Sirica will be required to in-camera screen all of the 63 or 64 conversations to determine if there are sensitive or non-relevant or other privileged matters? And I'm just wondering, how much time does the White House have to turn the tapes over, first of all, to Judge Sirica? And then I'm wondering, I can't help but wonder, how long is it going to take him from a physical standpoint to listen to the tapes, to screen them in camera, to determine the possible relevance?
I'll answer the gentleman in this way. As I understand it, Judge Sirica has ordered the materials delivered to him within 10 days. And I would say this, that if the information contained in these tapes, and I understand about 3/4 of it relates to the Watergate affair, it would seem to me that we're doing a disservice by not getting this material if it is available. Now, the reason my motion is directed directly to the President and not to Judge Sirica.
Can I just say to my friend that were it not for this late date, after all of these deliberations, and with the problems that I think are very apparent, I would be inclined to agree with you. And as a matter of fact, I think perhaps if we could ascertain that the House itself, after we move, would have a reasonable opportunity or a reasonable possibility that we could get a hold of those materials, perhaps the House should act. Let me just say one other thing. There is another tape, a September 15th tape, that it's my understanding now has somehow been obtained according to a newspaper source. I will not discuss what the allegations or the reports that have been made about that tape, but it is more apparent than ever to me that if that newspaper account is accurate, it is just absolutely essential and relevant that either the House or the Senate get a hold of that tape, because it's at least there are very, very serious allegations that can be made about that tape.
Mr.
Mr. Chairman.
Recognize the gentleman from New York, Mr. Smith, for 5 minutes.
Mr. Chairman, I speak in support of the motion of the gentleman from Illinois. As the chairman knows, I was one of 6 who voted to submit our subpoenas for presidential tapes to the court, and the will of the committee was otherwise, that we would not go into court and ask the court to enforce our subpoenas. I have always thought that we should have done that, and the recent Supreme Court decision in regard to the special prosecutor's motion enforces that opinion in my mind. I think that in the state of the evidence that we have had presented to this committee, that we should make every effort to secure these tapes if we can, and it seems to me that the motion by the gentleman from Illinois is at least in that direction, and I support it.
Mr. Chairman.
I reckon. Please be in order and be silent, or otherwise you will be ejected, removed from the room.
Mr. Chairman.
Recognize the gentleman from California, Mr. Danielson. And there will be no further outbursts from the audience.
Mr. Chairman, I oppose the motion offered by the gentleman from Illinois. The Supreme Court ruling very properly did not make any reference to these impeachment proceedings, as it should not have, since it is apparent on the face of our Constitution that the Supreme Court has no jurisdiction whatever to inject itself into these proceedings. The court's opinion, the decision, was absolutely proper and in keeping with its constitutional jurisdictions.
Will the committee will be in order.
Mr. Chairman, continuing.
Gentleman from California.
Thank you, Mr. Chairman. I would also like to point out that, as have my colleagues pointed out, we have subpoenaed these tapes, these conversations, long weeks ago, and it's been within the power of the President to produce them if he chose to do so. We are ready, willing, and I'm sure agreeable to receiving any information which he wishes to present. But there is no forum through which we should proceed other than the one which the Constitution places upon us. This committee, this House of Representatives, has the full jurisdiction. Lastly, I'd like to point out that the gentleman's motion is a truncated motion. The last 6 words of the last line and the last line itself would limit this to the tapes which the court has ordered to be available to the district court pursuant to the Supreme Court order. It's my understanding that the tapes which we have heretofore subpoenaed and which we deem to be relevant are far larger in number. They cover a greater period of time than those which are included within the gentleman's motion. I therefore urge... Yes, I'll yield.
I understand we've subpoenaed 147 tapes, and this would only cover 63 of those. But
that's correct. I thank the gentleman for confirming my fear here. This is a truncated order at best. If we are going to have some compliance, some cooperation from the White House, I submit that we should have full compliance and full cooperation. This is only a half a loaf, and we're in a situation where we're entitled to the full loaf. I therefore urge my colleagues to defeat this motion.
Chairman.
I recognize the gentleman from New Jersey, Mr. Sandman, for 5 minutes.
Mr. Chairman, I oppose the resolution of my friend from Illinois. I can hardly see how we can delay this proceeding to receive some tapes when this very same committee voted down the requirement to have the most important witness of them all come before the committee and testify live. If we didn't have one day to listen to Howard Hunt, the subject matter of the entire transaction of cover-up, we have no business trying to put this thing off to listen to some more tapes. Now, I do not subscribe to the thought that the President did not honor our subpoenas, and I've said so from the very beginning. I think that he should have. For whatever reason he used, whether he's right or wrong, we didn't get those tapes. Whether we received truckloads of tapes for or against, it's not going to change the outcome of the vote here, and everybody knows it. So let's get on. You have the votes, move the resolution, and let's go home.
I recognize the gentleman from Indiana, Mr. Dennis, for 5 minutes.
Mr. Chairman, this appears to me to be an exceedingly moderate resolution which really ought to draw the support of everyone here. All it says is that if the President gives us assurances by tomorrow noon that he is going to produce forthwith the matter which is to be given to the special prosecutor, that then we'll give him the short period of 10 days in which to do so. Now, that's a very moderate proposition. It seems to me axiomatic that in the conducting any investigation, you ought to get all the evidence you can get. And certainly in a matter of this importance, you ought to. I indicated my position on the basis of the evidence as it now stands in my remarks yesterday, but my view could be changed if there's something on these tapes that ought to change it, and there may be. On the other hand, I would hope that those who are now ready to impeach could have their views modified if there were something on these tapes which was indeed exculpatory. We owe it to ourselves, and we owe it to the country to get this evidence, if we can do it, without any immoderate delay. And I might point out, in reference to what my friend Mr. Brooks from Texas says, that this is addressed to the President of the United States. If he gives us this assurance, and he can deliver these tapes if he wants to, he's not bound by the order in the way the special prosecutor is, and I suggest there are maybe half a dozen of these tapes at most which are really important. And the President of the United States knows which ones they are, and he knows what's on them. And we know which ones they are, but we don't know what's on them. Now, if he tells us by tomorrow noon that he's going to give them to us, and we're going to know what's on them, we certainly ought to be able to wait a few days in order to get that. And it isn't going to look very good for this committee if there's something really important there, or for the individual members of this committee, and we cast a vote one way or the other, which we later find, and these are going to come out within the relatively near future anyhow, would have changed our situation. Now, question of waiting 6 weeks or something, I realize we've got an important matter here, and with that we can't do. But this is a very short delay predicated upon a promise from him to produce, and I just suggest to my friends and colleagues that we really ought to take advantage of that for our own sakes, if nothing else. It's the obviously correct thing to do. So I support the gentleman's motion, and I will yield to him.
Comment, and that is that the 10 days begins today. It doesn't begin tomorrow noon. It begins today, so it would So it's really a very brief period. I join with the gentleman in expressing disappointment that we haven't had better cooperation. And I know that the suspicion is that the tapes were not produced because they contain adverse information as far as the President is concerned. But what if they do provide exculpatory information which would change our minds and provide for the President to be exonerated on one or more of the charges? It would seem to me that it would be extremely embarrassing and awkward for us to have made a decision without the benefit of all the evidence. I thank the gentleman for yielding.
Mr. Chairman.
I recognize the gentleman from Ohio, Mr. Seiberling.
Mr. Chairman, I remember some years ago when a legal trial was being argued before one of our great judges, Learned Hand, and the attorneys kept wanting to file motions and re-arguments and so forth, and finally he advised them that the court would accept no further motions or papers in the case, and the lawyers protested, and he said, "Gentlemen, some concession must be made to the shortness of human life." Now, actually, our first request for tapes from the President was on February 25th. If my arithmetic's correct, that's almost exactly 6 months ago. The tapes are in the sole possession of President Nixon. At any time, he can walk in or send Mr. St. Clair in to this committee and deliver all of the tapes, not just the ones covered by the Supreme Court. He is in complete control of that. He has heard, presumably, the arguments that were advanced in this committee. He has had access to the evidence considered by this committee, and he knows what would be exculpatory and which would tend to disprove that evidence if he has further material that would tend to disprove it. And I submit to the gentlemen and ladies of this committee that there is absolutely no reason why at any point in our deliberations or in the deliberations of the House of Representatives, which are certainly going to take more than 10 days, there is no reason why the President cannot walk in and deliver to us every piece of evidence that we have subpoenaed. And we know full well that when that happens, and if it happens, we will stop our proceedings and consider the evidence. But until that happens, I do not see why we should fool around with giving further opportunity to delay to a President who has shown that he will take every possible means to delay and drag out and obfuscate these proceedings. And I think this committee would look foolish in the eyes of the Congress and the world if we allowed ourselves at this stage in the game to be sucked into that kind of a tactic.
I recognize the gentleman from Iowa, Mr. Manning.
Thank you, Mr. Chairman. I emphatically oppose this motion for an additional 10-day delay. As you know, I have consistently urged that these proceedings be expedited. I was quite critical, perhaps unfairly so, that the committee did not get organized and underway more promptly after we were given this mandate in October, and I have repeatedly urged that the proceedings be expedited since then. It seems to me that the American people are very justifiably impatient that the matter not drag on further. I can see no justification that has been made for another delay, and I therefore urge that we proceed promptly and that this motion for delay be defeated. And I'm happy to yield to the gentleman from New York.
I thank the gentleman for yielding. Mr. Chairman, if I thought for a minute that the delay sought here was a question of fairness to the President, I wouldn't hesitate to support the motion. But I don't think this is the case. It is, I think, very straightforwardly put. There's been every opportunity, including the opportunity to come in with the tapes today or tomorrow without the necessity of this resolution.
Recognize the gentleman from Maryland, Mr. Hogan, 5 minutes.
Thank you, Mr. Chairman.
all of us are obviously physically and mentally and emotionally drained from the ordeal that we've been enduring, and now that we're up on the threshold of facing this historic responsibility, understandably we want to get it over with as quickly as possible and have it resolved, and I share that feeling. And the day before yesterday, if this motion had come before the committee, I would have opposed it. But in the interim, as you know, a unanimous Supreme Court decision came down indicating that the President's claim of executive privilege with respect to the prosecution going on in U.S. District Court has no validity. Now, if that claim for executive privilege has no validity, then certainly his claim to executive privilege in response to the subpoenas from this committee, which has an overriding constitutional right to challenge that, we have a much stronger case than Mr. Jaworski had. Judge Sirica indicates that he's going to insist that the President comply within 10 days, and Mr. St. Clair indicated the President wanted some time to listen to the tapes. I don't really see any reason for the President to listen to the tapes. It's more important that the prosecution and we have access so that we can listen to those tapes. Now, some of my colleagues have said here today that they see no reason for waiting. I see a very important reason for waiting. If the tapes are given to us, and I do think that we should send another letter reminding the President of the Supreme Court's decision so that we're on record, and if the material does in fact come to us, and I'll admit that I'm not overly optimistic, perhaps it will be more damaging to the President's case, in which eventuality we may vote out a resolution from this committee by a vote of 38-0. I think that strengthens the case in the House and in the nation. If, on the other hand, if the material is exculpatory, perhaps no impeachment resolution would be voted out at all, and we and the House and the country would be spared the ordeal of this impeachment. So I think it's reasonable for us to delay for a 10-day period so that we can at least give the President the opportunity to do what most of us on this committee thought that he should have done all along, and that is to respond to our subpoenas, because there can be no doubt in his mind or in anyone else's mind that his claim of executive privilege for refusing to comply no longer has any legal support whatsoever.
I recognize the gentleman from New York, Mr. Rangel.
Mr. Chairman, I move the previous question.
Before the gentleman moves the previous question, the gentleman from Maine had been asking for recognition. Mr. Cohen.
Thank you, Mr. Chairman. If I can have it here. Thank you. Thank you, Mr. Chairman. I would like to speak in opposition to the motion. I think that in view of the Supreme Court decision and the ruling, that there would be no hesitancy on the part of the President to turn over this information to the committee, because as Mr. Hogan has just so eloquently stated, the Supreme Court has cut away any possible basis for the withholding of that information. I, like the rest of my colleagues, would like to have that information. We've waited since February for it. But it seems to me there's a time for deliberation, a time for debate, and also a time for decision. And today is that day. We stand ready. We are a continuing investigative body. We stand ready to receive and to screen all of this information and to report it to the House of Representatives, exonerating information as well as incriminating. And I suspect that the House, if it's in doubt after the evidence has been presented to it, it can always defer the matter back, refer it back to this body for further investigation and for further recommendation. But in the meantime, I think we owe it to the American people, after all of the calls for expeditious resolution of this matter, to go forward today. And I would therefore urge my colleagues to reject the motion.
The question is, for what purpose does a gentleman from
just make a
Pennsylvania...
brief comment, Mr. Chairman.
Gentleman is recognized.
Mr. Chairman, I'm opposed to the motion. I'd like to add a question or problem that has not been discussed as yet, and that is my concern, and I'm sure the concern of many others, that every day is important. I'm concerned about the problems that might arise in the event that the House concurs and we do impeach, that the trial would be held and go over beyond the election and possibly into next year. And we run into all sorts of problems if the trial goes beyond the election of this year and possibly into next year. And I think we should give the Senate the maximum opportunity to dispose of the matter before the election.
Is the gentleman from Ohio seeking recognition?
Yes, Mr. Chairman.
Gentleman from Ohio is recognized.
Thank you, Mr. Chairman. Thank the gentleman from New York for withholding his motion for a moment. I might say that I don't have the infinite wisdom of knowing at this point what's in those tapes and would like to listen to them because it might have some bearing on my ultimate decision in this matter. But I take this time to ask the gentleman from Illinois specifically what he is after in this motion. Would you like to have 10 additional days for the President to comply?
I think that I think that it would be a mistake if the information could be made available that we would not receive it and not consider it. And so I would think it would be important for us to have this and at least give this opportunity for the President to provide us with the additional information. I might say that there has not been, up to this present time, any indication that the President would make the information available to us, and that's why I'm just suggesting until tomorrow noon, it's less than 24 hours from now, for him to make a firm commitment to us that he would make this information available.
I thank the gentleman, but I just want to call his attention before we vote to the wording of his motion. You move to postpone for 10 days unless the President fails to give his assurance to produce the tapes. So if he fails tomorrow, we get 10 days. If he complies, we do not, the way you have it drafted. So I would suggest that you correct your motion to say that you get 10 days providing the President gives his unequivocal assurance to produce the tapes by tomorrow noon.
I think the motion is correctly worded. It has been thoughtfully drafted, and unless...
I would suggest they rethink it.
Would the gentleman from Ohio yield?
I'll be happy to yield.
I would just like to point out we'd better set the record straight. And I think the gentleman from Illinois, while he says we've had no indication that the President would comply, we've had every indication, and not just indication, but a clear demonstration and a clear reply and a response from the President to this committee by letter of May 22nd that he would decline to supply this committee with any material, that we had the complete story of Watergate, that he would respectfully decline any further subpoenas that this committee would issue. So there is no question whatsoever in the mind of this gentleman that the President has no intention whatsoever of complying. It has been a period of time since letter after letter was sent to the President. We have been fair, we have been patient, we have sought, not only through letter, but through various requests. And I think it would be an idle, futile gesture for us to delay this matter of moment at this time when we have before us an issue to decide, knowing full well that we have the President's full response, which is unequivocal, categorical, and as decisive as anyone would want it to be. So I would urge that this motion be defeated, and the gentleman from New York...
You're on my time.
Would the gentleman yield...
You're on my time.
Would the gentleman from Ohio...
No, I promise to yield to Mr. Marzini.
Thank you, Mr. Ladd. I'd like to thank the gentleman from New York for withholding action on his motion. Let me briefly say, Mr. Chairman, that I support this motion. I know it's important that we conclude these proceedings at the earliest possible time, but I think it's also important that we get all the possible information we can. And I concur with Mr. Hogan perhaps several weeks ago would have been a different story, but now we have a decision of the United States Supreme Court saying very clearly that the tapes must be produced, and if it's possible, even a mere possibility, that we will have these tapes, I think we should make the attempt.
The gentleman from New York. The question is on the...
Thank you.
Mr. Mann. Will the gentleman from New York withhold this motion for purpose of recognizing Mr. Mann?
Mr. Chairman, I think it's important that the committee vote on a resolution that properly expresses the intent of the gentleman from Illinois. And if he will examine his motion, he'll find that the words fails to need to be stricken and the as put on give.
The motion is correctly worded. It provides for a postponement for 10 days unless the President fails tomorrow to give his assurance, so that there is no postponement for 10 days if the President fails to give the assurance. There's just 1 day. I think it's correctly drafted. I've had it drafted by counsel, and I was misled originally too, but I think it's correctly drafted. There's a 10-day postponement unless the President fails to give assurance. If he does give assurance, there is a 10-day delay. If he fails to give it, there's only a 24-hour, or there's only a 23-and-a-half-hour delay.
South Carolina,
I think the members understand what they're voting on.
Indiana.
The gentleman yielded to me. The gentleman yielded to me, Mr. Rangel. Excuse me, I know you didn't realize that fact. Well, you didn't. I didn't realize that. What Mr. Mann says and what Mr. Latta says is true, in my opinion. It would be much better drafted if you said provided that or unless he does not or something. But I think, nevertheless, the gentleman from Illinois is correct that although this is a very backhanded way of stating it, it does in fact state it, because it says he gets 10 days unless he fails to give assurance, which is a backhanded way of saying he gets 10 days if he doesn't, well, it's a backhanded way of stating what the gentleman is trying to state. It could be improved, but what he's doing is nevertheless there.
We all understand it. Thank you, Mr. Chairman.
The gentleman yielded it.
Itself has provided sufficient delay, and I move the previous question.
The question is on the motion of the gentleman from Illinois. All those in favor of adopting the motion, please signify by saying aye. Aye. All those opposed? No. The noes appear to have it.
Mr.
Chloe?
Call the ayes and nays.
A call for the yeas and nays is demanded, and the clerk will please call the roll. All those in favor of the motion, please say aye. All those opposed, no. Clerk will call the roll.
Mr. Donahue?
No.
Mr. Brooks?
No.
Mr. Kastenmeier?
No.
Mr. Edwards? No. Mr. Hungate?
No.
Mr. Conyers?
No.
Mr. Eilberg?
No.
Mr. Walde?
No.
Mr. Flowers?
No.
Mr. Mann?
Aye.
Mr. Sarbanes?
No.
Mr. Seiberling?
No.
Mr. Danielson?
No.
Mr. Drinan?
No.
Mr. Rangel?
No.
Miss Jordan?
No.
Mr. Thornton?
No.
Miss Holtzman?
No.
Mr. Owens?
No.
Mr. Mesvinsky?
No.
Mr. Hutchinson?
Aye.
Mr. McClory?
Aye.
Mr. Smith?
Aye.
Mr. Sandman?
No.
Mr. Railsback?
No.
Mr. Wiggins?
No.
Mr. Dennis?
Aye.
Mr. Fish?
No.
Mr. Maine?
No.
Mr. Hogan?
Aye.
Mr. Butler?
Aye.
Mr. Cohen?
No.
Mr. Lott?
No.
Mr. Fraley?
Aye.
Mr. Moorhead?
Aye.
Mr. Mariziti?
Aye.
Mr. Latta?
Aye.
Mr. Rodino?
No.
Mr.
Clerk
Chairman,
will report.
11 members have voted aye, 27 members have voted no.
And the motion is not agreed to. And pursuant to the resolution, the clerk will read.
Resolved that Richard M. Nixon, President of the United States.
Mr. Chairman, do we have a copy of what he's reading?
Copies have been distributed.
I don't have a copy.
Those copies were distributed Wednesday night. Clerk will please proceed with the reading.
Resolved that Richard M. Nixon, President of the United States, is impeached for high crimes and misdemeanors, and that the following articles of impeachment be exhibited to the Senate. Articles of impeachment exhibited by the House of Representatives of the United States of America, in the name of itself and of all of the people of the United States of America, against Richard M. Nixon, President of the United States of America, in maintenance and support of its impeachment against him for high crimes and misdemeanors. Article 1.
Mr. Chairman. Mr. Chairman, I have an amendment in the nature of a substitute to Article 1 of the proposed resolution. Mr. Chairman, the amendment is at the clerk's desk and a copy has been distributed to each member.
I ask the clerk will please read for what purpose does the gentleman seek recognition?
Mr. Chairman, I wanted to ask your advice as to the procedure. It would be my understanding that the entire resolution, as it's on the clerk's desk and that has been distributed, might be read in full and then be open for amendment at any point. In other words, I'm wondering whether in order to offer amendments we have to make them at the time that the article is being proposed, or can we not have the entire article or the two articles read and then the opportunity for offering substitute articles or amended articles at that time? What is the procedure that we're about to follow?
The clerk is at this time, pursuant to the resolution which was adopted by this committee, reading the articles for amendment. And at the present time, the gentleman from Maryland has offered an amendment in the nature of a substitute, and that would be subject to amendment and open for amendment. Mr. Sarbanes.
Mr. Chairman, my amendment's at the clerk's desk, and I ask that the clerk proceed with its reading.
Parliamentary inquiry, gentleman will state.
In normal course, would it not be necessary either to read the original Donahue resolution before the substitute were offered, or else to obtain unanimous consent or a vote that be considered as read and then offer the substitute, neither of which has been done?
In view of the fact that the rule provides that we deal with each article, the substitute amendment is in order at this time, and unless there is offered an amendment to the substitute of the gentleman, no, the clerk would continue with the reading of this article.
Well, you're going to read the substitute then?
The substitute is now being read.
I respectfully suggest that, for the reasons stated, that's not really in order at this point. Get unanimous consent, and then he could do it.
The rules would provide that the clerk would read.
They haven't read the original, that's the point.
Ask unanimous consent to waive the reading.
Mr. Chairman, will the gentleman please defer?
We did receive these Wednesday night to afford us an opportunity. And I take it we're only talking about Article 1 at this point, to seek unanimous consent that it be considered as read and open to amendment at any point.
Chairman, when we opened our proceedings here Wednesday night, we did so on the basis that since we were going to have general debate with regard to articles that were distributed, that we would forego the actual reading of the proposed articles at that time. Now it seems to me, for the benefit of all of us, those that are listening in and looking in, and those of us on the committee, it would be appropriate to now have the proposed articles read and then open for amendment at any point, at which time the gentleman could more appropriately offer his substitute Article 1. I would think that would be the more orderly procedure, Mr. Chairman.
To all of Article 1.
Well, I understand,
the procedure which the gentleman suggests would in effect have essentially a reading of what is
well, a reading and an understanding of the Article 1 as proposed, and then we would read and understand your substitute, Mr. Sarbanes. I'm not objecting to the offering. I just think that we should have the benefit of the original article before we consider the substitute.
Mr. Chairman.
Just a minute. The chair is conferring with the parliamentarian. Mr. Brooks.
Thank you, Mr. Chairman. I would ask unanimous consent that the original article be considered as having been read, and we can then proceed with the reading of the substitute offered by Mr. Sarbanes.
Reserving the right to object, Mr. Chairman.
Yes,
and the only reason I reserve the right to object, and I may feel impelled to object, is that it seems to me important for the members and others to realize what the proposed article is that we're considering before we go into the question of a substitute or a different article.
To my friend,
we did forego under my reservation. We did forego.
Let me reply to my distinguished friend and say that we've had this document before us for some 48 hours now, and I think that it would be just burdensome to read it in its entirety and then to offer the substitute by Mr. Sarbanes, and I think in the interest of time and the fullest consideration of the current matter, that
I appreciate
we would withdraw any objection.
No, I'm not going to withdraw my reservation. I'm going to urge the gentleman not to ask for his unanimous consent, because I think that we should have it read aloud. I don't think that's.
I did not ask for unanimous consent. I asked for unanimous consent that the article be considered as having been read.
I will object, Mr.
Objection is heard.
I'd move that the article be considered as having been read.
Mr. Chairman.
All right, I'll withdraw it. And
the clerk will read the articles, and at any time, the gentleman from Maryland can, at that time, ask for unanimous consent and move the adoption of his article as a substitute.
Mr. Chairman, a parliamentary inquiry. Is not the rule of the House that once, for example, a title or a bill is, the reading on it is commenced, that a substitute is in order without completion of the reading?
The gentleman is absolutely correct, and this is what is attempted to be done at this time. So, Mr. Sarbanes' amendment is in order at this time, in the nature of a substitute. The only deficiency is that the clerk did not begin to read one word of the proposed articles. And if the clerk would do so, then we can proceed, and Mr. Sarbanes can offer his amendment that time in the nature of a substitute.
Article 1. In his conduct...
Mr. Chairman.
Gentleman from Maryland.
I move that the article be considered as read. I have an amendment in the nature of a substitute to Article 1 of the proposed resolution, which is at the clerk's desk and which I offer.
The gentleman is recognized, and the clerk will read the substitute.
Article 1. In his conduct of the office of President of the United States, Richard M. Nixon, in violation of his constitutional oath, faithfully to execute the office of President of the United States, and to the best of his ability, preserve, protect, and defend the Constitution of the United States, and in violation of his constitutional duty to take care that the laws be faithfully executed, has prevented, obstructed, and impeded the administration of justice in that, on June 17, 1972, and prior thereto, agents of the Committee for the Re-election of the President committed...
Mr. Chairman, parliamentary inquiry. I believe that the panel is laboring under what I believe to be the false impression that this substitute will be read in full and open for amendment at any point. The chair has not made such a ruling, and I would suggest that the parliamentary situation, or I'd ask the chair's ruling, if there is an amendment proposed, it must be proposed at the point the proposal would come up. And I do believe that the panel is laboring under the impression that the entire article will be read and open for amendment at any point.
The gentleman is advised that the substitute is open for amendment at any point.
Well, Mr. Chairman, I respectfully suggest that that's the first time the chair has ruled that way, and you're saying it's open for amendment as it's being read, or it will be read?
That is correct.
Well, it's not open for amendment at any point until you reach that point, then. Is that right, Mr. Chairman?
Well, the whole amendment or the whole article would be read, but it would then be amended at any point, open for amendment at any point.
After the reading of the entire article?
Correct.
That's the chair's ruling now.
That is the ruling of the chair. The clerk will proceed.
Continued illegal entry of the headquarters of the Democratic National Committee in Washington, District of Columbia, for the purpose of securing political intelligence. Subsequent thereto, Richard M. Nixon, using the powers of his high office, made it his policy, and in furtherance of such policy, did act directly and personally, and through his close subordinates and agents, to delay, impede, and obstruct the investigation of such illegal entry, to cover up, conceal, and protect those responsible, and to conceal the existence and scope of other unlawful covert activities. The means used to implement this policy have included one or more of the following. 1, making false or misleading statements to lawfully authorized investigative officers and employees of the United States. 2, withholding relevant and material evidence or information from lawfully authorized investigative officers and employees of the United States. 3, approving, condoning, acquiescing in, and counseling witnesses with respect to the giving of false or misleading statements to lawfully authorized investigative officers and employees of the United States, and false or misleading testimony in duly instituted judicial and congressional proceedings. 4, interfering or endeavoring to interfere with the conduct of investigations by the Department of Justice of the United States, the Federal Bureau of Investigation, and the Office of Watergate Special Prosecution Force. 5, approving, condoning, and acquiescing in the surreptitious payment of substantial sums of money for the purpose of obtaining the silence or influencing the testimony of witnesses, potential witnesses, or individuals who participated in such illegal entry and other illegal activities. 6, endeavoring to misuse the Central Intelligence Agency, an agency of the United States. 7, disseminating information received from officers of the Department of Justice of the United States to subjects of investigations conducted by lawfully authorized investigative officers and employees of the United States for the purpose of aiding and assisting such subjects in their attempts to avoid criminal liability. 8, making false or misleading public statements for the purpose of deceiving the people of the United States into believing that a thorough and complete investigation had been conducted with respect to allegations of misconduct on the part of personnel of the executive branch of the United States and personnel of the Committee for the Re-election of the President, and that there was no involvement of such personnel in such misconduct. Or 9, endeavoring to cause prospective defendants and individuals duly tried and convicted to expect favored treatment and consideration in return for their silence or false testimony, or rewarding individuals for their silence or false testimony. In all of this, Richard M. Nixon has acted in a manner contrary to his trust as President and subversive of constitutional government, to the great prejudice of the cause of law and justice, and to the manifest injury of the people of the United States. Wherefore, Richard M. Nixon, by such conduct, warrants impeachment and trial and removal from office.
What happened was Democratic Congressman Sarbanes of Maryland offered a compromise article of impeachment, the first article being considered, charging the president with obstruction of justice. In a moment, Congressman Sarbanes will take the microphone to defend his compromise. NPAC's videotaped coverage of the House Judiciary Committee impeachment debate will now continue shortly.
This is PBS, the Public Broadcasting Service. Washington Week in Review analyzes the presidency.
Yeah, I think he does think the House will not impeach him. Now, you may think that's living in a world of self-delusion, but I think they genuinely believe that is not going to happen.
Washington Week in Review reports on the Congress.
It's becoming increasingly doubtful whether the Senate will have time this year to try the impeachment trial.
Washington Week in Review discusses foreign affairs.
Kissinger goes up and down in optimism and pessimism. I think that's clear. He saw a chance to get a deal, and he said he'd stay a few more days.
With moderator Paul Duke, Washington Week in Review looks at the major national and international events of the week. From Washington, NPAC's Washington Week in Review.
Evening at Pops is back. Arthur Fiedler and the Boston Pops Orchestra with guest stars for another wonderful summer of entertainment. Join us for an Evening at Pops.
NPAC's coverage of the House Judiciary Committee's impeachment debate continues.
As we go back to the Judiciary Committee's proceedings, Democrat Paul Sarbanes of Maryland is explaining his substitute motion for the first article of impeachment charging the President with obstruction of justice.
The gentleman from Maryland is recognized.
Mr. Chairman, I'd like to take a moment or two to speak on the substitute. It, of course, sets out Article 1, a substitute for Article 1 as it pertains to the resolution of impeachment. I think perhaps the thing that I could do that might be most helpful to the members of the committee is try to review very quickly the changes encompassed in this substitute as compared with Article 1 as it was introduced on Wednesday evening, because I appreciate the fact that the members of the committee have reviewed Article 1 introduced on Wednesday evening carefully, and in fact, this substitute is in response to that careful examination of Article 1 which has taken place, and is an effort to clarify language, clear up concepts, place this matter in a position where the debate can go hopefully to the substance and less to the form of the article as it is before the committee. If the members have the previous resolution, or they can follow the substitute, there's very little change in paragraph 1 other than to clarify that the language, the President of the United States. Paragraph 2, we are using carefully Committee for the Re-election of the President, which is, of course, the proper name, and those changes are made throughout with respect to the Department of Justice or the committee or any official reference. There is stricken the phrase "has made it his continuing policy to act," and instead the phrase "made it his policy." Richard M. Nixon, using the powers of his high office, made it his policy, and in furtherance of such policy did act directly and personally and through his close subordinates, etc. There is added the language near the bottom of paragraph 2, next to the last line, to cover up, conceal, and protect those responsible. And there is stricken in paragraph 3 the language "or others," which previously followed the word "following." The means that are set out are illustrative of the policy that is contained in paragraph 2, which is basically the gravamen of this article. And it was felt that the use of that language was unnecessary and really superfluous. The first item listed follows essentially the previous language, although it limits it to the investigative officers and employees of the United States. Paragraph 2 of the substitute was paragraph 6 of the original article. It has been placed here in an effort to group together means which seem to be related to one another, and it seemed appropriate that it should be here with 1, 2, and 3 rather than further down on the list. This is an effort, obviously, amongst other things, to introduce some additional logic into the structure of this article. Paragraph 3 is essentially the same as paragraph 2 of the original proposed article. Paragraph 4 includes interfering and the addition of the language "or endeavoring to interfere with the conduct of investigations by the Department of Justice of the United States, the Federal Bureau of Investigation, and the Office of Watergate Special Prosecution Force." 2 changes clarifying the official titles of these agencies and the addition of the language "or endeavoring to interfere." Paragraph 5 strikes the language "and concealing" and inserts "condoning and acquiescing in the surreptitious payment of substantial sums of money." And then "this means," which previously went on, "for the purpose of obtaining the silence of participants in the illegal entry." The participants in the illegal entry language has been stricken, and in place has been put "or influencing the testimony of witnesses, potential witnesses, or individuals who participated in such illegal entry." In other words, the thrust of that action encompasses not only individuals who participated in the entry, but influencing the testimony of witnesses or potential witnesses. Paragraph 6 of the substitute is identical with paragraph 5 of the original article, with the addition of "an agency of the United States" at the end of that sentence. Paragraph 7 of the substitute makes some changes in what was formerly paragraph 8 of the original article. And I think it probably would be best if I simply read that it includes the disseminating information received from officers of the Department of Justice of the United States to subjects of investigation, and then this is new language, conducted by lawfully...
Be given 2 additional minutes.
Gentleman is recognized for 2 additional minutes if there's no objection. Gentleman is recognized for 2 additional minutes.
The language "conducted by lawfully authorized investigative officers and employees of the United States" is new language. It's meant to clarify the thrust of point number 7. For the purpose of aiding and assisting, and instead of the language "their avoidance of," we insert the language "such subjects in their attempts to avoid criminal liability." Paragraph 8 of the substitute parallels paragraph 9 of the original article, and the changes are as following. Making false or misleading public statements, strike the language "in his capacity as president." So it's making false or misleading public statements for the purpose of deceiving the people of the United States into believing that a thorough and complete investigation has been conducted with respect to allegations of misconduct. And the earlier language said "at the White House," and this language has been changed to say "on the part of personnel of the executive branch of the United States," which I think is a more accurate description of the individuals that would be discussed under this means. Paragraph 9 of the substitute is former paragraph 7 of the original article, endeavoring to cause prospective defendants and individuals duly tried and convicted to expect favored treatment and consideration, which is new language, in return for their silence or false testimony, and then the balance, or rewarding individuals for their silence or false testimony, is new language. And finally, Mr. Chairman, the concluding paragraphs are a reworking, I think, essentially of the language to place it in a better form so that the final paragraph would read, "In all of this, Richard M. Nixon has acted in a manner contrary to his trust as President and subversive of constitutional government, to the great prejudice of the cause of law and justice, and to the manifest injury of the people of the United States.
I recognize the gentleman from Michigan, Mr. Hutchinson.
Mr. Chairman, I want to express my opposition to the substitute as offered. I will not take all of 5 minutes, I'm sure, but I am very critical of the substitute in its drafting, in that it does not set forth with the specific detail the exact incidents upon which any criminal indictment would have to lay. It seems to me as though in writing an article of impeachment in this general language, that you leave the defendant or the respondent or whatever it is that we call him grasping around trying to find out specifically what it is that he's charged with, what he has to answer to. This is just a lot of generalities. You don't set forth any specific incidents. You don't, and I think I think it's fatal on that account. I also raised, just by way of illustration here, another point, and I won't go through it all, but your first two paragraphs here, I'm referring to paragraphs numbered 1 and 2. You say, making false and misleading statements to lawfully authorized investigative officers and employees of the United States. It would seem to me as though you ought to at least allege that those were made to them in the course of an investigation. If they were made in an off-duty status or something of that sort, it would seem to me in that respect to be fatal, or rather defective. For all of this, Mr. Chairman, I certainly do not believe that this substitute represents the caliber of legal work that should go into drawing an article of impeachment, and so I oppose it.
Mr. Chairman, I'd like to address some questions to the gentleman from Maryland, if I might have his attention. Mr. Sarbanes, I think the mic is off. Hello? Is it working? No. Hello? Oh. Mr. Sarbanes, I'm wondering if it's your intent in drafting this article to try to limit the allegations to matters that include the President himself, either in respect to knowledge that he had or participation that he entered into, rather than to in any way try to impute criminal responsibility to him for acts of misconduct on the part of his subordinates that he had no knowledge of. In other words, are these various allegations meant to apply to the President himself and either knowledge that he had or involvement that he had in these various acts that you've enumerated?
If the acts of his subordinates were in furtherance of his policy, and that's the language set forth in paragraph 2 of the article, then those acts could be shown under the headings provided for means. Those acts would have been carried out by those subordinates and agents in furtherance of such policy. The policy, of course, is the one outlined in paragraph 2 of the proposed article.
It would have to be, would it not, a policy that would be a specific policy of his, that based not on inference but based on some facts or information?
Well, the President could establish a policy with respect to this cover-up, which his agents were subsequently implementing.
But that would have to be a specific...
The implementation of that policy by the agents could be brought forth in support of the allegations of this article.
But it would have to be a specific policy and nothing that we're inferring or from other actions that have taken place. Am I correct?
Well, there would have to be a policy of the President's. Now, you could have a policy that he had established, which he wished to have implemented. You could have that policy subsequently implemented by his close subordinates or his agents.
Let me perhaps express to you my concerns, and I think the concerns of others. Some of us don't believe in the so-called Madison concept by which you hold responsible a superior for acts of misconduct committed by subordinates. This, well, why don't you respond to that,
well,
if you can?
As I understand the wording of this language, it would not reach to the limits of the Madison superintendency theory.
All right.
Because that theory would reach to the point of, could reach to the point, I think at least, of acts of subordinates not only that the President did not have any knowledge of, but that were not in implementation of a policy of the President's.
I think you've answered my question. Let me ask you this. Would you have any objection, or do you think it would be desirable in the light of Mr. Hutchinson's comments, and I frankly, to a certain extent, share his expressed concerns, do you think it might not be desirable to have in the report that we prepare certain backup information relating specifically to each of the numbered paragraphs in your Article 1? Is that possible?
I think that's a very constructive suggestion, and I would anticipate that the report would do that, but I would be opposed to an effort to include that sort of factual material in the article. I do not think it's appropriate in a proceeding of this sort.
But it would seem to me that it would be a very good idea, and it would be more fair to the President and more fair to Mr. St. Clair if he could refer to a report that would in some detail go into the supporting evidence that supports each of the individual numbered paragraphs.
It would be my own view that the report would provide information of that sort. Whether in exactly that form, I would think would be left open, but I would anticipate that the report would provide information of that sort, yes.
Thank you. Mr. Chairman. I'd be glad to yield to...
The time of the gentleman from Illinois has expired.
Mr. Chairman.
Recognize the gentleman from California, Mr. Wiggins, on
Thank
the
you, Chairman.
amendment.
Mr. Chairman, an article of impeachment is no less pleading than any other pleading in a civil or criminal case, and its function is to give fair notice to the person charged so that he may have an opportunity to defend against that charge. It must not only be legally sufficient, but in the context of a panel such as this, we must be satisfied that the evidence justifies an otherwise legally sufficient article of impeachment. It's with that in mind that I'm going to ask the author of the proposed articles a series of questions, and I shall yield, of course, for the purpose of your answer. The thrust of Article 1 is to charge the President with an obstruction of justice, as I understand it. Is it your intent by your article to charge the President with the substantive crime of obstruction of justice? The substantive crime of obstruction of justice.
In a criminal sense?
I'm asking you the question.
No, it would not be the intention that this article would be specifically, that the contours of this article would be specifically defined in criminal terms, in terms of a criminal offense and in terms of what would be required accordingly in a criminal trial.
All right, I understand.
An impeachment proceeding, an impeachable offense, I do not believe is coincidental with a criminal offense. I think that's a view generally accepted by members of this committee, and this article is drawn on that premise.
All right. That being the premise, I think the answer to the next two questions is no. And if you just answer no rather than explain, it would preserve my time. Is it your intent by this article to charge the President with the substantive crime of conspiracy to obstruct justice?
Again, if you're using that term in a criminal sense, the answer would be no.
Is it your intention
But that does not mean that concepts pertaining to conspiracies would not be pertinent in the application of this article.
All right. Is it your intention by this article to charge the President with the substantive offense denounced in Section 1510, that is, the interference with properly constituted investigative agencies?
Well, I take it in each instance when the gentleman, and Mr. Chairman, I ask that the unanimous consent that the gentleman be given an additional minute, since I find it difficult to answer the questions
Try to keep your
simply
answers
yes or
within
no.
a minute, then, please.
When the gentleman uses the phrase substantive offense, of course, impeachable offenses are substantive. Now, if that phrase is meant, again, as I said earlier, to be coincident with a criminal offense, as defined in the criminal code, then this is not meant to be coincident with a criminal offense, although concepts that may pertain in that area might also pertain here.
I understand. And finally, I gathered that your answer would be the same with respect to the substantive crime of subordination of perjury in 1621 of Title 18.
Well, of course,
22, I believe.
If those matters can be shown in a criminal sense, then they're pertinent to proceeding under this article, but the article is not restricted solely to those matters. In other words...
Well, I think you've adequately answered. I'm merely trying to develop the theory of the article, and it appears to be your answer that the article is not premised necessarily upon a violation of the criminal law.
That's correct. It does not preclude such violations, but it is not premised and not limited to them.
I understand the answer. Now, the heart of this matter is that the President made it his policy to obstruct justice and to interfere with investigations. Would you please explain to this member of the committee and to the other members when and in what respect and how did the President declare that policy? And I wish the gentleman would be rather specific, since it is the heart of the allegation.
Well, of course, the means by which this policy has been done are the ones that are set out subsequent to the second paragraph.
Well, if the
in
gentleman
other words,
would confine himself to the question of when,
1 through
first,
9.
When was the policy declared?
Well, the policy relates back to on June 17, 1972, and prior thereto, agents of the committee committed illegal entry. It then goes on and says, subsequent thereto, Richard M. Nixon, using the powers of his high office, made it his policy, and in furtherance of such policy...
I can read the article, but I think it's rather important to all of us that we know from you as the author of that article exactly when this policy was declared, and I hope you'll tell us.
Well, I think there are varying factual matters that a member can draw conclusions in his own mind as to when the policy, as to when that policy was established. And there are different stages in this matter. There is evidence with respect to the policy having been established immediately after the break-in, or virtually immediately after the break-in. There is other evidence that pertains more specifically to the period of March and April of 1973. The wording of this article would encompass that full time period. I think the language is broad enough to carry with it the
but your intent
encompassing
is not
of the
broad. I'd like your intent to be specific, at least in your answer to me. We're talking about a policy of the President of the United States, which is the heart of your allegation, and the answer should not be confused. It ought to be specific. When was the policy declared? If I get an answer to that, I'd like to know in what manner it was declared. Now, that's not asking too much.
Well, I want to distinguish two things. One is the scope of the article, which I think encompasses the entire period or any part of it, if a policy was established at any point through that period. I think a strong argument can be made that...
Mr. Chairman, my question has been unanswered thus far, Mr. Chairman. Mr. Chairman.
Chairman, the gentleman from New Jersey will state his parliamentary inquiry.
Mr. Chairman, would it be in order to make a point of order against any kind of article of impeachment which is indefinite, uncertain? Would it be in order to make such a motion at this particular time?
I would have to say no. It would not be in order.
Then the only thing that I can do then is to object to the substitute if I want to be heard at all. Is that correct?
After the article is completely debated.
Mr. Chairman.
Of course you could be heard on.
May I be heard?
You may be.
Mr. Chairman, I oppose the substitute as I do the original article for the same reasons set forth by the ranking member and also the gentleman from California. And it is unfortunate that we haven't been able to have a ruling on this particular objection prior to today, because if we did, I think we could save a lot of time. And I would like to direct a couple of questions to the gentleman from Maryland. If I can have his attention, please. Is it your understanding of the law that articles of impeachment must be specific in order to meet the due process clause of the Constitution?
I believe that this article that's presented to you meets the law of impeachment with respect to the problem that you raised.
I didn't ask that. I asked, do you understand the law to say that an article of impeachment must be specific?
Not in the same sense that a criminal indictment must be specific, and I do not believe that the standards which govern the specificity of a criminal indictment are applicable to an article of impeachment, if that is the thrust of the gentleman's question.
Well, how don't you believe that under the due process clause of the Constitution that every individual, including the President, is entitled to due notice of what he's charged for? Do you believe that?
I think this article does provide due notice.
Well, you're not answering my question.
Well, I think I am answering the
All right, let me ask
question.
you this then. As I see this, you have about 20 different charges here, all in one piece of paper, and not one of them specific. The gentleman from California has asked for a date, for example, on charge 1 and 2. No date. You say that he withheld relevant material. When and how? Isn't he entitled to know that? How does he answer such a charge? This is not due notice, due process.
I would point out to the gentleman from New Jersey that the President's counsel entered this committee room at the very moment that the members of this committee entered the room and began to receive the presentation of information, and that he stayed in this room throughout that process.
I don't yield any further for those kind of speeches. I want answers, and this is what I'm entitled to. This is a charge against the President of the United States, why he should be tried to be thrown out of office. That's what it's for. Now, for him to be duly noticed of what you're charging him, in my judgment, he is entitled to know specifically what he did wrong. And how does he gather that from what you say here?
My response to the gentleman is that the article sets out the means. The President's counsel has been here throughout the proceedings and is aware of the material that was presented to us, and that this article, in comparison...
One last question, and this you can't answer. Do you or do you not...
I believe that this article that's presented to you meets the law of impeachment with respect to the problem that you raised.
I didn't ask that. I asked, do you understand the law to say that an article of impeachment must be specific?
Not in the same sense that a criminal indictment must be specific, and I do not believe that the standards which govern the specificity of a criminal indictment are applicable to an article of impeachment, if that is the thrust of the gentleman's question.
Well, how don't you believe that under the Due Process Clause of the Constitution that every individual, including the President, is entitled to due notice of what he's charged for? Do you believe that?
I think this article does provide due notice.
Well, you're not answering my question.
Well, I think I am answering
All right, let me ask you this then. As I see this, you have about 20 different charges here, all in one piece of paper, and not one of them specific. The gentleman from California has asked for a date, for example, on charge 1 and 2. No date. You say that he withheld relevant material. When and how? Isn't he entitled to know that? How does he answer such a charge? This is not due notice, due process.
I would point out to the gentleman from New Jersey that the President's counsel entered this committee room at the very moment that the members of this committee entered the room and began to receive the presentation of information, and that he stayed in this room throughout that process.
I don't yield any further for those kind of speeches. I want answers, and this is what I'm entitled to. This is a charge against the President of the United States, why he should be tried to be thrown out of office. That's what it's for. Now, for him to be duly noticed of what you're charging him, in my judgment, he is entitled to know specifically what he did wrong. And how does he gather that from what you say here?
My response to the gentleman is that the article sets out the means. The President's counsel has been here throughout the proceedings and is aware of the material that was presented to us, and that this article, in comparison...
One last question, and this you can't answer. Do you or do you not believe, and this can take yes or no, that the President is entitled to know in the articles of impeachment specifically on what day he did that thing which you say he should be tried to be removed from office? Is he entitled to know that in the article of impeachment? Not by virtue of the fact that his counsel was here.
I do not believe that the article of impeachment is going to contain all of the specific facts which go to support the article. If it were to do that, the article of impeachment would be 18 volumes, or whatever number of volumes are pertinent to place into it all of the specific information.
I don't think it has to say that at all. But I think it has to say that on a certain day he did something which is illegal, thus and so, period. You can say that in a simple sentence, but you are not saying that here. And in fact, there's plenty of law on this point that says that these things shall not be general. These things shall not be general. They shall be specific. This has been the case of every impeachment trial tried in the United States, all the way up to the last one in 1936. You don't dispute that, do you?
I do dispute that. If the gentleman is referring back to criminal indictments, then the thrust of the gentleman's point has some merit. But I do dispute it when he seeks to shift it to the law of impeachment.
No,
it is not a correct statement of the law of impeachment.
I'm talking about the impeachment of Justice Ritter.
The time
impeachment.
of the gentleman from New Jersey has expired. The chair recognizes the gentleman from California, Mr. Danielson.
Thank you, Mr. Chairman. Apropos the debate as to specificity as to time, I should like to point out that although this is not a criminal prosecution, there is ample precedent in our federal criminal procedural laws to establish that the only necessity for establishing a date in an indictment to which this is analogous is to bring the activity complained of within the period of the statute of limitations. here, since the pleading would indicate that on June 17, 1972 and prior thereto, but obviously in its context, within the period of time that Richard Nixon has served as President of the United States, and therefore clearly within the period of limitations for this proceeding, these events did take place and the policies were established. The only other requirement in an accusatory pleading, which a bill of impeachment will be, as to specificity on facts, is that the facts be described with sufficient particularity so that the person charged or accused can be aware of the offenses with which he is charged and thereby enabled to prepare his defense. Secondly, that an acquittal or a conviction on that charge of factual information will serve as a bar to any subsequent prosecution. I respectfully submit that the pleading before us, the proposed pleading submitted by Mr. Sarbanes, does clearly establish as to time that this policy was established on June 17, 1972 and prior thereto, but within the term of office of President Richard M. Nixon, and therefore, as to time, this is sufficiently specific. Number two, as to the facts, I would respectfully submit that they're alleged with great particularity and sufficiently enable the President to prepare his defense and to have an acquittal or a conviction serve as a bar to a subsequent prosecution, thereby avoiding the constitutional ban against double jeopardy. Lastly, I would like to point out that this document, a bill of particulars, is not an indictment, and criminal law precedents do not control. They are valuable as an analogy. But this need not be as specific as an indictment in a criminal case. Moreover, the added information which counsel for the President may want in the nature of time, in the nature of dates, places, particulars on facts, can be reached by him in the event this goes to trial in the Senate through his bringing a motion for a bill of particulars or a motion to make more definite and certain, and it is not an attack upon the validity of this proposed article of impeachment.
Gentlemen, yield, please.
I'll be delighted to yield.
Now, you have made a point that this is not necessarily the same as a criminal indictment.
That's correct.
All right. Now, even if we were to agree on that point, which I don't altogether, but let's assume we do, does the President have any less rights pertaining to due process, notice, than any common criminal would in an indictment?
He does not have less rights. As a matter of fact, in this proceeding, he has enjoyed much greater rights.
All right, now wait a minute. If he is entitled to due process, and if he is entitled to notice,
I will point out that the President has been present and participated in these proceedings since the very first hour that we have met.
Well, the gentleman
His counsel has been permitted to introduce evidence, to examine witnesses. He has a complete copy of every document that pens before this committee. Due process has not merely been observed here, it has been exalted, and I'm proud that it has.
Well, the gentleman
but the
yield,
President
please.
and no one else has ever had opportunities to be informed, such as have been provided to him in these proceedings.
Will the gentleman admit that this begins a new chapter, this begins a new charge?
The gentleman from New Jersey, I was about to yield to my colleague from California, Mr. Edwards.
Danielson. Well, thank you. The purpose, of course, is to always be fair in an indictment, and that's why it should be exact and as possible. Do you think that the President and his attorney can understand in great particularity exactly the charges, the specific events that this bill of impeachment refers to?
Well, at the risk of sounding frivolous, I would state that anyone who's in charge of the complicated business of this nation certainly would be able to understand the intendments of this proposed article of impeachment. But if, under some happenstance, this is not deemed clear to the person accused, he still will have the remedy of asking for a bill of particulars or make a motion for greater detail in the specificity of these facts at an appropriate time. Yes, due process is well served and fairness has been revered in these proceedings.
Yes, the time from the gentleman from California has expired. The chair will now declare a recess until 3 o'clock.
Many committee members had a working lunch behind closed doors as they sought to complete another round of compromise on the obstruction of justice charge. When Chairman Rodino gavelled the committee to order, the Democrats shifted strategy a bit and tried to cite some specifics to back up the charges in the draft impeachment article.
The committee will come to order. The gentleman from Texas, Mr. Brooks.
Mr. Chairman, I want to thank you for recognizing me and yield my 5 minutes to the gentleman from Maryland, Mr. Sarbanes.
Gentleman from Maryland.
I thank the gentleman for yielding. Mr. Chairman, there are 2 points I want to clarify stemming out of the discussion that was held this morning. The first deals with the procedural aspects of this matter with respect to the detailing of the factual material that underlies the article of impeachment. And there I want to make 3 things very clear. First, the President's counsel has been here throughout the proceedings. All of the factual material that the committee has considered, all of the statements of information, all of the summaries were provided to him on a daily basis just as they were provided to us. So the contours and the details and the pattern and the interrelationship of the factual matters has been spelled out fully to the President's counsel. Nothing has been concealed from him. Second, this committee, once it makes its decision, will have to make a recommendation to the floor of the House of Representatives, and at that point, what we bring forth will be supported by a report which will have to detail the underpinning for the action that we have taken. So the material will again be spelt out there for the benefit of our colleagues in the House before they make their decision. At this point, or in the House, at neither of those instances is the President yet on trial. He is only on trial when the matter reaches the Senate. And thirdly, when the matter does reach the Senate, the President's counsel is in a position to seek further specification if he deems it's necessary, although it's my conviction that his participation here and the further report that will have to be prepared for the members of the House of Representatives will fully provide him with all of the material necessary to prepare a defense for the trial which will take place in the other body. Now that's the procedural side of this thing. Let me turn for a moment to some of the substantive things. Time, of course, is not going to permit me to sketch out all of the matters which underlie the allegations in this article. But I do want to set some of them out so there's some appreciation of the detail that lies behind the charge that is being made against the President of the United States and contained in this Article 1 for the purposes of impeachment. Let us look at the pattern of conduct that began subsequent to the break-in on June 17th. The President professed ignorance of both the involvement of the committee to re-elect the President and White House involvement in Watergate in the face of discussions of Watergate on or before June 20th with Haldeman, Colson, and Mitchell, persons aware of such involvement in the President's closest advisors. On the morning of June 20th, Haldeman, Mitchell, Ehrlichman, Kleindienst, and Dean met in the White House in the early morning. Later that morning, Haldeman met with the President. Later that morning, Haldeman met with the President. The Chief of Staff met with the President, and his notes indicate that in that conversation with the President, Watergate was discussed. The part of that tape pertaining to the Watergate discussion is the 18.5 minutes that is missing, in which an expert panel, as reported to Judge Sirica, was manually erased. The President has refused to honor subpoenas of this committee seeking conversations with Haldeman and Colson on June 20th. On the 22nd of June, the President made a statement that Mitchell and Ziegler had stated the facts accurately when they had said there was no basis for believing of involvement. On the 23rd of June, the President had a meeting with Haldeman, his Chief of Staff, subsequent to which Haldeman and Ehrlichman met with Helms and Walters and in effect directed them to indicate to the FBI that the pursuance of the investigation into Mexico should be halted because it might encounter CIA activities. The day before, on the 22nd of June, Helms had told Gray, the FBI director, that there was no CIA involvement. And at that meeting, initially Helms and Walters reported to Haldeman and Ehrlichman that there was no such involvement. On the 20th of June, Mitchell apologized to the President because some of his people had gotten out of hand. He regretted that he had not policed the people in his organization. We heard that tape. On the 30th of June, there was a conversation with Mitchell in which the President indicated that they must cut the loss from potential disclosures about CRP involvement in Watergate by having Mitchell resign as campaign director. On the 6th of July, in a conversation with the President, the director of the FBI, Patrick Gray, told the President the members of his staff were trying to mortally wound him. The President paused for a long time and then said to Pat Gray, "You just keep on with your aggressive and thorough investigation." He did not ask Pat Gray then or later what he meant by that, who was involved, who was trying to do it, how they were trying to do it. On August 29th, the President issued a statement concerning the Dean report. She went before the American people and said he had asked John Dean to investigate the matter.
Has expired. Mr. Mariziti.
Thank you, Mr. Chairman.
Recognized for 5 minutes.
Gentleman from Maryland explain why it is not necessary to detail the facts. And one argument given is that the counsel for the President was present in the room when these matters were being discussed. That is not a satisfactory disposition of the matter. It reminds me of counsel for a defendant appearing in the magistrate's court. There's a presentation made of an hour or two, and then the prosecutor of the county has a very general indictment, and it's not sufficient for the prosecutor of the county to say, "I don't have to specify," because the counsel for the defendant attended the preliminary examination. And the knowledge of the counsel is not the knowledge of the President. We don't know whether the counsel for the President that appeared here is going to be an associate counsel or one of a number of counsel, or whether there will be different counsel. Now, he makes a point of once the resolution or the articles get to the floor, they can be justified and amended and so on. That may be so. But I think it's necessary, Mr. Chairman, members of this committee, for us, the members here and now, before we vote for or against a particular article, to know the time and place and names, to know all the events. Now, I have done some legal research during the noon recess, because it was represented that the law that pertains to indictments does not necessarily apply to impeachment proceedings. And I found that from the very beginning, when impeachment proceedings were instituted in 1798, right down to the present time, the last impeachment of Judge Ritter in 1936, that every respondent charged has been faced with articles of impeachment that allege specifics. And there's a reason for it. There's a reason for it so that he who is charged, and this is fundamental to Anglo-Saxon law, that he who is charged must know on what particular charge or points he must defend himself. It's not necessary for him to go over the tremendous amount of information that we have here and say, well, maybe they'll accuse me on this and maybe on that. And it's very simple, Mr. Chairman, because the gentleman from Maryland began to specify certain times, places, and events. Now, if that is it, if that's what the charge is, simply include it in the articles of impeachment. Just to take an example, on the point 1 of the paragraph 1 of the article, making false or misleading statements. All right. What statements? When were they made, and where were they made? That's simple, because if you're going to know about it when it goes to the House of Representatives, we ought to know about it now. To lawfully authorize investigative officers. What officers? 1, 2, 3. When and where? What's so difficult about that? Number 5, approving, condoning, and acquiescing in payment of substantial sums of money. All right. How much money are we talking about? The amounts, the purpose. I'll yield as soon as I'm through. The purpose for which the money was given. To whom was it given? How many persons are involved? Number 6, endeavoring to misuse the Central Intelligence Agency. That's a very broad, general statement, and it may be true. I am not denying it, and I'm not affirming it either. Endeavoring to misuse the CIA. Well, we ought to know how, when, where did this occur? Disseminating information received from officers. What information? What officers of the Department of Justice? And that can be characterized throughout the entire part of this article. Number 8, making false...
Expired.
Thank you. Thank you.
I recognize the gentleman from Massachusetts, Mr. Dono.
Thank you very much, Mr. President. I desire to yield my 5 minutes to the gentleman from Maryland, Mr. Sarbanes.
Gentleman from Maryland is recognized.
I thank the gentleman for yielding his time, Mr. Chairman, and it does give me an opportunity at least to try and summarize a few of these, of this initial outline of facts. I think it's important that they be understood, that a perception of the underpinning that rests behind this article be generally appreciated. Let me go back for a moment. I was up to August 29th. On July 8th, the President and John Ehrlichman walked on the beach in California. And the subject of clemency for Watergate, for those involved in Watergate, was brought up. And Ehrlichman reports that the President rejected it and said that they were not going to consider that. But the essential question is, why was it brought up at all with respect to men who had not yet been indicted 6 months in advance of trial? People, it was contended at that point, had absolutely no connection with the committee to re-elect or with the White House. On August 29th, as I was saying earlier, the President issued in a public statement the report that John Dean had carried out a comprehensive investigation, had reported that no one in the White House was involved. There was no such investigation, not at the moment. If the gentleman will allow me to continue, I want to try and get out some of these facts in a substantive way.
What I'd like to know, is this a new statement or
about.
is this a rehash of what we had? Maybe this is a new statement, is it?
Subsequent to the 29th of April, on the 15th of September, the President met with H.R. Haldeman, his Chief of Staff, and with John Dean. And Haldeman at that point said to the President, before Dean came into the room, that he had done a good job and he had kept people from falling through the holes. Now, that was a piece of tape that we picked up accidentally when the staff went down to record at the White House. And it proved to be highly relevant, even though it had earlier been asserted that it was not pertinent to our inquiry. Then John Dean came into the room. And our transcript, the committee's transcript, taken from the tape of that conversation, has a conversation opening with the President saying, hi, how are you? Now, this was the day that the indictments were returned in the Watergate matter. They were limited to 7 people, and it was assumed that it had been cut off at Hunt and Liddy and would not go higher. So the President says to Dean, hi, how are you? Dean says, yes, sir. The President, well, you had quite a day today, didn't you? You got a Watergate on the way, huh? And Dean says, quite a 3 months. That quite a 3 months by Dean is missing, ladies and gentlemen, from the edited transcripts of the conversation of September 15th, which were submitted to this committee by the White House and which were made public to the American people. Subsequently, in that conversation, the President went on and said that a lot of stuff went on, that Dean had handled it skillfully, putting his fingers in the dike when leaks had sprung here and sprung there, and that you just try to button it up as well as you can and hope for the best. And remember that basically the damn thing is just one of those unfortunate things, and we're trying to cut our losses. We're trying to cut our losses. Now, they succeeded in covering up through the November election, and then early in the year, things began to come apart. They started slowly and accelerated. And we have in January discussions, the President and Colson, a discussion about clemency for Hunt. Again, Colson says that there was no assurances made, but the discussions were held. The subject was brought up. Why were they bringing up this subject with respect to people for whom they denied any connection at an earlier time? And then in late February, the President begins to have some conversations with Dean, and those continue in late February and into March. And of course, beginning with March 21st and coming forward, things begin to snowball. Let me go back to the March 21st conversation. It is imperative that you take the transcripts and read through them, and that you read through them not only in terms of what is being said then as to what is happening, but refer it back as to what happened earlier. Because there are discussions of how it developed, what the pattern was, what the problems were that came forth. And in that conversation of March 21, 1973, in the morning, at which the President, John Dean, H.R. Haldeman, the President's Chief of Staff, were all 3 present, the President said to John Dean, all right, fine. And my point is that we can, you may well come. I think it is good, frankly, to consider these various options. And then once you decide on the plan, John, and you had the right plan, let me say, I have no doubts about the right plan before the election.
Time of the gentleman has expired. Mr. Smith.
Mr. Chairman, I would like to yield my time to the gentleman from New Jersey, Mr. Sandman.
Sandman is recognized.
I would like to
5
start
minutes.
with one simple question. It certainly deserves a simple answer. I have just heard a rehash of all of the excerpts from all of the tapes. My question to the gentleman from Maryland who just presented those, is this a new document that you've submitted? Or what was your purpose?
No, I'm recounting back over the transcripts of the tapes pertinent portions of that conversation.
Well, if it's not a new document, then we're back to where we started. Why are you resisting the fact that this should be in the articles of impeachment? Isn't the Congress entitled to know what they're going to vote on when it gets to them? Shouldn't they know when it happened and how it happened? Shouldn't this be in the articles? A brief answer from the gentleman from Maryland, if he has one.
Well, I responded to that question this morning when the gentleman said it, and I said at that time that if we were to bring into the articles all of the factual material which underpins them, we would have to have articles that ran into volumes and volumes.
Now that is not so, and you know it is not so. In a moment I will yield. You know that is not so, any more than it is in an indictment. You don't need the whole brief in an indictment, and I don't want to be confused again by saying this is an indictment. It isn't. But the common criminal in a criminal case has no more rights than the President of the United States in an impeachment case. This is what I've said.
Would you yield?
No, I won't yield. I'm not finished. Now, the important thing here is, why isn't the President entitled to this kind of simple explanation? It can be in a single sentence. We don't have to go through the speech that you made. All you have to say on any one of your articles, a very simple sentence. On such and such a date, the President did, contrary to the law, a simple act. That's all you have to say, and why won't you say it? I want him to answer it, not you.
Will the gentleman yield?
Sure, a simple answer.
Behind each of those allegations lies an extensive pattern of conduct. That will be spelled out factually and will be... If the gentleman would let me finish, I am endeavoring as best I can to respond to his question.
All right, go ahead.
And that pattern of conduct will be spelled out in the report that accompanies the articles. But there is not one isolated incident that rests behind each of these allegations. There is a course of conduct extending over a period of time involving a great number of people.
I'm not going to yield any further. It's my time you're using up. I'm not going to yield any further for that kind of an answer. You are entitled to your proof. No one said that you aren't. You are entitled to as many articles as you can get the Democrats and some Republicans to agree upon. And no one says that you're not entitled to that. But to each of these, my friend, the law from the beginning of this country up to the last impeachment in 1936 says, whether you like it or not, it has to be specific, and this is not specific.
In a moment, the chairman will try to shed some light on the issue by asking for advice from special counsels Dorr, Jenner, and Garrison. INPAC's videotape coverage of the House Judiciary Committee's impeachment debate will continue shortly.
This is PBS, the Public Broadcasting Service.
Can you hear it? Sure you can. Sound familiar? Sure it does. Feel that tingle? Oh, tingles are good, especially Tingles Revisited. Here it comes, the Great American Dream Machine. Re-originals of your favorites, as crisp and crunchy as the day they first came down the pike. I'm Marshall Efron, inviting you to hook up to the Great American Dream Machine. It'll make you feel good. The Great American Dream Machine.
Award-winning films from the Washington National Student Film Festival, as judged by Nicholas Ray and Stan Vanderbeek.
NPAC's coverage of the House Judiciary Committee's impeachment debate continues.
As we go back to the proceedings, the issue under discussion is whether or not the draft article of impeachment is specific enough to be fair to the President.
The Chair would like to address a question to counsel of this staff, which has had the whole matter before it for a period of time, citing the precedents and the history of impeachment as to whether or not there is a requirement that there be specificity in the preparation of articles for impeachment. I address that to our counsel.
Mr. Chairman, in my judgment, it is not necessary to be totally specific. And I think this article of impeachment meets the test of specificity. As the congressman from Maryland said, there will be a report submitted to the Congress with respect to this article if the committee chooses to vote this article. And behind that report will be the summary of information as well as the all of the material that was presented to this committee. Prior to trial in the Senate, the counsel for the President is entitled to make demands for specificity through perhaps a motion similar to a bill of particulars, and so that all of those details may be spelled out. But from the standpoint of this article, my judgment is firmly and with conviction that this meets the tests that have been established under the procedures.
Mr. Chairman, would the chairman yield? Would the chairman yield? Would the chairman yield so that we might get an opinion from Mr. Garrison?
Address the same question to Mr. Garrison.
I have not, frankly, spent a great deal of time researching this question, but I would say that while it may very well not be a requirement of the law, it clearly can be said to be the uniform practice of the past to have a considerable degree of specificity in the articles. And I would cite the members of the committee to a publication of this committee, October of 1973, entitled Impeachment Selected Materials, and beginning on page 125, concluding on page 202, every article of impeachment which has been tried in the Senate is set forth, and I would be less than frank, Mr. Chairman, if I didn't suggest that a simple reading of those articles would suggest an enormous amount of factual detail. As a matter of fact, to an extent that is actually not included in indictments. There are not only times, dates, and places named, but sometimes there are the sums of money that allegedly have been misappropriated. I would refer you, for example, on page 173 to the fifth article against Judge English, in which the judge was accused of inebriacy, and I'm sure much to his embarrassment, the article goes on at great length describing exactly when and where he was drunk.
I would like to address the same question to Mr. Jenner. The gentleman is associate counsel of this committee, associate to the staff as counsel, and for a while and for a great while served by selection of the minority as the minority counsel. Mr. Jenner.
Thank you, Mr. Chairman, ladies and gentlemen. An article of impeachment as of the present day is to be viewed in the light of the progress made in the field of criminal procedure by this Congress and by the progress made under the Enabling Act by the advisory committees of the United States Supreme Court adopting the Federal Rules of Criminal Procedure. And secondly, arising out of the electrical cases, the multi-district panel plan by which all complicated cases are reviewed, whether they're multi-district or otherwise. And as a result of that progress that has been made with respect to the Federal Rules of Criminal Procedure and the new Federal Rules of Criminal Procedure, which have now been approved by the House of Representatives, and I believe this committee, it is no longer necessary to specify either in civil or criminal complaints a range of specificity that accompanied the needs of a past era. And all that is necessary under the cases is that the bill, the complaint, and I respectfully suggest the articles of impeachment give but what is called notice or notice pleading, and that is in itself sufficient. Under the Federal Rules of Criminal Procedure, under the discovery provisions, the President may obtain all of the 38 books, all of the summaries, all of the materials that are before this committee, as is specifically stated in Rule 16, that is, the rules now in effect, not even counting the new criminal rules that have been approved that are not yet in effect. So that in considering present-day articles of impeachment, you must have in mind the progress that has been made in those respects in the last decade.
Thank you very much. I recognize Mr. Edwards.
Thank you, Mr. Chairman. I think it's important to continue to present proof of the charges in the bill of impeachment. I'm sure that there are going to be many byroads and many other issues that will be brought up, but I think it's vital that in these proceedings the evidence be spelled out so that we all can understand it better. In support of the first portion of the bill of impeachment, Mr. Sarbanes presented some very clear evidence of the President's knowledge almost immediately after the June 17, 1972 burglary at the Watergate. And I think that anybody here can understand the reluctance of the White House and the President to have the public find out about this and find out of the connection with his committee to re-elect of Mr. Hunt and the other people who were arrested for the burglary. Well, one of the choices would have been just to let them go to jail and call it a bizarre incident, and I think it's very clear that that was a choice, and every effort was made to have it appear that was it, just a bizarre incident. Yes, perhaps there could have been some connection with the White House with Mr. Hunt and so forth. Or another choice would have been just admit Mr. Hunt worked at the White House, yes, had an office there, was in the White House phone book, and then down the road let Liddy, chief counsel, I believe, for the committee to re-elect, surface. He was bound to surface. Well, why not take that choice? That could be ridden out, perhaps, by the White House, even as Watergate itself was ridden out. But why do you imagine the President had to, or felt he had to, encourage such a massive cover-up after June 17th, shortly thereafter the burglary? Why not let it hang out? That was discussed quite a lot. We all remember that in the transcripts. Why not direct the FBI to go ahead and do a darn good job and really complete the investigation as they started out trying to do? Why involve the CIA in this unfortunate behavior? Why encourage or almost demand that the CIA go to the FBI and say, stop, don't continue your investigation, stop where you are. By all means, don't get into that money that was found on one of the burglars. Well, incidentally, it was successful. The efforts by Mr. Dean and the others to direct the CIA to influence the FBI not to continue the investigation. It was successful until June 5th, and when Pat Gray finally said, no, I'm not going to do it anymore, and went to the CIA, and the CIA said, oh, no, of course we don't have anything to do with that anything in Mexico where your investigation might disclose some unfortunate things are going down there, something clandestine by the CIA. Well, here's the key to it. Immediately, the next day, actually, the White House knew that Hunt was involved. His name was in the phone book. He had an office at the executive office building. And Liddy had to be exposed somewhere down the line. The money on the burglars could immediately be traced to Liddy, the Mexican banks, and back to the committee to re-elect the president. Sloan had given the money to Liddy to launder. That was all sure to come out. But what would the exposure of Hunt and Liddy reveal in addition to their participation in the Watergate burglary and their connection with the committee to re-elect the president and the White House? Hunt, original plumber, just about the original plumber, came aboard the White House in July 1971, and suppose, and this probably would have happened if it had all come out right there with a FBI investigation, an honest, hard-hitting FBI investigation, that after Mr. Hunt went to work as a plumber at the White House, in late 1971, he composed the fake DM cables, attempting to link former President Kennedy with the DM assassination. Tried very hard to sell those cables, not to sell them, but to get Life magazine to write them up as real. It's very much to the credit of the magazine that they didn't do it. On July 22nd, this is just a few weeks after Mr. Hunt became a plumber at the White House, he went to the CIA in these famous visits where he got a red wig and a voice changer and fake identification papers and so forth. He put on this disguise shortly after that and went to Massachusetts to interview a Clifton DeMott in hopes of digging up some dirt on Senator Ted Kennedy. What else was Mr. Hunt doing during this period shortly before Watergate that would have been exposed? He had taken the famous trip to Denver, Colorado, in the same red wig with the voice changer to interview Dita Beard, who was in a hospital bed there in connection with the ITT case. We all remember the famous Dita Beard ITT memorandum. And then, for all we know, another project of the plumbers that John Dean testified to but did not come off might have been exposed, the planned bombing allegedly ordered by Charles Colson of the Brookings Institute so that in the confusion people could rush in and take out a report that was being written. But more importantly, what would have been exposed? The burglary in Los Angeles on September 2nd, 1972 of Dr. Fielding's office in Los Angeles. Who was involved in that burglary that was also involved? Participants arrested at the Democratic National Committee. Mr. Barker, Martinez,
Time of the gentleman has
De Diego.
expired.
Yes.
Time of the gentleman has expired. Mr. Butler.
Thank you, Mr. Chairman.
Recognize you for 5 minutes, Mr. Butler.
I share the concern raised by the gentleman from New Jersey, Mr. Sandman, and I would like, if I may, to return to our questions of Mr. Jenner, if you could answer a few more questions for me. We really have so much information that it's not sufficient to say to the counsel for the president that he's entitled to all of those 38 books, because we really have so much we don't have any. I'm concerned that the president is entitled to know what facts are going to be induced against him. So my question is this, based on your view of the precedents and your experience, is the president entitled to know at some point prior to trial just exactly what facts will be adduced against him?
I think in an impeachment proceeding that he is so entitled.
Now, how would counsel for the president go about getting that information if it were not spelled out specifically in the articles of impeachment?
In the proceedings that take place prior to trial, he is entitled to ask for and receive, virtually without subpoena, without process, but by request under supervision of the Chief Justice, who will perform the function of the presiding judge, the production of all materials in the possession of this committee bearing upon the issues presented by the article of impeachment. Under the present practice, especially in civil cases, but substantially so also in criminal cases under the criminal rules and the multi-district panel manual, counsel are required in criminal cases subject to the Fifth Amendment, of course, the Fifth Amendment rights, to all of the material that bears upon the issues in the case.
Counsel?
In just one moment, if I may ask him one more question. Is the President also entitled to know sufficiently in advance of the trial the facts that may be adduced in order to prepare a defense, so it cannot come to him at the last moment?
I think he's entitled to that, Congressman Butler, but he's not entitled to it by way of a specific pleading. He is entitled to know, and he will receive, under the present modern practice, the facts, which I assume you mean evidence, of all bearing upon the issues stated in the bill.
Well, whether he gets them sufficiently in advance will depend upon whether he asks the question soon enough. Is that in part?
Well, that'll depend on the President's counsel, of course, but yeah. Mr. St. Clair has demonstrated here as one of the most able lawyers in America. He is experienced both in the civil and criminal field, and we anticipate, I think without peradventure, that he will proceed to do so, sir.
All right. Now I yield to the gentleman from Indiana.
I would like to thank the gentleman for yielding, and I would like to ask Mr. Jenner if Rule 7 of the Federal Rules of Criminal Procedure does not provide that the indictment or the information shall be a plain, concise, and definite written statement of the essential facts constituting the offense charged.
That rule so reads, sir.
I thank you. I yield back to the gentleman from Virginia.
Time remaining, Mr. Chairman, I'll yield to the gentleman from Maryland.
The gentleman from Maryland is recognized.
If I could further ask counsel, either Mr. Dorr, Mr. Jenner, or Mr. Garrison, would it be possible for Mr. St. Clair to not request any additional information or specificity and wait until the time of trial in the Senate and then move to dismiss the impeachment on the grounds that it's not specific?
He may do that, Mr. Hogan, at the greatest possible grave risk of waiting until that particular time. That is...
Except as a practical matter, he has all the material already.
That's correct, sir. And the Chief Justice, in presiding and ruling upon that motion, would have that in mind.
But the real thrust of my question is, would he prevail in offering that motion for, in effect, a directed verdict?
I think not, sir, under the present modern practice.
Mr. Chairman. The time of the gentleman from Virginia has expired. I recognize the gentleman from Wisconsin seeking recognition.
Yes.
The gentleman is recognized for 5 minutes.
Chairman, I'd like to take this time to yield to my colleague, Mr. Danielson, because on the question which nags that of specificity, I think that he has something further to contribute. Danielson?
I thank my colleague, Mr. Kassemeyer, for yielding. The points raised by the gentleman from New Jersey, Mr. Sandman, and others along his line, I'm fearful have a motivation, perhaps, an intent which we must avoid in this case of impeachment, namely by specifying some one overt act following one of the articles, one of the listings of impeachable offenses. We might thereby narrow the area of proof under which the prosecution of this case, the managers in the Senate, would be entitled to produce evidence. By stating, for example, under the first item, the making of false statements to investigative officers or whatever that is, if we were to list a specific false statement that may have been made on, let us say, June 30th, 1972, would we not then, in the Senate, be limited in our proof to evidence which would relate directly to that specific false statement? In a moment, I may yield. Likewise, the fact of notice pleading, which our counsel, Mr. Jenner, has pointed out, is clear here. The President is put on notice as to the specific types of impeachable conduct which we allege against him. This is enough to alert him, to give him notice as to what are the charges. And bear in mind that if and when this matter reaches the Senate, it will be accompanied not only by a committee report, but of course by the final articles of impeachment, and he will then, if he desires, have the right to make a motion for a bill of particulars or related motion, the idea being to request greater specificity in the charges against him. Or if some of those charges appear to be a little bit vague and uncertain as to time and place and manner, he can make a motion to make more specific and certain. And aided by the results of those motions, he will have a wealth of information, everything that he could possibly need to make his own defense. In this case, he is even in a better position simply because, and I know this cannot be charged to him at the present time, but as a practical matter and in the real world in which we're operating, the President does have some 40 volumes of evidentiary and statistical matter already at his disposal and in his office, and I think that unless we're to stultify common sense, we're going to acknowledge that that is a fact. I would say this: if this committee should decide, in order to lessen the concern of our colleagues on the other side of the aisle, list any specific item of factual information in these articles, it must be couched in such language and the committee report worded in such language that it's eminently clear that proof in the Senate would not be restricted to those specific items.
You promised to yield.
It's not my time. I yield back to Mr. Kastenmeier.
Gentleman from Wisconsin has time remaining.
Mr. Chairman, I yield back the balance of my time.
The gentleman from Indiana is recognized for 5 minutes.
Chairman, I would like to ask one question of my friend from Maryland, briefly, if he'd give me his attention for just one moment. On the theory you advanced of your article this morning, as I understand you, and am I correct, that before the acts of alleged agents and subordinates could be attributed to the President, you would have by some means and some type of evidence to establish the existence of the policy which you allege he had adopted. Is that correct?
The acts of the subordinates would have to be carrying out the policy
yes,
of the President.
And before you could prove them as against the President, you would have to first establish the policy, would you not?
Well, there's a possibility of a ratification involved here, which I think
But before you could attribute their acts to him on your own theory, you'd have to have a policy there which they were carrying out. Isn't that right? You'd have to have the policy established first.
Not if there were a ratification involved. And there could be a ratification involved on the part of the President with respect to acts of his subordinates.
You'd have to prove a ratification.
But absent a ratification, there'd have to be an established policy.
What the gentleman is really doing under another name is adopting a theory of a conspiracy, isn't he?
Well, I was asked that question this morning, and I think I indicated that while I did not tie the article to the proof of a criminal conspiracy, that I did say that the article contained elements of a conspiracy theory.
And
yes.
First, by Hornbook law, you've got to prove that the conspiracy exists before the acts of co-conspirators are attributable to the principal. That's just elementary, is it not?
Well, the President can intrude into that conspiracy and ratify events. If that happens, then I think the gentleman would recognize that those acts are then part and parcel of the President's responsibility.
I suggest to the gentleman that proceeding on the theory he's proceeding on, he better consider, if he has not, and of course he may have, just by what evidence he's going to establish this policy or conspiracy or whatever you want to call it, because until he does that, the acts of these other people aren't going to mean a thing, in my opinion. Now, shifting to another matter, I'd just like to talk about this matter of specificity for a moment. In a criminal charge, I just read the criminal rule, and that's the existing criminal rule. This is at least a quasi-criminal case, and my friend from California, Mr. Danielson, I am sure, is aware of the Due Process Clause, and the very reason why we require specificity is the exact reason why my friend from California seems to be against it. It is for the exact purpose that a man may know what he is charged with, and that the proof may be held down, indeed, to that with which he is charged. And I suggest that ordinary due process of law absolutely requires that. Now, I'm not going to yield for a minute. No one contends, I don't contend certainly, that you've got to plead in an indictment all the evidence by which you intend to support your specific charge. But you do have to say, if you're charging the man with making false or misleading statements, you do have to say, in that, on the 14th day of April 1973, he did say to Henry Peterson, a dead Assistant Attorney General of the United States, the following, so that he'll know. He can't be required under the Constitution to look back over everything he may have said sometime that somebody is now going to say was false or misleading. You've got to specify to that extent, and there's only one precedent in this particular case, and that's the case of Andrew Johnson. And if you'll look at the articles set forth in page 154 of our own publication, you'll find that they were exceedingly specific. On a certain date, he discharged Secretary Stanton contrary to the Tenure of Office Act by writing him the following letter. And on a certain date, he conspired with one Lorenzo Thomas to make him Secretary of War when
Would
no
the gentleman
vacancy
yield?
existed. I will for about 30 seconds because
That's about all the
not giving me
gentleman.
much time.
That's about all the gentleman has.
Well, I hate to yield it to you then, but I'd like to hear an answer at that.
I wonder if I understood the gentleman correctly in that I understood him to say that if we specify these acts in our accusatory pleading, the evidence to be adduced at the trial is restricted to those items which we...
Of course, and that's the whole purpose. And what you want to do is give a man no chance to know what he meets and then bring in anything you happen to think of. And it's not constitutional, and it's not fair, and just because you're a congressional committee, you can't just tear the Constitution up and throw it away. That's what you want to do here.
Would the chairman yield the gentleman 2 minutes that he could yield to me to respond, please?
The time of the gentleman has
I
expired.
don't want 2 minutes to yield.
May I...
The gentleman from Maine has been seeking recognition, Mr. Cohen.
Thank you, Mr.
Recognized for
Chairman.
5 minutes.
If I could, I'd like to address a question to the gentleman from Maryland, Mr. Sarbanes. Mr. Sarbanes, I would assume that in each of the subheadings under the article that you propose to substitute, and let me say that I think the statements as conclusions I can agree with most, if not all of them. But let me turn to page 1 under Article 1, where you list subtitle 1, making false or misleading statements to lawfully authorized investigative officers and employees of the United States. Now, would it be fair for me to assume that you would rely upon certain, Mr. Dennis said, essential facts? I would hesitate to use the word operative facts in this context. But is it fair to say that you would rely upon 1, 2, 3, or 4 specific dates and operative sets of facts to support that general statement, the making of false or misleading statements to lawfully authorized investigators? Is that fair to say that you have that in mind?
Yes, although I would, in most of these instances, when it's finally detailed, I would assume in the report, would really think of many more instances than the number the gentleman... One of the problems is that there is a course of conduct and not a single event.
I understand. And would it be fair to say that you would probably refer to the summary of information that's been presented by Mr. Dorr and Mr. Jenner such as summary pages 30 through 32, to support that specific operative set of facts?
Well, I would assume that the report would go further than that. Well, the report could do that, but I would also assume that the report would spell, this was the response I gave this morning to the gentleman from Illinois, that the report would spell out the matters.
The problem that I've had for several months now, and usually with counsel, Mr. Dorr, Mr. Jenner, you may recall that in each time we issued a subpoena, I specifically asked you, inquired, and was always rejected, as to whether or not we might attach the specific justifications which you set forth in great detail, justifying the issuance for those subpoenas and the reasons why we needed them. And I'd just like to inquire, I think I know the answer you'll give me, but is there any reason why a document could not be attached to the articles, proposed articles of impeachment, with a phrase to the effect, all of which is set forth with greater particularity in the appendix attached here too? In other words, getting into the civil pleading, I happen to agree with counsel, Mr. Jenner, that we're talking not necessarily criminal pleading, but also perhaps civil pleading, and we do have notice pleading in civil cases, and we also have the very well-established doctrine of incorporation by reference. Now, wouldn't that be helpful in this particular instance?
My understanding, Mr. Congressman, is that this material would be included in the report and would go along with the articles. Now, whether it's attached that way or attached to the pleading, my understanding further really is immaterial, but generally speaking, in civil pleading that I've been familiar with, is that you don't incorporate this by reference. You furnish it by way of answers to interrogatories or other discovery pretrial procedures.
But it certainly would be helpful in this instance to at least incorporate by reference several operative sets of facts supporting the general allegation, which again I can agree with, that the making of false and misleading statements to lawfully authorized officers, I agree with that. There were false statements made. And I think we can, by the simple act of incorporating by reference, clear away the problem, really. I yield to Mr. Rangel, gentleman from New York.
Thank you. I wonder, as we try to talk about specifics so that the President would be in a better position to defend himself, whether we're really taking in consideration that the mandate of this committee is to report to the House of Representatives. And it seems to me that if we got bogged down with specifics before the House of Representatives has worked its will, that perhaps we would not give the general recommendation to the House that it rightfully deserves. It is not our constitutional responsibility to impeach the President, but merely to report to the House, so that it seems to me that we should not be talking about specifics, but give the maximum amount of information to the House of Representatives so that they can deal with the problem constitutionally.
I thank the gentleman for yielding. Mr. Dorr, I wonder if I could direct a question to you. I wonder if in past impeachment cases it has not been the procedure that the Judiciary Committee has recommended, and then on some occasions the House of Representatives itself has formally drafted and prepared articles of impeachment which were then submitted to the Senate. In other words, it's my recollection that there may have been cases where the House Judiciary Committee simply made a recommendation that the House itself had the responsibility of drafting and adopting the articles of impeachment based on the recommendation, and I wonder if we couldn't do it that way. What's your feeling about that?
My understanding is that has been the past practice.
I thought that was the practice.
Remain has expired. Before we proceed, the chair would like to state some propositions. First of all, we do know that we are proceeding under a very unique proceeding. Impeachment has offered us, except for the case of Andrew Johnson, no guidelines, no precedents. It is a fact, however, that the rules of evidence do not apply as such. The rules that will be the rules that will apply should this impeachment proceeding move on into the House and then to trial in the Senate will be the rules that the Senate will adopt. we do know, as a matter of fact, from impeachment proceedings and the research that has been extensive, and all I need do is recall to the members of the House that the House of Representatives has indeed impeached without any articles of impeachment, except merely to impeach, and that on a mere motion, a privileged motion of any member of the House, that the House could move to impeach. So that therefore, this discussion and this issue requiring specificity in order to lay the groundwork for articles of impeachment seems to me to be begging of a question which I think has long been settled. What we do here is to proceed with deliberations concerning the proposition that certain articles of impeachment be recommended by this committee to the House of Representatives. In the report that the committee will then furnish the House of Representatives, that information will be specifically included. Together with that, counsel for the President, as has been properly pointed out by the gentleman from Maine, would be provided with all of the information which is contained in the summary of information which details all of the specifics, and that prior to trial in the Senate, upon proper request by counsel for the President, should it reach that stage on discovery and other proceedings, that these materials would be then provided. And I believe that this affords all of the opportunity for fairness in this proceeding to ensure that the House of Representatives not act as a trial body under the exacting rules of evidence as we know them, because this, as a matter of fact, and all of us are aware, I think, who have been long wrestling with this question, that the House of Representatives is indeed not the trial body, but the body merely recommending articles of impeachment, even if they may be in the broadest sense.
Will the chairman yield?
I recognize the gentleman from Michigan.
I thank the chairman for yielding. If I understand the chairman's remarks, it is that perhaps this committee, in working on articles of impeachment, so-called, that our responsibility is not now actually to perfect any articles, but simply to decide whether or not we should recommend impeachment, and that those recommendations could be included in a report and so on. However, somewhere down the line, the House of Representatives has got to draft some articles of impeachment, which, in the opinion of the House, will stand the legal test in the Senate. And if that is so, I wonder, Mr. Chairman, whether the House will look to anybody else but this group in the Judiciary Committee to do that very task. And so, Mr. Chairman, it seems to me that we have that responsibility, and we might just well give our attention to those problems right now.
I do not want to take more time, except that I must correct the gentleman from Michigan, who I'm sure would want me to set the record straight, does not want to misunderstand me. I did not state that we should not perfect the articles. What I merely stated was a legal proposition that in impeachment proceedings there is no requirement, in fact, that the articles be specifically set out. That is all that I stated. Now I recognize, well, I have to go to this side. I recognize the gentleman from Missouri, Mr. Hundgate.
Chairman, and I would like to begin by commending our colleague, Mr. Sarbanes, who seems to be the target for tonight, on a rather excellent job, I think, of explaining what he's worked out here and what's going on. And he reminds me a great deal of an old saying of our former distinguished chairman, Mr. Celler. I can give you explanations, I can't give you understanding. I think Mr. Sarbanes has done an excellent job. The impeachment, as the chairman has indicated, grounds indeed are quite broad. As I understand, in the case of Andrew Johnson, they passed the resolution of impeachment, came back and drew 9 articles, and got over in the Senate and decided they needed some more and drew a couple more. So going into all this great, I hesitate to try to say specificity. I really can't say specificity. I didn't mean to say it. And as we get into all these legal terms, it's a lot of fun for 38 good lawyers, I think. 37 good lawyers. It's a lot of fun, but we forget perhaps that in the House of Representatives they aren't all lawyers. And the public likes it that way, I think. They may like it better. And these strict standards of proof. I saw where one of the distinguished senators said yesterday that some of the discussions we'd had about rules of evidence that they had different views. The Senate would decide on the rules of evidence. And as I recall the Johnson case they did, they overruled the Supreme Court justice. Wouldn't that be a thrill? So many times that he finally threatened to quit and leave unless they behaved a little better. So I think it's educational for us as lawyers, but the doctrine of impeachment is as strong as the Constitution, and it's as broad as the king's imagination. And we have that problem now, perhaps. All the technicalities just remind me of the story of the old Missouri lawyer. The fellow was kind of a country fellow and got a case fined in the Supreme Court, and he was nervous. And he got up there and he was arguing along, and one of these judges looked down at him and he says, "Well, young man, where you come from, do they ever talk of the doctrine of fake it per alium, fake it per se?" Well, he says, "Judge, they hardly speak of anything else." Now, let me tell you, I think Mr. Haldeman faked it per alium, and Mr. Ehrlichman faked it per alium, and Mr. Mitchell. There's lots of evidence here. If they don't understand what we're talking about now, a fellow wouldn't know a hawk from a handsaw anyway. Seriously, we know what we're discussing. It's really a question of pleading, and I think we're seeking to piling inference on inference. There you go again, piling inferences. And we sit through these hearings day after day. I tell you, if a guy brought an elephant through that door, and one of us said that's an elephant, some of the doubters would say, that's an inference. That could be a mouse with a glandular condition. Now, and you're on my time. And friends, one of them might be, but not 12, or not 28 volumes. And let's talk some about this evidence here. And I know these distinguished gentlemen know the law far better than I, and they realize that we don't have to plead it with all that great, whatever that word was. Article 3, I'd like to talk about it a little, approving, condoning, acquiescing, counseling witnesses to give false or misleading statements, etc., etc. March 21, 73, transcripts relating to conversation 10/12/11:55 a.m., Appendix 6, GPO 185 to 186, conversation. Mr. Dean, there's no doubt I was totally aware of what the Bureau was doing at all times. I was totally aware of what the grand jury was doing. I knew what witnesses were going to be called. I knew what they were asked, and I had to. Nixon. I infer that's the president. Why did Peterson play the game so straight with us? Dean, because Peterson is a soldier. He kept me informed. He told me when we had problems, where we had problems. He believes in you, and he believes in this administration. This administration has made him. I don't think he's done anything improper, but he did make sure the investigation was narrowed down to a very, very fine criminal thing, which was a break for us. There's no doubt about it. It'd be another break if we narrowed this thing down to the head of the pin. President Nixon, do you honestly feel he did an adequate job? Dean, they ran that investigation to the fullest extent they could follow a lead, and that was it. Nixon, but the point is where I suppose he could be criticized for not doing an adequate job. Why didn't he call Haldeman? Why didn't he get a statement from Colson? Oh, they did get Colson. Dean, that's right. But it's based on their FBI interviews. There was no reason to follow up. There were no leads there. Colson said, I have no knowledge of this, to the FBI. Strawn said, I have no knowledge. They didn't ask Strawn about any questions about Watergate. They asked him about Segretti. And as a result of some coaching, Strawn appeared to be the dumbest paper pusher in the bowels of the White House. That completes my sentence.
Time of the gentleman has expired. I recognize the gentleman from Maryland, Mr. Howard.
Thank you, Mr. Chairman. As the chairman of Mr. Railsback correctly observed, in the Andrew Johnson impeachment, the committee brought to the floor a general recommendation of impeachment. The House approved it, and then and only then was a committee appointed to draw up a list of charges to go to the Senate. Over there were, as someone observed, there were not only some added, but there were some ignored. I think one of the traps that we're falling into here is that we're drawing this grand jury analogy much further than it warrants. A number of us in our remarks in general debate tried to indicate what an impeachable offense is. Now, if you subscribe to the idea that an impeachable offense must be an indictable offense, then perhaps you have some justification for arguing that we are really here drawing an indictment. But such is really not the case. We're not a grand jury. We're operating here under a constitutionally authorized extra-legal power. We are not involved in a criminal proceeding. So that when we go to the floor, we can go with as broad and nebulous an impeachment resolution as we possibly desire to draw. It is amendable on the floor, depending on what rules we operate under. It is, even by the precedents, amendable in the Senate. But even...
The gentleman suspend until the committee is in order.
But even beyond that, Mr. Chairman, I think we're really straining here as we talk about precedents. There are not really that many precedents. There have not been that many impeachments, and there have been far fewer. There's been only about a dozen impeachments, and if my memory serves me, there are only 3 convictions. And those impeachments are contradictory one with the other. So I think we're really not looking at the responsibility that we have here is to go forward with a recommendation to the House. That's really all that we are about. Now, I personally think it would be preferable to have specific charges, naming places and dates and times and names, but it is not essential. And to argue that that is our responsibility under the Constitution is just ignoring what the Constitution gives us for the impeachment power. I yield back the balance of my time. I yield to Mr. Wiggins of California.
I
thank the gentleman for yielding. Let's not confuse apples and oranges. We do not have any responsibility to be specific at all here with respect to the recommendation we make to the House. Indeed, the House is able to recognize any member at any time to impeach Richard Nixon without any degree of specificity. We're talking rather about what happens at the Senate. This is a job which will be ours to carry to the Senate. Now, ladies and gentlemen, each in turn, yesterday and the day before, we paid tribute to the Constitution. Well, now's the time to put up or shut up, because we're talking about the Constitution. We're talking about the Fifth Amendment and the rights of a respondent, not on the floor of the House of Representatives, but at the bar of the Senate. And specificity is required over there because the Constitution demands it. Wouldn't it be a damning indictment, Mr. Chairman, of this committee, if after all this time and all this money, we were unable to state with specificity what this case is all about? I think it would. Now, all we're asking, Mr. Chairman, is that we get about it and do it. We shouldn't argue over that point. We should be precise, and I suggest we do so.
In a moment, you'll hear from the other side of the committee as Democrat John Conyers explains why he believes the charges are specific. NPAC's videotape coverage of the House Judiciary Committee's impeachment debate will continue shortly.
This is PBS, the Public Broadcasting Service.
Sir Arthur Conan Doyle, I do believe. So sorry to have kept you waiting. Do please sit down.
Thank you.
And how's the great man?
I beg your pardon?
Mr. Sherlock Holmes.
Oh.
In good health, I trust. Likely to be on the scent again shortly. I suppose I should congratulate you on the ingenuity and cunning of your plots, even if they sometimes show up we professionals in a rather dim light.
Seems there's been an appalling miscarriage of justice.
Do you think he's innocent?
Well, somebody does, because he's just been released.
What reason was given?
None. Now, that's what intrigues me. The young lad sent for my help. I got onto the Home Office. They refused to answer.
When do I see you again, Mr. Holmes?
Oh, in a day or two. It won't take long.
Well, you will keep me informed.
Well, of course I will. You shall be Watson.
The ATP Summer Tennis Tour will attract world-famous players competing for top prize money. Stan Smith, Arthur Ashe, Marty Reeson, Chris Evert, Yvonne Goolagong, Rod Laver, and Bjorn Borg are just a few of the players you'll see in major tournaments, like the Canadian Open from Toronto, the U.S. Clay Court Championships from Indianapolis, and the U.S. Professional Championships from Boston. All great tennis, all on this station, all summer long.
Surface is like the skin of an apple. To disturb it is to destroy it.
NPAC's coverage of the House Judiciary Committee's impeachment debate continues.
Now back to the House impeachment debate, and we pick it up with Democrat John Conyers of Michigan adding his thoughts to the discussion.
Recognize the gentleman from Michigan, Mr. Conyers, for 5 minutes.
Thank you, Mr. Chairman. I'd like to observe, if I might, that we have spent a good deal of time talking, and I think we may have reached some agreement upon the validity of the Sarbanes substitute. That is to say, we realize that we're going to bring to the floor of the Congress this matter so that to attempt to detail the policy or the plan that has been suggested as the basis for Article 1 in the substitute would be a little bit ludicrous. Mr. Sarbanes has outlined on at least 3 or 4 5-minute periods of members' times the basis for that continuing course of conduct. And it seems that for us to continue to say that we want to write it in, Article 1 of a resolution of impeachment would be highly unsound. Now, as I look across this article, we have only 9 subsections. We allege a plan that the President, using the powers of his office, made it a policy to delay, impede, and obstruct the investigation of the illegal entry of the DNC on June 17, 1972. And as I look at the first specification of making false or misleading statements to lawfully authorized investigative officers and employees of the United States, It's clear that on April 18, 1973, for example, the President talking to Mr. Peterson, the Assistant Attorney General of the United States, he told Peterson to stay out of the Fielding break-in investigation because of reasons of national security. That was a false or misleading statement. We've documented it any number of times in the course of the months that we've been here. And so for us to have to write this in is an unnecessary act, because there is not just one or two, there are several, any number of them, any of which, since as I read this pleading, it is in the alternative, would be sufficient. The means used to implement the policy of the President have included one or more of the following, emphasis, one or more of the following, and we allege 9 specific courses of conduct that demonstrate that the President of the United States used his office to obstruct justice. Now, with that in mind, Mr. Chairman, I think that after we analyze any number of these reasons that demonstrate a course of conduct, those of us who are ready to support the notion of impeachment as embodied in this very plainly worded language should be able to support it before this evening is over. And I would hope that we would move to that point so that we could at least accept this very first article before the end of this evening. I would yield, if I have time remaining, to the gentleman for Pennsylvania for an observation, Mr. Chairman.
The gentleman from Pennsylvania is recognized for a minute and a half.
Mr. Chairman, I think that we should be very careful about this subject of specificity. As you have said, this is a unique proceeding, and in that sense, I believe it is one that is developing all the time. Almost every day we are learning something more about the situation with regard to the White House. Now, I suggest, Mr. Chairman, that as we know, the Supreme Court has ordered 64 subpoenas to be turned over to the special prosecutor. Suppose that those tapes or portions of them become available to the House or even the Senate at a later time. I'm afraid that if the articles are or subheadings are too specific, that some subjects that may arise out of those 64 subpoenas that might ultimately come into our possession might be denied consideration when they should be considered by the House or by the Senate. Also, Mr. Chairman, we have the trial that we know is coming up in September of Mitchell et al., and it's entirely possible that facts or situations may develop which may bear on the ultimate outcome in the trial in the Senate if there is one. And I say that we should not be so frozen in here that we can't use additional information. And we don't know what other disclosures may come about, what other situations in the next few weeks and couple of months. And I suggest, Mr. Chairman, that the outline in Article 1, as suggested by the gentleman from Maryland, is definite enough and still gives us that flexibility so that additional facts may be brought to bear.
The time of the gentleman from Michigan has expired. I recognize the gentleman from Mississippi, Mr. Lott. 5 minutes.
I thought that determining the specific charges was what this was all about. Now, there's been some talk about including all the other specifics in a report. I wonder who would prepare that report. Would it be left just to the staff? I think that's a question that we should determine, particularly if we come out here with very general articles. And, Mr. Chairman, I think that as we reach this important milestone in these proceedings, the actual drafting of the articles of impeachment, that the American people see the way in which it proceeded, see the confusion that we're faced with, the disagreement about whether it should be general or specific. After 7 months, it looks like something of this great importance would have already been.
classification of making false or misleading statements to lawfully authorized investigative officers and employees of the United States. It's clear that on April 18, 1973, for example, the President, talking to Mr. Peterson, the Assistant Attorney General of the United States, he told Peterson to stay out of the Fielding break-in investigation because of reasons of national security. That was a false or misleading statement. We've documented it any number of times in the course of the months that we've been here. And so for us to have to write this in is an unnecessary act, because there is not just one or two. There are several, any number of them, any of which, since as I read this pleading, it is in the alternative, would be sufficient. The means used to implement the policy of the President have included one or more of the following, emphasis, one or more of the following, and we allege 9 specific courses of conduct that demonstrate that the President of the United States used his office to obstruct justice. Now, with that in mind, Mr. Chairman, I think that after we analyze any number of these reasons that demonstrate a course of conduct, those of us who are ready to support the notion of impeachment as embodied in this very plainly worded language should be able to support it before this evening is over. And I would hope that we would move to that point so that we could at least accept this very first article before the end of this evening. Well, I would yield, if I have time remaining, to the gentleman for Pennsylvania for an observation, Mr. Chairman.
The gentleman from Pennsylvania is recognized for a minute and a half.
Mr. Chairman, I think that we should be very careful about this subject of specificity. As you have said, this is a unique proceeding, and in that sense, I believe it is one that is developing all the time. Almost every day we are learning something more about the situation with regard to the White House. Now, I suggest, Mr. Chairman, that as we know, the Supreme Court has ordered 64 subpoenas to be turned over to the special prosecutor. Suppose that those tapes or portions of them become available to the House or even the Senate at a later time. I'm afraid that if the articles are or subheadings are too specific, that some subjects that may arise out of those 64 subpoenas that might ultimately come into our possession might be denied consideration when they should be considered by the House or by the Senate. Also, Mr. Chairman, we have the trial that we know is coming up in September of Mitchell et al., and it's entirely possible that facts or situations may develop which may bear on the ultimate outcome in the trial in the Senate if there is one. And I say that we should not be so frozen in here that we can't use additional information. And we don't know what other disclosures may come about, what other situations in the next few weeks and couple of months. And I suggest, Mr. Chairman, that the outline in Article 1, as suggested by the gentleman from Maryland, is definite enough and still gives us that flexibility so that additional facts may be brought to bear.
The time of the gentleman from Michigan has expired. I recognize the gentleman from Mississippi, Mr. Lott. 5 minutes.
I thought that determining the specific charges was what this was all about. Now, there's been some talk about including all the other specifics in a report. I wonder who would prepare that report. Would it be left just to the staff? I think that's a question that we should determine, particularly if we come out here with very general articles. And, Mr. Chairman, I think that as we reach this important milestone in these proceedings, the actual drafting of the articles of impeachment, that the American people see the way in which it proceeded, see the confusion that we're faced with, the disagreement about whether it should be general or specific. After 7 months, it looks like something of this great importance would have already been answered. I had intended to offer a motion to strike Article 1 as proposed by Mr. Donahue because it was so general. But because of the present parliamentary situation involving the Sarbanes substitute, I will not do so. Now, he's given some specifics here, but I assume he hasn't offered to make them as a part of his substitute. I've already heard some things here today offered as specifics in support of this article that I think are not supported by the evidence. I feel very strongly that several sections of Article 1 that's been offered obviously are not supported by the evidence. It's clear to me that the use of certain words in this article try to impute the wrong of the aides of Mr. Nixon to him. As I said yesterday, we're not attempting to impeach John Mitchell or John Dean or others. The line must be drawn directly to the President. But I feel really it's futile at this point to argue the evidence. And I want to speak instead to the fact that this article is far too general in nature and incorporates duplicity and prejudicial joinder through collective use of evidence. What clearly emerges to me from the Constitution's original context and its impeachment provisions is an overriding concern that due process be a guiding principle in an impeachment action. The Constitution's concern with enunciation of the grounds for impeachment under Article 2, Section 4 reads inescapably that the one most important element of this is due process, and that has to be the grounds in the impeachment articles, and they must be sufficiently specific for a respondent to be impeached. They must be also specific and explicit for the Senate to conduct a fair trial. Mr. Chairman, surely there are members of this committee who would perhaps vote for an article of impeachment that was specific and had different wording, but I do not see how they can live with the Sarbanes Amendment. We cannot send this mockery to the Senate, and after all, that is what, in my opinion, we're determining here now, what we will send to the Senate. I yield the balance of my time to Mr. Wiggins.
Thank the gentleman.
Recognize the gentleman.
I thank the gentleman for yielding. I do appreciate the comments of my friend from Maryland, Mr. Sarbanes, in attempting to flesh out what he understands the evidence to be in support of this policy, which is at the heart of Article 1. But I think, in fairness, we ought to expose the totality of that evidence to ourselves and to those who are watching these deliberations. Let me go through it quickly. It's contended that there was a pattern of conduct commencing on or about the 20th of June. That tape contains a gap. The only evidence we have as to what occurred during that gap are the notes of Mr. Haldeman. And those notes indicate a discussion of a PR offensive. And that is all. Now, we can be suspicious, but those suspicions have not provoked any grand jury who's investigated this, has not provoked Judge Sirica, has not provoked anybody else to return in criminal indictments because they don't know. Let's recognize that that gap is a suspicious circumstance to me, but that's not evidence. We have the situation of the President being less than candid, according to Mr. Sarbanes, in saying there was no White House involvement on the 20th of June of 1972. But let me tell you what John Dean said. He said he talked to Liddy on that day, and you know what Liddy told him? Liddy, first the statement was made by Dean as follows. First, Gordon, he said, I want to know whether anybody in the White House was involved in this. And Liddy, the architect of all of this, replied, no, they were not. And that continued to be the state of the President's knowledge thereafter. If that's the kind of quality of evidence upon which this plot is hatched, this policy, let me say that it's ambiguous, it's confusing, it might be susceptible of different interpretations. But we know what the law is. You can't do it on that basis. If there is a benign interpretation pointing toward innocence, we must take it. We must take it. Well, let me say that that first essential charge that the President made it his policy is not supported by the evidence.
Time of the gentleman from Mississippi has expired. The gentleman from Pennsylvania is recognized for 5 minutes.
I yield, Mr. Chairman, to the gentleman from Massachusetts, Father Rodino.
Thank you very much for yielding. It seems to me those who challenge the wording here have to turn up with another policy. The wording here in the Sarbanes substitute is very clear. We are not saying that Mr. Nixon invented this policy. He made it his policy to carry out the obstruction of justice. It seems to me that this is the only possible conclusion that one could come to when you look at the vast amount of evidence following the incident at the Democratic National Committee. If there's another explanation, it has not turned up in all of our investigations. It seems to me the situation is unique for many reasons, And the principal one is this, that the President has withheld the evidence in 69 cases of possible impeachments in all of our history. Only one individual has ever sought to withhold evidence from an impeachment inquiry, and that person invoked the Fifth Amendment. What are the alternatives to that careful wording? The President made it his policy. Can you say that all these things are mere chance? There's absolutely no coherent explanation. You can take that, but lawyers resist that there has to be some explanation of all of the tragic events that took place out and inside the Oval Office. Can we say that the President knew nothing about what Haldeman and Ehrlichman were doing, that they themselves conspired alone? That is contrary to all of the evidence. I say, therefore, that we have to name some policy that the President had, and in this substitute, we say he made it his policy to obstruct justice. I'd love to find another policy. I've searched for 6 months with the other lawyers here for another policy, but I've come to the inescapable conclusion that the President made it his policy to impede the investigation of the burglary in the Democratic National Committee. I yield back to the gentleman from Pennsylvania.
I yield the balance of my time to the gentleman from California, Mr. Walby.
Gentleman from California is recognized.
Mr. Chairman, I too want to address myself to the question of the President's policy. Understand we're dealing with a policy that will not bear the scrutiny of light. It's an action and a plan and a policy of the White House and the highest people in the level of government in the United States. And it simply will not bear scrutiny. They cannot stand to have anybody examine this policy. So therefore, to demand that we provide a parchment scroll of a presidential declaration that on such and such an hour of such and such a day, a policy was established by the White House to engage in a cover-up of illicit activities is really quite unrealistic and is not really advanced, I think, with the objective and the desire to really get at the truth. But a policy of this nature is a surreptitious, covert policy that evolves. Its parameters and its limits are not known at its inception. The policy is we've got to cover up. We simply cannot let the people of America know that we have financed political intelligence activities that have resulted in the burglary of the Democratic National Committee headquarters at the Watergate Hotel, because once they find that out, they will find out that whole litany of covert activities authorized and financed by the White House, by Hunt and Liddy, the principals of the Watergate burglary, the plumbers, that whole litany of illegal covert activities described by John Mitchell as the horrors of the White House. So the policy is clear. You can't permit the American people to discover that because you're in a national election year. The policy is to protect the election of the president. It's implicit. Nobody denies it. The policy is to protect the election of the president by immediately taking actions to cover up the entry and the participation and authorization and part of that entry, illegal and surreptitious, into the Watergate Hotel by the White House and by the Committee to re-elect the President. And it didn't start late in the period after the entry. It started immediately. Howard Hunt, one of the burglars, and Gordon Liddy, another of the burglars, who were not picked up the night of the 17th. 5 were picked up. They were not. They were across the street in the electronics gear room. Immediately went back to the White House and picked up $10,000 in cash that he had been paid by Gordon Liddy from campaign funds of the Committee to re-elect the President for emergencies such as this. And he gave that $10,000 cash early the morning of the burglary to an attorney to defend those burglars.
From Pennsylvania has expired.
Mr. Chairman, I seek recognition on my own part.
The chair will have to recognize the gentleman on the other side. I recognize the gentleman from Wisconsin, Mr. Froelich.
Thank you, Mr. Chairman. When Mr. Lott had the floor, he asked a very important question. I would like you, Mr. Chairman, to reply, or the staff to reply. Who is going to write the committee report that will go to the floor that will show the members of the House specifically what is behind each individual paragraph in this article of impeachment? Is the staff going to write that? Does the committee have any right to review, to approve that report as a group? Or is it going to be written outside of our view and without our knowledge?
The gentleman is advised that any report is a committee report, and that the report would then, of course, if any individual member wanted to exercise individual views, additional views, or views other than the views of the majority of the committee, could so do. But the report, however, would be a report prepared by the committee and the report of the committee, circulated to each of the members, and of course, all of us would have to recognize that, as has been done, as will be done, that the assistance of staff is always employed, but nonetheless, the work is the work of the committee. And unless that committee report is authorized by a majority of the committee, it does not become a report of the committee.
Thank you, Mr. Chairman. Mr. Jenner, when you indicated that sometime just prior to trial in the Senate, a demand could be made by the attorney for the president for something akin to a bill of particulars, what point in time were you referring to?
I think I was responding to Congressman Hogan's question as to whether the President's counsel could wait until just before the Chief Justice opened the trial and then move with respect to the pleading. I don't wish to compromise Mr. Hogan, but I think that was the question you asked.
I don't want that answer, Mr. Jenner. I want the answer as to what point in time would it be proper for the President's attorney to demand on behalf of the President a bill of particulars as to this impeachment?
He can do so, Mr. Freilich, at any time after the bill of impeachment is lodged with the United States Senate.
And who writes the bill of particulars, then?
The House of Representatives, the managers for the House of Representatives.
Did you say that this was an unconstitutional delegation of the sole power of impeachment to a small group of individuals in behalf of the House of Representatives as a whole, since the power of impeachment, as you so eloquently have stated time and time again, rests in the House of Representatives?
Excuse me, sir.
Solely in the House of Representatives?
Congressman Freilich, I think not, because when you reach that point in the course of the proceedings before the United States, you are pursuing procedures and practice before the United States Senate, and the United States Senate, in its rules with respect to this impeachment, will have established prior to that time, I very much anticipate, the procedures in that Senate.
Mr. Chairman, members of the committee, I've just paged through the October 1973 publication of this Committee on Impeachment, and I'm looking at the articles for Senator William Blount in 1798, and I'm looking at the articles for impeachment of Judge James H. Peck, and I'm looking at the articles for the impeachment of Judge West H. Humphreys, and I'm looking at the articles of impeachment for Judge Charles Swain. And each one of these articles of impeachment are specific. They tell the date, they tell the place, they tell the occurrence, they tell what was wrong and what laws were violated if there were laws violated. And it seems to me that in fairness and in justice to the President of the United States, after 8 months and over $1 million, that this committee could come to a conclusion as to what the specifics of this impeachment are, in detail and by specific charge. And I am ready, as I indicated yesterday, in some instances, in some cases, if the case is put in the proper form and the proper shape, to vote for an article of impeachment. But I don't think that the articles placed before us are in specific enough detail to bring me to that conclusion today. I yield to the gentleman from Maryland.
The time of the gentleman from Wisconsin has expired.
Parliamentary inquiry.
I recognize the gentleman from California.
Mr. Chairman, let me continue elaborating on the events that transpired immediately after the arrest of 5 employees of the Committee to Re-elect the President and 1 employee of the White House. 2 employees of the White House that were fugitives immediately thereafter on June 17th to determine whether the President began implementing immediately a policy of cover-up. And I say he did, and the evidence justifies that. It was an evolving policy, but the essential component of that policy was cover up, protect the 1972 election. But the information that occurs from Saturday, June 17th, immediately after the burglary, through June 22nd, is enormously important information. These people are involved in the scenario, as it is referred to at that particular moment in time. In Washington are Mr. Ehrlichman, Mr. Liddy, and Mr. Kleindienst, and Mr. Dean. In Key Biscayne are the President and Mr. Haldeman and Mr. Ziegler, and in Los Angeles are Mr. Mitchell, Mr. Magruder, Mr. LaRue, and Mr. Mardian. The phone conversations between those 3 varied points in this country practically burned up the wires immediately on Saturday as they discussed this enormously dangerous event. Dangerous to whom? Dangerous to the President. The first notice that the President got of it, according to Colson, was when he called the President called Colson, as the President had apparently heard from Haldeman, who had already heard that Hunt, an employee of the White House, was involved. Hunt, he of the plumbers and the White House horrors. When the President was informed by Colson of what had happened, it is alleged that the President threw an ashtray across the room. Now, that's not a reaction of a man who is not aware that is... And
until the committee is in order, and the committee is not in order. Gentleman from California.
I thank the chairman. I thank my colleagues. That is not the action of an individual who is learning for the first time in his life that there's been a burglary in Washington, D.C. There are burglaries that occur in Washington, D.C. with sufficient frequency that when presidents are informed, they don't throw ashtrays across the room. The next thing we understand, on that same day, Mr. Liddy, one of the burglars, goes to the Attorney General at the direction, we are told, of Mr. Mitchell, the former Attorney General, goes to Mr. Kleindienst the very day of the burglary and says to Mr. Kleindienst, "You've got to get our boys out of jail." And Kleindienst said, "Get out of here." Interestingly enough, that's all Kleindienst said or did. He didn't say, "What are our boys doing in jail, and who are they, and let's get to the bottom of this. And what are you doing out of jail?" The Attorney General didn't say that, so he understood what was going on. Mr. Ehrlichman called the President. Actually, he didn't. He called Mr. Haldeman on Sunday, the day following the burglary, from Washington to Key Biscayne, and he told Mr. Haldeman of the involvement of Mr. McCord, a security officer for the committee to re-elect the President, and the involvement of Mr. Hunt, who was an employee of the White House and whom the President knew had been involved in Plummer's activities. He told Mr. Haldeman that Mr. Haldeman was told by Mr. Ehrlichman that Mr. Mitchell had authorized with Haldeman a plan to procure political intelligence by bugging. He told him it was financed by creep funds, and that Hunt and Liddy were in this team, had been involved in previous activities. Now, do you really believe that Haldeman, the closest confidant and advisor of the President, on Sunday, June 18th, when told these startling and damning facts, did not convey them to the President in Key Biscayne? Was he that disloyal that he would not convey to the President something as enormously important to the President's re-election? That does not add up to common sense. Of course he had to convey it to the President. The next thing we know in terms of presidential involvement is that the president called Mr. Colson, the good friend of Mr. Hunt, on Monday from Key Biscayne. The president calls Mr. Colson, and they talk for an hour. Mr. Colson had probably had more phone calls from more people in high levels of government over those 2 days since the break-in than anybody in America, because Mr. Colson had brought Mr. Hunt into the White House employ, and they were worried about Mr. Hunt because Mr. Hunt at that point was a fugitive. They only knew he was employed by the White House, but they wanted to know, is he off the payroll of the White House? So everybody was calling Mr. Colson, including the president. And everybody that called Mr. Colson testified they called Mr. Colson to find out about Hunt. Mr. Colson said that wasn't why the president called him. They discussed Watergate. It was common knowledge in Washington there'd been a burglary, and the president wanted to carry on a little conversation from Key Biscayne, calling Colson in Washington on a Sunday just to talk about a burglary. You know he asked Colson what he knew about Hunt. Then June 20th. June 20th, all the president's men gather in Washington, and the meetings that take place are these. Haldeman, Ehrlichman, and Mitchell meet. Dean and Kleindienst join with them in the morning of the 20th, and they discuss strategy for Watergate. That's all they really discussed, and there's really no question about that in anybody's mind.
Gentleman has expired. I recognize the gentleman from California,
Parliamentary
Mr. Moyer, for 5 minutes.
Mr. Chairman, I can well understand why some of the gentlemen and ladies here today are discussing the tapes again rather than the issue at hand, because they're on the wrong side of a most important issue, one that I feel that is as important and dear to the citizens of this country as any right that they have under the Constitution. I think we have to uphold our Constitution and the rights of people who are accused of any kind of offense. You can't arrest a man for suspicion of a robbery at 10th and Elm in Washington, wait until the time of trial and have him build up his defense, and then offer evidence against him for an offense on an entirely different day in another city that he hasn't had a chance to defend. There must be a time when the issues are formed, when they're joined, where the man knows what he's charged with specifically. Now, I don't blame the people who have drawn these articles. I know the reason. Mr. Hungate said you had to have understanding. I think we have understanding. The understanding is that all the way through these hearings, Mr. Dorr and Mr. Jenner told this committee, you will be the judge of these offenses. You will be the judge as to whether this particular fact is truly a fact or whether it is not. You will be the judge of determining whether this fact constitutes an offense or whether it doesn't. But now what we're asked to do as a committee is to not determine whether those facts are true or whether we accept them or whether we accept a particular version of them. We're asked to pass on a lot of generalities that really don't allege specific charges, that don't tell the president what we believe he's guilty of and what he is not. And the reason is, obviously, that you couldn't get 21 people on this committee to agree to many of these things which haven't been proven, for which there isn't adequate evidence. And so I don't blame anyone that wants to go by these very general, in some cases misleading statements. Let me read one place in this article. The means used to implement this policy have included one or more of the following, and they allege 9 different general things. One or more. Well, I suppose if you read that carefully, it's saying that maybe 8 of them are false, but maybe one of them is true. I think the President of the United States, as well as any other citizen of this country, has a right to know what he's charged with and has a right to prepare a defense. Now, I know we've got 39 volumes of materials. Some of it's hearsay, some of it's newspaper articles, some of it is quotes from other tapes, Some of it comes from all kinds of various sources. A lot of it isn't evidence. Couldn't be admissible in any court of law. You can't tell the president or any other person, we've got these general charges, but you may be accused of anything that's in this book or anything else that we want to bring in at the last minute. Let's follow the Constitution that we've talked about, and many people have said last night was so important. I believe in that Constitution. I believe in that Constitution more than almost anything in this world. And I'll fight and defend it in every way that I possibly can. It's more important than Richard Nixon or me or anyone else in this room. That Constitution is the thing that has given us freedom. But I would tell you that if this modern law that supposedly is taking effect, and I don't think has reached California yet, thank goodness, if that's ever really adopted into law, the people of this country have lost some of their constitutional rights, and they're in bad shape, because you won't know what you're accused of until you get to trial. I think the President of the United States has more opportunity, or should have more opportunity than that. And getting down to specifics, we've been told that a bill of particulars could be had when this thing goes to the Senate. And we heard earlier in the newspaper, at least, that Mr. Mansfield was discussing giving the President 54 days to prepare a defense, to offer arguments against the petition that might be filed by this body. But I read the other day that he was considering starting the trial immediately so that it would get all the good press just prior to election, I'm sure. So we'd be in the newspapers and on television pointing out the mistakes that a Republican administration had made on prime time right up to Election Day. This isn't justice. No justice, and I can't laugh at jokes Mr. Hungate or anyone else might tell in a serious time like this. This is an important time for the people of America, and we're fighting for far more than Watergate or any other specific thing. I'll fight for clean government. I'm against anything that's dirty in government or that involves the morals of our elected officials. But surely let's have the rights that are given to us under the Constitution and give it to the President as well as we would anyone else. Yes.
But in response to Mr. Freilich's question about who draws up the charges, you said the managers on behalf of the House. I'm sure you didn't mean to imply that the House would not approve those charges before they went to the Senate. Or did you?
I think that's a very good question. May I give it a minute's or a few seconds thought? Because, Congressman Hogan, a bill of particulars in criminal proceedings does bind the indictment, it would be my judgment that perhaps the bill of particulars would have to be submitted to the House.
I think it's very important to note that this is not a criminal proceeding and that the Constitution of the United States specifically provides that in the event that somebody is impeached, that shall not bar him from trial or indictment or conviction according to law. So we're not talking about a criminal procedure at all. And I'm very surprised to hear the gentleman state that the federal rules of civil procedure, which were enacted in the late 1930s, have not yet reached California, because I'm well aware of them, at least in New York. And they certainly bind federal proceedings throughout the United States. And those rules of civil procedure allow for notice pleading. This is basically a civil case and a civil proceeding. And I don't think we ought to be bound by criminal practice, and I think that these articles, as they've been proposed, are eminently fair and eminently within the procedures and the precedents.
An opportunity to answer. Can I have 30 seconds to reply to the question that was put to me?
Mr. Chairman, I ask unanimous consent that the gentleman be given an additional minute.
There's a basic difference in the court hearings in which the defendant almost immediately upon being presented with the charges gets a bill of particulars. In this case, there would be no way that the President could know of the charges until very shortly before he was to begin trial. I would also point out that while this may not be a criminal procedure, impeachment is a penalty almost worse than death to any human being that would be President of the United States and get that penalty, and certainly he deserves to have his constitutional rights protected. And in almost every single impeachment that we've had in recent years, the President has had the right to know what he was charged with before he went to trial. Are we going to degenerate the benefits that we give to a President or any other accused in this modern day when supposedly we are expanding the rights of freedom instead of retracting them?
The gentleman has expired. The gentleman from South Carolina, Mr. Maine, seeking recognition.
Mr. Chairman. Mr. Chairman, I don't think that I have to yield to anybody in my desire to see that these proceedings are fairly conducted, and if it goes to a trial in the Senate, that the proceedings there will be fairly conducted. But as I read this article, the gravamen of the offense is that Richard M. Nixon, using the powers of his high office, made it his policy, and in furtherance of such policy, did act directly and personally and through his close subordinates and agents to delay, impede, and obstruct the investigation of such illegal entry, referring to a specific date, to cover up, conceal, and protect those responsible, and conceal the existence and scope of unlawful covert activities. Now, this article goes on to list 9 means by which that impeachable offense was carried out. Now, I'm astonished to infer here that there are those here who would assert that we should list in this article all of the evidence that applies to this charge. It's very clear, of course, that if we were to attempt to do that, that we would have a document equaling several of these books. But what bothers me most of all are the loose statements, some of which we have just now heard, that the President is going to go to trial without knowing what the charge is. The President, if he goes to trial, is going to trial not only knowing what the charge is, but knowing what every iota, every word, every I, and every T, every bit of evidence that's been made available to this committee has been presented here in the presence of the President's counsel. If we get further evidence, I can assure you, you will have my support to see that the President's counsel is present when it's presented to this committee, and that he's present when it's presented to the House of Representatives if new evidence is presented at that time. So what are we talking about? Sneaking up on someone. The evidence, all of it, will be available to the President tomorrow, the next day. He's got it up until now. He's got some, of course, that we would like to have. So I don't find that this proceeding, which admittedly has sparse precedent, is in any way violating anyone's constitutional rights, who stands before the bar of justice, possessed of every fact known to the prosecution, possessed of the description of the charge of which he stands charged. What surprise, what surprise can I conclude other than that this is not a substantive objection, is a procedural matter, is a matter that I must suggest that I somewhat predicted as I realized that the arguments made here in front of these cameras would not be made for the benefit of me as a member of this committee. I don't think Mr. Salmon would be so strident or even so partisan if these proceedings were not being conducted to influence the opinions of the American people. But I am here to study the law and the evidence and to see that Richard Nixon gets a fair trial, that he is advised of all of the evidence against him. And in my judgment, the charges that included in Article 1 notify him of what he's charged with. They set out something extra, the means by which he is alleged to have committed that offense of obstruction of justice. Let us be reasonable. We have had the advice of Mr. Jenner, who, because of his objectivity, stands stripped of his title as minority counsel, a man who was chairman of that body of the American Bar Association, the advisory committee, to advise the Supreme Court on rules of evidence and criminal procedure, the foremost expert in the United States, I submit, on this issue, and he tells us that in his judgment, this article is adequate to advise the respondent of the charges against him. Fairness is what is required. I would settle for nothing less, and I submit that this article grants fairness in the highest tradition of American jurisprudence and of the power of this body to exercise its serious power of preserving our government through the power of impeachment. I yield back the balance of my time.
Yield for a question, please.
Recognize the gentleman from Iowa, Mr. Maine, for 5 minutes.
Mr. Chairman, I yield 3 minutes to the gentleman from New Jersey, Mr. Sandman, and reserve my remaining 2 minutes.
I'm absolutely amazed to hear some of the arguments that I've heard here today. I can't believe that this is the same group that made all of those speeches yesterday and the night before. Every one of them making that Constitution the most valuable thing that was ever made, and it is, and yet so willing to cast aside the most important provision in there, the one known as due process. That one, for their own convenience, they will throw under the rug. Isn't it amazing they're willing to do anything, such resistance to making the thing specific? Isn't it amazing they have so much, but they are willing to say so little? Isn't it amazing? Willing to do anything except make these articles specific. It's the same old story, you know, when you don't have the law on your side, you talk about facts. You don't have the facts on your side, you just talk. And that's what a lot of people have been doing today. Now we talk about this going to the Senate. What about the House of Representatives? Are you going to get down there and say, fellas, we've got so many stories to tell. Here's 40 books that have been put together by Dorr and Jenner. You just rehash those. You don't need anything else. Don't pay any attention to the constitutional law or anything else. Just look over these things. And maybe this is the reason why they didn't want any witnesses. Never wanted a witness. Why didn't Dennis get his right to have the big man here, Hunt, the man who demanded the money? The most important witness never testified before this committee because this committee doesn't want witnesses. This committee doesn't want to be specific. This committee just wants to rehash tales. That's what this committee wants. And that, I say, is a miscarriage of justice. Now, 3/4 at least of all of the charges leveled against this president will not be involved in any articles of impeachment presented to this committee tonight, and everybody knows it. And the president is entitled to which ones are left. And every lawyer here knows that it's the only fair thing to do. The only fair thing. You don't require an adversary to do all kinds of things. What is so wrong about in a simple sentence saying what happened? What is so difficult about that? You have so much. but you are so afraid to say
Fired.
so much.
Mr. Maine, it's 2 minutes remaining.
I yield those 2 minutes to the gentleman from Indiana, Mr. Dennis.
I
Dennis is recognized.
thank my friend from Iowa. I merely want to suggest that there are at least 2 points that deserve some thought. First, if you're going with Mr. Sarbanes' theory, you've got to figure out when and how did the so-called policy come into being and prove it. Because until and unless you do that, you can't attribute the act of anyone else to the President of the United States. Second, if you're going to rely on implementing the policy by the allegations here, you're going to have to come up with when and what were the specific occasions on which that policy was implemented by, for instance, making false statements to investigating officers or counseling with witnesses to give false testimony. Now, those things either happened or they didn't. If they did, it's very easy to specify them, and the law says that you've got to do it. And it doesn't make any difference whether the respondent knows or doesn't know some of the things you may have in your mind. He's still entitled to a good charge. That's due process of law. And you can't satisfy it by saying that statements in a committee report can perform the function of a good charge, or that you don't have to pay any attention to the rules of evidence with the Chief Justice in the chair, because an impeachment thing is somehow different. You got the votes, of course. You can vote anything, but somewhere down the line you're going to have to follow the law and the Constitution and prove your facts.
Chairman.
Time has expired. Recognize the gentleman from Ohio, Mr. Seiberling, for 5 minutes.
Thank you, Mr. Chairman. I quite agree that due process is absolutely essential, that the Constitution requires it in an impeachment proceeding as in any other judicial proceeding under our Constitution. But due process does not require any specific form of proceeding. It requires certain essential matters of substance, such as notice to the defendant or the person who is on trial as to the nature and the detail of the charges against him. Now, as Mr. Jenner pointed out, under our modern practice, we don't do that anymore in the indictment or the similar document. We get into the details through other matters of discovery, and that is just as much due process as to do it in the old way. What was done 107 years ago in the trial of Andrew Johnson isn't necessarily the only way to do it. But even then, I'd like to read some authorities older than Andrew Johnson's trial. Alexander Hamilton in the Federalist Papers said, with respect to impeachment, the nature of the proceeding can never be tied down by such strict rules in the delineation of the offense by the prosecutors, as in common cases serve to limit the discretion of courts in favor of personal security. And Justice Story, in his commentaries on the Constitution, said, it is obvious that the strictness of the forms of the proceeding in cases of offenses at common law is ill-adapted to impeachments. The adherence to technical principles, which perhaps distinguishes criminal law more than any other, are all ill-adapted to the trial of political offenses in the broad courses of impeachment. There is little technical in the mode of proceeding. The charges are sufficiently clear and yet in general form. There are a few exceptions which arise in the application of the evidence which grow out of mere technical rules and quibbles, unquote. Now, every time we talk the facts, why, the gentleman from New Jersey wants to talk about procedure. And when we get into procedure, then the gentleman from Indiana wants to talk about the facts. And I suggest that the facts still need to be discussed, as the gentleman from New Jersey originally started to ask us. And I yield the balance of my time to the gentleman from California, who I thought was doing a pretty good job of it.
I thank the gentleman. 5-minute segments of the Watergate saga is a pretty hard one, but we left the principals after the president, Mr. Colson, on Sunday, following the burglary. We're having an hour's chat. at which they discussed Watergate, but only in general terms, and never discussed any particulars at all, according to Mr. Colson, and we don't know, according to the President. But we do know something that happened on June 20th. All the President's men gathered from all over this country back into Washington. They came in from California, they came in from Florida, and they came to Washington, where they could meet and confer and decide what to do about this threatening calamity. The threatening calamity to the re-election of the President. The most important thing all of them had facing their entire lives was the re-election of this President, and their blind dedication to that objective is just not even arguable. And after they met and discussed their policy, the President met with Haldeman, his closest advisor, and they discussed Watergate. That's in Haldeman's notes. Everybody agrees there was a discussion of Watergate. On that tape, that 18 and a half minutes is all that's missing. There's nothing else missing on that tape except the discussion of Watergate right after that big strategy session. Now, it is now determined that human hands erased that 18 and a half minutes while it was in the exclusive and sole possession of the President, and it is attributable to sinister forces. My own inclination is to believe that it is inescapable inference that the President had that 18 and a half minutes erased because it would have been so devastating in its incrimination of the President immediately in the cover-up plan. But there is something that was not erased. There was a dictabelt of a phone conversation, the recollections the President had of events that day. And one of the events...
Expired. The gentleman from Ohio seeking recognition.
Yes, Mr. Chairman, I thought maybe they'd never get down this far.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. It's interesting to sit this far away from the center of power. You get all of these statements before you get an opportunity to speak. And let me just say, Mr. Chairman, that I was surprised as a member of the Rules Committee to hear that you propose sending these articles of impeachment in a general form and attached thereto as a supplement, I might say, in the report to the Rules Committee for consideration. Now, Mr. Chairman, members of the Rules Committee are supposed to read those reports before we make a finding and report a rule to the House of Representatives. And certainly, you would not want us to void our own rules. I think that we ought to ponder about that. The same way that the members of the House of Representatives ought to ponder about what you're proposing. You're saying that we're going to send these general articles of impeachment to the floor of the House without being specific, without saying the time, the place, and say to the members of the House of Representatives who are not on this committee, go through those 38 or 39 volumes. Try to sort out what we think as members of this committee are impeachable offenses and make a judgment thereon. Is that what we're saying? If you are other members of the House, good luck. Now, Mr. Chairman, I think we ought to rethink what we're proposing. A common jaywalker charged with jaywalking any place in the United States is entitled to know when and where the alleged offense is supposed to have occurred. Is the President of the United States entitled to less? Yes, he's entitled to know, even though the Constitution from whence impeachment proceedings comes does not specifically spell out that you have to do so. The Sixth Amendment is still in the Constitution, and are we going to waive it? In this case, they didn't waive it in other impeachment cases. Are we going to set a new precedent here in
and waive that? Where are these civil libertarians? I think it's high time that we stop and rethink what we're doing. Nobody is trying to delay the action here, because I well know that any time that the chairman puts down that gavel and says, call the roll, the votes are here to do exactly as you like. Whether or not Mr. Jenner or Mr. Dorr prepared these articles, which they probably did, whether they certainly ought to agree with what they prepared, and I thought that was a question that really didn't have to be asked by the chair as to whether or not these gentlemen agreed with what they had prepared. I think that was useless. But I think that it's important that we do something fair for the other members of the House. Let's forget about the President of the United States. We're not the only members of the House of Representatives who are going to be called upon to make a judgment and to throw 38 or 39 books at them and say, here's what we meant. Let's just take a look at them. On the first page at the bottom, number 1, charged with making false or misleading statements to lawfully authorized investigating officers. Well, now, how many investigating officers are there in the United States? And who are they? Where are they? And employees of the United States. Well, in June of 1972, there were only 2,650,000 employees in the United States government. In common decency and common sense, we ought to be more specific than that. Now, I can't agree with everything that Mr. Jenner does, or as has been alluded to, as an outstanding member of the bar, and he is. But I know that other members saw an item in the Wall Street Journal that they didn't agree with. The committee that he sat as chairman of has just reported that they recommend the repeal of the anti-prostitution laws in the United States, which termed the state laws, quote, one of the most direct forms of discrimination against women, end quote. The committee is chaired by Albert Jenner. Now, we don't agree with that.
Time of the gentleman has
expired. We can't agree with everything that Mr. Jenner proposes.
That remark about Special Counsel Albert Jenner will be the subject of further comment in a moment. INPAC's videotape coverage of the House Judiciary Committee's impeachment debate will continue shortly.
This is PBS, the Public Broadcasting Service. Washington Week in Review analyzes the presidency.
Yeah, I think he does think the House will not impeach him. Now, you may think that's living in a world of self-delusion, but I think they genuinely believe that is not going to happen.
Washington Week in Review reports on the Congress.
It's becoming increasingly doubtful whether the Senate will have time this year to try the impeachment trial.
Washington Week in Review discusses foreign affairs.
Kissinger goes up and down in optimism and pessimism. I think that's clear. He saw a chance to get a deal, and he said he'd stay a few more days.
With moderator Paul Duke, Washington Week in Review looks at the major national and international events of the week. From Washington, NPAC's Washington Week in Review.
Evening at Pops is back. Arthur Fiedler and the Boston Pops Orchestra with guest stars for another wonderful summer of entertainment. Join us for an Evening at Pops.
NPAC's coverage of the House Judiciary Committee's impeachment debate continues.
When we restart our videotape, you'll be hearing from one of the more outspoken critics of the president, Father Robert Drinan.
Recognize the gentleman from Massachusetts, Father Drinan, for 5 minutes.
Mr. Chairman, the gentleman from New Jersey states that we are unwilling to make the article specific, and the gentleman from Indiana asked when and what. Let me give you some specifics that the President obviously knows. On June 20, 1972, John Mitchell said that the committee to re-elect had no legal, moral, or ethical responsibility for the Watergate break-in. 2 days later, the President publicly said John Mitchell has accurately stated the facts. On that same day, the President said the White House has had no involvement whatsoever in Watergate. The very next day, however, the President directed Haldeman to get the CIA to head off the FBI investigation. Everyone knows that really in the intent to have the CIA tell the FBI that the CIA has an involvement in Mexico. Why? Because the laundered money. The President of the United States had to know about the laundered money because the checks had shown up that were traceable to the bank account of Bernard Barker. Mr. Helms, the head of the CIA, told Mr. Haldeman and Mr. Ehrlichman there's no involvement of the CIA in the Watergate, and the FBI can go forward in Mexico, and that we have no interest in that matter. But Haldeman said that he feared that the FBI shouldn't do this, and Ehrlichman said that the President himself was concerned about the Mexican money and the Florida bank account. This is the President who 3 days earlier said, we have no involvement whatsoever in the Watergate. And at the end of that meeting on June 23rd, Ehrlichman advised Walters that Mr. Dean would take over in negotiating with the CIA. On June 26th, Mr. Walters told Mr. Dean that no FBI investigator could compromise any CIA activity. On June 27, Dean met with Walters once again, and he had the effrontery to ask the CIA to deviate from its basic purpose and to pay bail for the people who were involved in Watergate and to pay them salaries. And Mr. Walters said, I shall not unless the President orders it. And Dean said that Mr. Ehrlichman has approved of it. And Dean went back to Ehrlichman, and Ehrlichman said to Dean, push Walters a little harder. And the very next day, Mr. Dean summoned Mr. Walters to his White House office, and Dean brought up the 5 Mexican checks and the checks of Mr. Dahlberg. And Dean again asked Mr. Walters to have the CIA stop the FBI investigation. There's no involvement. We have no specifics. On June 28, Dean and Ehrlichman knew that Gray and Helms were not going to collaborate, and they canceled the whole thing. Other specific things happened in that long summer 2 years ago. Dean obtained raw data from Pat Gray on the FBI Watergate investigation, and Mr. Dean turned that over to the committee to re-elect. Attorney General Kleindienst had refused that information, and that information impeded the investigation. Other things happened in that early August of 1972. The President himself asked Mr. Ehrlichman to arrange that Starnes not be compelled to go before the grand jury, and that was granted. And similar compromising arrangements were made by the special prosecutor for Colson and Crow and Young and Chapin and Strawn. They gave testimony before the prosecutors and not before the grand jury. The only possible explanation is the adoption of the policy by the President himself, a policy to obstruct the investigation of the break-in. I yield the balance of my time to the gentleman from California, Mr. Waldy.
Gentleman is recognized.
Thank you, Mr. Chairman. Well, back to the evening of the 20th, where the President is having a conversation with John Mitchell, and they're talking about Watergate, but the phone, unhappily, is a phone that is not hooked to the taping system. That's one of those things that happened on the 20th, and we just have to live with those unhappy circumstances. So the only evidence we have of what they really talked about was a dictabelt where the President recorded, as was his custom, the events that occurred during the day. And on that dictabelt, he got to this paragraph, said, I also talked to John Mitchell, tried to cheer him up a bit. He is terribly chagrined that the activities of anybody attached to his committee should have been handled in such a manner. He only regretted he had not policed all his people more effectively in his own organization. And there's another one of those sad circumstances. There's a 42-second silence on that dictabelt that we have to put up with. But After that, we know then that John Mitchell knew what had happened. There's no question about that. John Mitchell told the president that creep people were involved. The next day, John Mitchell puts out a press release saying he deplored that Watergate break-in, but fortunately there were no creep official people involved, no campaign people. And Ron Ziegler joined that and said, you're right, neither are there any White House people in that third-rate burglary attempt. Now, John Mitchell lied. Everybody agrees, everybody but John Mitchell, for the record. John Mitchell lied. There were campaign people involved, and he knew it. Ron Ziegler lied. Ron Ziegler may not have known it, because Ron Ziegler has an ability not to understand many things that occur, but there were White House people. Hunt. And the president knew Hunt was there. Then on the 22nd, here's the overt acceptance of the president of the plan. The president asked in a press conference what he thought about the Watergate burglary. Were any people from the White House involved? And he said, John Mitchell and Ron Ziegler have told you about that event, and they told you the truth, and I agree with them. He said there were no White House people involved. He said there were no committee to re-elect the president people involved. There were. He knew it. At that point, he joined publicly in front of all the American people the plan to cover up, as he of necessity thought he had to. He could have gone before the American people at that press conference and said, it's incredible. This fellow Liddy went to my attorney general out on the golf course and told him to bail out these fellows. And I fired the attorney general because he didn't report it and didn't put Liddy in jail. He could have said, I've been told that there is creep money involved, that they found down there, money from the committee to re-elect the president. I can't believe that. That's beyond my... In fact, you know what I did? I threw an ashtray across the room when I was told that. That's what he could have said if he wanted to tell the truth. But what he said was there were no White House people and no campaign people involved. The president lied, and the president covered up.
Mr. Chairman.
McClory.
Thank you, Mr. Chairman. As the chairman and the members of the committee know, I do intend to support an article, perhaps two articles of impeachment. But I think that this article, which is proposed, the substitute article proposed by the gentleman from Maryland, is very faulty, very poor, the weakest article which I think the committee could recommend. Now, it's been correctly said that the process of impeachment is not a criminal proceeding, but a civil one. We know that our counsel has confirmed that by recommending that we should only consider that the rule or doctrine of evidence that must prevail here is that of clear and convincing proof, not proof beyond a reasonable doubt. But what we have before us here is an allegation of a conspiracy. Now, it's called a policy, and this is a thesis which our counsel, Mr. Dorr, has propounded in his when he took on this partisan posture in the final days of our investigation. And the thesis is that the president organized and managed the cover-up from the time of the break-in itself or immediately afterwards. And, of course, this is the thesis upon which my colleague from California and from Massachusetts are trying to develop. And it just doesn't hold water. It's weak, it's fuzzy, it's contradictory. The theory just doesn't exist. Now, it may be that on the 21st of March, when the next year, when the president learned about this and we talked about it with Mr. Haldeman and Mr. Dean, he got involved in another type of activity. But in June and in September, they weren't talking about that at all. As a matter of fact, on September 15th, when the president talked about this subject with John Dean, he asked John Dean, he said, what the hell do you think is involved? What's your guess? And what does John Dean says? He says, I think the DNC planted it quite clearly. So that you see, at that time, while they're trying to consider what the political implications are, they suggest that possibly the Democratic National Committee themselves planted the bug in order to try to trap the Republicans. And it was kind of political shenanigans were going on. And on September 15th, if you consider that testimony, if you consider that tape fairly and clearly and honestly, you'll see that they're talking about the political implications, not criminal implications insofar as the White House is concerned. And so what it seems to me is that what we've got here, we've got a criminal charge, and then we're trying to back it, then we're trying to support it by non-criminal allegations and non-criminal proof. Now, it's very well and good to say, well, all the proof is there. We've got 38 volumes. But you know the kind of proof that you're recommending that we're supporting this thesis, this policy, or this conspiracy, is proof of circumstantial evidence, of innuendos, of inferences. Now, what circumstantial evidence is this president and his counsel supposed to look at? It's in the 38 volumes. That's fine. But that isn't the kind of specificity. I didn't do any better than my colleagues on that, did I? Those kind of specific allegations that the president is entitled to have. It seems to me that in connection with this article, in connection with this charge of conspiracy, we should be clear and definite. Where is the direct evidence? Sure, the gentlemen talk about people lying. As a matter of fact, the basis for this immediate involvement of the president is a press release put out by John Mitchell, which somehow they try to attribute to the president. No indication, no proof in this hearing the president ever saw or hear had anything to do with the press release, or knew or didn't know whether it was false or true. Now, that kind of proof just isn't legitimate, it doesn't seem to me, in this kind of a serious, critical, insofar as our nation is concerned, hearing. No, I won't yield at this time. It seems to me clearly that what we should require, if we're going to charge the president with a criminal offense, which is what this is doing, not only have clear and convincing proof, but have proof beyond a reasonable doubt, because that is the standard which we require in connection with a criminal charge. So I'm hopeful that the committee will either require that we do make these charges specific if they're going to be offered at all, or that we dispose of this proposed article and go to the one which relates to the president's oath of office, in which the president did indeed fail to take care to see that the laws were faithfully executed. The violation of his constitutional oath. This doesn't require that kind of specific proof and allegation. And also, I think we should turn to the subject of whether or not the president isn't in contempt of the Congress and subject to an impeachable offense because he refuses to comply with our subpoenas and provide the information that we've required. Those are the things we should consider.
Has expired.
Mr. Chairman? Mr. Chairman?
Recognize the gentleman from New York, Mr. Rangel, for 5 minutes.
Mr. Chairman and my colleagues, it seems to me that our constitutional responsibility is really to respond to the House of Representatives. It seems to me that we would be taking on more than our mandate allows if we were to draw some very narrow allegations and not have the evidence that we have heard over all of these months presented to the members of the House. I think that their judgment as to what final allegations, if any, is going to be presented to the Senate, we can't be presumptive enough that it just meets our needs and to cut off to them the benefit of all of these months of research. If members are having some type of a problem in terms of what they are prepared to vote for in connection with an article of impeachment, it seems to me that this does not necessarily have to be done in a parliamentary way to just delay these proceedings. I think that each member would have the opportunity as to what in his own mind he believes is an impeachable offense, and I personally believe there's enough in the edited transcripts for that purpose. But he should not preclude the information which we have compiled from reaching the floor of the House of Representatives. We merely have the responsibility to report our findings to the House. If we vote articles of impeachment, they may in fact be rejected by the House. If we suggest to them that 3 or 4 articles have been voted on by the majority members of this committee, they may see fit to expand. So it seems to me at this late time that If the members want facts, my God, we've had more than enough facts to reach questions of whether or not we should vote on a particular article. But if there are members that are prepared to vote on a particular article, it seems to me we should be prepared to vote on that and then move so that we can work our will and report back to the House of Representatives. I think that is our restricted constitutional responsibility, and not to allow our vote to be interpreted as being the vote of the full House. I yield to the gentleman from Ohio.
I don't want to let any more time pass than I can help to suggest that the other gentleman from Ohio owes this committee and Mr. Jenner an apology for what I consider to be an unprofessional and certainly an unjudicial comment on a completely extraneous matter with respect to Mr. Jenner. And I would hope the gentleman would reflect that it's unbecoming to the dignity of these proceedings, and in all my time on this committee, it's the first time I ever heard that kind of a thing indulged in.
Gentleman yield.
I don't have the time.
Who has the time? The gentleman is entitled to his opinion, and that's all it is. I might say that the gentleman, Mr. Mann, was referring to some of the items or the articles that he agreed with, and then went into the matter of some of the activities of Mr. Jenner that he agreed with. And I'm not going to give a blanket endorsement to what came out in the paper today.
Well,
I would like, if the gentleman please withhold just a moment.
I would hope the gentleman would reflect on what he did.
No, I think the American people are interested in what was in the article, and here it is.
Mr. Chairman, I
Not at this time. There's still discussion on the... The chair is going to recess at this time until 8 o'clock.
And so ended 5 hours of daytime debate as the House Judiciary Committee moved through the third day of its historic impeachment debate. Today marked another turning point as the members began debating specific articles of impeachment. The day was interesting on several counts. First, it became obvious that the president's defenders, the Republican members of the committee who believe Mr. Nixon should not be impeached, that they intend to use a variety of parliamentary and debating devices in an effort to slow down the impeachment process and even perhaps to try to block it. Second, there is indication that the Democratic majority, which does favor impeachment, may have some difficulty in getting Republicans to go along in supporting all the articles of impeachment which they are now trying to draft. But one thing is certain, and that is that there is now a clear majority on the committee for impeachment, and that ultimately some kind of impeachment resolution almost surely will emerge from the committee. Jim?
Paul, tomorrow is to be another full and complete day for the committee as it continues to wrestle with the exact wording of the proposed articles of impeachment, and we'll be back tomorrow night with our coverage of the day's proceedings. Until then, for Paul Duke and our Impact colleagues, I'm Jim Lara. Thank you and good morning.
From Washington, you have been watching videotaped gavel-to-gavel coverage of the House Judiciary Committee proceedings. Production funding provided by public television stations, the Ford Foundation, and the Corporation for Public Broadcasting. This has been a production of Impact, a division of GWETA. from Washington, NPAC brings you gavel-to-gavel coverage of the House Judiciary Committee proceedings. Tonight, impeachment debate, July 26, 1974. Here is NPAC correspondent Jim Lehrer.
Good evening for Paul Duke and myself. By the time this evening is out, an article of impeachment may be adopted by the House Judiciary Committee, which charges the President of the United States with obstruction of justice in the Watergate cover-up. That is the clear prospect, at least, but that path toward a final vote is still strewn with potential snags and roadblocks. Before adjourning for dinner 90 minutes ago, however, the debate was almost complete on the article, which was introduced by Democrat Paul Sarbanes of Maryland. Based on the give and take within the committee, it appears to have the support of the majority of the committee, as many as 25 or 26 of the 38 members. Much of the committee's time today was taken up by debate over whether or not the Sarbanes article was specific enough, and the lines of combat were clean and easily recognizable.
And the debate today, Jim, was a different kind of debate from the opening round that we've had the past 2 days. In that, we had the congressmen speaking eloquently about their concerns and their convictions about Watergate and all of the various allegations involving the president. But these, for the most part, were the formal, prepared addresses. Today, they got down to the tough job of actually drafting articles of impeachment, and so all of the passions and partisanship which have built up lo these many months began to come out in a very natural way. There were sharp exchanges, and along with it, a good bit of verbal punching. What became clear, I think, were two things. The President's defenders will fight every inch of the way, in every way, to slow down and derail the impeachment drive. And second, it may be more difficult than first seemed likely for the supporters of impeachment to agree on the language of impeachment. In any event, we may be in for a long evening before it finally becomes clear just how the first article, the article which embraces the charges under obstruction of justice against the President, before that article is eventually voted on and perhaps finally approved. The maneuvering still is going on at the Capitol, and as you can see, our reporter, Carolyn Lewis, is standing by, as always, very vigilantly. And Carolyn, can you tell us what's been happening?
There is an effort right now behind, again, those same closed doors to try to soothe some of the ruffled feathers that we've seen in operation over the afternoon, and they may be able to iron out some of the small differences. I think there's been a lot of posturing in the earlier sessions today, a lot of effort to grandstand to reach the general public, but now at about 7 o'clock this evening, some of the members decided they would get together behind closed doors and see if they could iron out these difficulties to shape up something like an article of impeachment that can get general consensus and general agreement. What we expect this evening may be rather surprising. If they can settle this behind closed doors, we may find very quickly that they're going to get to the article itself and vote on the amendments. As I understand it, the amendments, the changes in the amendments have not been very serious, and they may have been generally agreed to in the background. So we might be surprised tonight. This committee that seems to be just lumbering along or creaking along may eventually get to a vote this evening and may get to it quite quickly now that they've gotten rid of all their fuss and bother that we've had in the past. Back to you, Jim.
Well, Carolyn, let me ask you one more question, because you have covered the Capitol for a long time, and you obviously know that congressional committees can get bogged down on the most inane details sometime. But you seem fairly optimistic that we may indeed have a vote tonight. Do you feel that certain about it?
I talked with Peter Rodino's chief aide, Francis O'Brien, just after the session ended, and he seemed to think that there could be a vote tonight. The way he laid out the scenario, he said they expect that Charles Wiggins will make a motion to strike very early in the evening, that is just to get rid of the entire article. Then there'll be a vote to table that or lay it aside, and that will succeed, and then they'll be open to amendments. And he said that they really have ironed out behind the scenes the details on the amendments. So we can only go by the experts. Rodino's aide has been pretty right on just about all the information he's given us, and if he is right, that means we might have a very dramatic vote tonight on that first article. But once again, I've got to warn you that when you're dealing with a congressional committee, there's always that unexpected thing that can happen between now and what we're predicting.
Thank you, Carolyn, and we'll be coming back to you to find out what the latest information may be from time to time. There is one thing of certainty that we can say, namely that there are now clearly enough votes to approve a resolution of impeachment, probably by a margin of more than 2-1. There has been a good bit of jockeying, but during the past few days we have seen how certain votes have shifted from the undecided or the uncommitted column into the committed column, or at least into the column where it becomes fairly clear what it is likely the members will do. We have a tote board, which many of you undoubtedly have seen before and have been following, and our official counter, Jim Lara, is standing at the board now. And Jim, what is your latest calculation?
Well, I think, first of all, Paul, rather than to deal with the general area of impeachment generally, on this one article that now is pending and that they will debate further tonight and finally probably vote on tonight, this is the way I have them arranged at this point. First of all, the rough numbers, those that are now committed to vote aye, the commitment either coming in their prior statements or coming in what they said during the give and take during the day-to-day. You have 23 in the aye column, and let's run through them quickly. Kasten Meyer of Wisconsin, Edwards of California, the chairman, Peter Rodino of New Jersey, Danielson of California, Rangel of New York, Brooks of Texas, Donahue of Massachusetts, Seiberling of Ohio, Jordan of Texas, Holtzman of New York, Mizvinsky of Iowa, Owens of Utah, Sarbanes, the sponsor of the substitute article that is now the subject of the debate and eventually of the vote. He is of Maryland. He is from Maryland, of course. John Conyers of Michigan, Drinan of Massachusetts, Hungate of Missouri, Waldy of California, Alberg of Pennsylvania, Butler of Virginia, a Republican, Thornton of Arkansas, Hogan, a Republican of Maryland, Mann of South Carolina, a Democrat, William Cohen, a Republican from Maine. The two additions today were Mann of South Carolina, who very clearly said today that he would support this article, the Sarbanes substitute article, and Cohen of Maine, the Republican, who also said the same. So we have 23 sure votes. Now, on the nays, those who have said they are definitely not support impeachment generally or this specific article as proposed by Sarbanes. Hutchinson, the ranking minority leader of Michigan, Charles Wiggins of California, Sandman of New Jersey, Moorhead of California, Lott of Mississippi, Maraziti of New Jersey, Lotta of Ohio, Henry Smith of New York, David Dennis of Indiana, Wiley Maine of Iowa. The addition today is Robert McClory of Illinois. Mr. McClory, as you probably know or have heard, has said he would support articles of impeachment, possibly contempt of Congress, possibly an abuse of power. But he said before, and he made it very clear today, that he did not believe the president was guilty of obstruction of justice, and he wasn't going to support this particular article or probably any other article that charged him with obstruction of justice. So all we have is 11 firm votes, all Republicans. All right, over here by himself is Harold Freilich of Wisconsin. He is also a Republican. Mr. Freilich, as you'll recall, said in the general debate that he could support articles of impeachment if they were properly drawn, or drawn in a way that he could accept them. What he said clearly today during the debate was that he couldn't support the wording, or couldn't support the broadness of the Sarbanes amendment. Now, it could be that, or the Sarbanes substitute article. Now, it could be that during dinner the wording might be worked out in such a way that Freilich will eventually support this particular article, but we leave him over by himself. The definite maybe ayes, and the three rather crucial people at this particular stage of the game, the three people that most of the leaders of the pro-impeachment group would concede they must have in order to make this particular article swing when it goes to the House floor, would be Hamilton Fish, a Republican from New York, Tom Railsback, Republican from Illinois, and Walter Flowers, a Democrat of Alabama. These three gentlemen have not declared themselves on this particular article. All right, so to repeat very quickly, the sure votes, 23 ayes, 11 nays, 1 maybe either way, and 3 maybes leaning toward pro-impeachment on Article number 1. All right? Carolyn Lewis, how does that look to you? Would you agree with my totes?
On the whole, I would, Jim. I just have a few questions about Mr. Butler, I think, who also raised some questions this afternoon about the articles of impeachment without some specific lines drawn underneath, and I just wonder whether he's been persuaded that he can go ahead with it without more specificity, which was the word we've been hearing so much. I also feel in my bones, and I can't give you anything more than that Mr. Flowers will not, in the crunch, make an issue of this because he feels so strongly about the morality in the White House that I don't think he would be in that undecided column if he has to go along with an article of impeachment without specific charges underneath. I think he would vote for that article of impeachment. Butler, I don't know. He's a stickler for protocol, and he may decide he might pass that one. I think maybe he's in the wrong column, but that's just judging by what he said late this afternoon.
Well, Carolyn and Paul, let's take it the next step. We've dealt here with sure things. If we were to take your prospect of Flowers and move him over here, and possibly move Butler aside, put Freilich up there, what we're really then talking about is a 23 to 23, 24, about 25 to 13 vote, possibly. Right?
I think the point, Jim, that we should conclude from this is that regardless of the combination, regardless of the members who may be voting on this article, that there certainly will be a majority for it, no matter how many Republicans or how many Southerners. There's one other interesting thing which I think you point out, Jim, here, and that is that there are 7 Southerners on the Judiciary Committee, and all but one now indicate they are ready to vote for some form of an impeachment resolution.
And that the one exception, of course, is Trent Lott of Mississippi, the Republican. I think that the James Mann decision today to definitely vote for impeachment, a man from South Carolina, will have its effect. And as you say, the only 2 remaining maybes then, if we put Flowers over here, probable, then would be Hamilton Fish of New York and Railsback of Illinois.
And additionally, when we first started out, our first night, as I recall, I think we had about 12 members who were in the undecided or uncommitted column. And now almost all of those have fallen into the column for impeachment, or at least have indicated that they can vote for one or more articles of impeachment.
One thing more while we're here at this board, I think we should note, not in terms of the votes, but in terms of the debate that we heard today and that we're likely to hear more of this evening, is that these are the gentlemen who are leading the fight to make the articles more specific. In other words, the Republicans who are already committed against impeachment, and of course who have indicated that they wouldn't vote for an article no matter what it says in it. But they are the gentlemen who are asking the questions and who are carrying the ball for the president, particularly Charles Wiggins of California, Sandman of New Jersey, and Latta of Ohio. All right.
Well, thank you, Jim, for that very fine rundown. What all of this does indicate, of course, is that the die is cast inside the Judiciary Committee. It is certain that some form of resolution will be sent to the House floor. Just when the committee will wind up its work, of course, is not certain. That could come tomorrow, or if the committee cannot complete its deliberations and its voting by then, of course, it could go on into a Sunday session. Chairman Rodino has indicated that possibility. Or it could postpone its final action until next week. After that, we expect the impeachment resolution, in whatever form it may finally emerge from the committee. We expect that resolution to go to the House floor approximately in mid-August. On the House floor, there could be a debate that would go on for a week or for possibly 2 weeks. I believe Carolyn Lewis is standing by at the Hill. No, I am now told that it is Chris Gall. There has been action today at the federal court. as a follow-up to the Supreme Court decision directing the president to turn over 64 tapes to the Watergate prosecutor Leon Jaworski. The White House, of course, has said that it will comply with that order, but there has been a dispute about when it would comply. And our White House man, Chris Gall, has some details on that. Chris?
Yes, Paul. The White House has agreed to turn over some of the subpoenaed tapes by Tuesday and has assured District Court Judge John Sirica that the rest of the tapes will be processed as speedily as possible. The action came today after a hearing in Judge Sirica's court, a hearing requested by Watergate Special Prosecutor Leon Jaworski in an attempt to provoke a court ruling on a timetable for surrendering the 64 tapes and related material that was subpoenaed for the Watergate cover-up trial, which is scheduled to begin September 9th. Rather than issue a ruling, though, Judge Sirica chose to lock up Jaworski and presidential counsel James St. Clair in his jury room to see if they couldn't reach an agreement. And they did, an hour and a half later. St. Clair will make 20 tapes available to the court by next Tuesday and has promised to report to Judge Sirica by next Friday on the status of the remaining 44 tapes. If those tapes are not to be readily available soon after Friday, then Judge Sirica will impose a specific time schedule of his own.
Chris, was there any mention at all in the hearing this morning about the possibility of these tapes eventually ending up in the hands of the House Judiciary Committee, the House of Representatives, the United States Senate, the impeachment process generally?
No, there was no discussion of that in the open hearing. Now, what they said behind the closed doors of the jury room for almost an hour and a half is something else again. I don't know. The only reference to the impeachment inquiry came from Judge Sirica, who wanted to know how Mr. St. Clair could conduct an adequate defense without having listened to many of the tapes that are at issue in the impeachment inquiry.
Yes. Now, there was a statement from Gerald Warren at the daily briefing in San Clemente in which he said the president had no intention of turning these tapes over to the House Judiciary Committee and said that he felt that the committee should continue with its work. This, of course, is important in terms of the reference of the committee because this was a subject of a long debate and eventually a vote this morning where Robert McClory, Republican of Illinois, suggested a 10-day delay if they could get assurances from the president by noon tomorrow that he would, in fact, turn the tapes over. But I guess that is a matter now that is gone by the boards, and there is no indication at all that unless it goes through this long process.
It just doesn't make any sense. I mean, all the talk about turning the tapes over to the Judiciary Committee, from the one hand, St. Clair is telling the court it's going to take some time to segregate these tapes from their big reels to get to the court. Then how can they possibly dump on the Judiciary Committee in a short period of time all these tapes, many of which presumably the president hasn't reviewed? And St. Clair emphasized that the president must listen to those tapes before he turns them over.
But apart from that, Chris, during today's debate, some members made a point of saying that they felt the time was past when the president should be given any more time to turn over these tapes. That, of course, was the subject of the amendment that was offered today to give the president another 10 days if he would give an indication that he would provide the tapes. But the general feeling in the committee was, no, we've subpoenaed material from the White House, and the president has made it absolutely clear that he is not going to provide us with any additional material. So why should we wait upon the president now to see whether he would give us any more material?
Well, there is a problem that St. Clair himself brought up in his recent press conference in California, and that was the implication that some of the conversations that the court wanted might not be there, that the tapes may have just run over, or there may have been some mechanical problems. And I have a feeling that we may run into that kind of problem. The court may run into that sort of problem in not getting everything that Jaworski thinks he's going to get.
I think also we should note, just when we're talking about tapes for the committee, tapes for Judge Sirica, I think we need to point out that the 64 tapes that were subpoenaed by Jaworski were for use in the trial of the Watergate cover-up, or the Watergate cover-up trial, which is slated to begin September the 9th. Now, 63 of those 64 tapes are also under subpoena by the House Judiciary Committee. However, we need to point out that the House Judiciary, as was pointed out in the debate this morning, that the House Judiciary Committee has subpoenaed another 70-some tapes. They have subpoenas pending and refusals received back for 147 or so tapes from the committee. Keep in mind that the committee, obviously, in the impeachment proceeding is investigating things other than Watergate, so that's the reason for the discrepancy. This whole tapes business gets very, very, very confusing.
Jim, this might be a propitious time to bring up the revelation that still another tape has come out today disclosing that the President had threatened to fire George Shultz, his Treasury Secretary, if he tried to prevent the Internal Revenue Service from looking into the activities of some of his political enemies. And according to this story, the President is quoted as saying that after the election, certain uncooperative officials would be let out of the administration. And the story goes on to say the whole goddamn bunch go out, and if he, Schultz, doesn't do it, he is out as Secretary of the Treasury. And that is the way it's going to be played.
You know, there's a fascinating thing about that. That story, of course, comes from the Cox newspaper chain from their Washington bureau. And the best that anybody's been able to determine today, that particular portion of that tape has not yet fallen into the hands of the House Judiciary Committee. In fact, this morning, Congressman Railsback of Illinois mentioned very early that, it was late this morning when they started, but early in the debate, that he mentioned the September 15th tape and said, you know, he asked the question almost, why haven't we gotten it yet? But this one particular segment. Now, but to keep the matter straight, and things are very complicated in this whole matter, the issue of the IRS and the alleged, one of the proposed articles of impeachment, and alleging that the President abused power by exerting power of the IRS or attempting to subvert the workings of the IRS is not involved in Article 1, which is going to be the subject of debate when we take up the live proceeding here in a few moments. This Article 1 is restricted only to the obstruction of justice count, which involves Watergate, and Watergate alone. The count, Article number 2, is the one that alleges abuse of power, and the IRS matter is one that is listed under that, just to keep things straight.
Jim, let's move on now to our distinguished resident experts tonight. William Van Alstyne, constitutional lawyer and teacher at Duke University, and Martin Diamond, a political science professor from Northern Illinois University. They've been sitting in with us today and helping us draw conclusions and witness the proceedings of the Judiciary Committee and proffering us their wisdom. What conclusions did you have about this morning's session?
Well, you asked for wisdom. That's why we're so hesitant. If you'd asked for speculations and guesses, one or the other of us might have been more forthcoming.
Well, in terms of what we're going to see, what we may be seeing tonight.
Well, there is always a tendency in looking at Congress to be annoyed at its apparent backing and filling, its hesitations, its stalls, its delays. It's very likely that once again they'll be late and not actually start at 8 o'clock. But we've already made the point during the day that that's when they're working. That's when they're doing their crucial work. Now, the crucial work going on all day today is to move from a mere or bare majority, quite convinced proponents of impeachment, to a broader majority, and the only kind of majority that can possibly win in the House and in the Senate and in the minds and hearts of the American people. And that's not just a question of dickering, wheeling and dealing, or compromising in any low bargaining sense. That's a question of a meeting of the minds, of a gradual accommodation of legitimate concerns. And I wait with considerable excitement, because this is a terribly exciting process. I wait with considerable excitement to see if it's only some superficial changes that have taken place during the dinner hour, or whether some very substantial developments may have occurred. In politics, the unexpected must be anticipated.
I hope it's not anticlimactic, but I think that, that the coalition will hold together and that the majority has led from strength. It has put forward that article, which on the strength of the debate we've entertained the last 2 days seems to share the broadest base support, the obstruction of justice count. It is an article, moreover, which should terrify the White House as much as it may please the American Civil Liberties Union, because it seems on its face to meet most of the requisites that Mr. St. Clair had asked for at all times, even down to the debatable technicality that the character of the grave offense should at least closely resemble, if not be identical with, federal statutory crimes. I'm most struck by the similarity of language that the President has prevented, obstructed, and impeded the administration of justice in certain then thereafter detailed respects, and the nearly identical language employed by the Criminal Code of the United States on the same count. And I've used terrify, I think not for dramatic effect, but somewhat advisedly in memory of the fact that in the untoward event, the President may be removed by this process. He then does become, in fact, exposed to the ordinary criminal process and may indeed be indicted on roughly identical language.
Well, you speak of the specific detail which may be in the article. We'd like to look more closely at that and solicit the opinions of you two gentlemen, because this obviously is the major agenda item now before the committee. It is a 3-page document that covers the charges growing out of the general charge of obstruction of justice. As has been indicated, it was redrafted in an attempt to compromise that is being managed on the Democratic side by Congressman Paul Sarbanes of Maryland. This article charges the President, following the Watergate break-in, made it his policy to, quote, delay, impede, and obstruct the investigation of the break-in. The draft then cites 9 ways the President allegedly implemented that policy. Now, let me tick off some of these and we'll have a more specific discussion. First, by making false and misleading statements to investigative officers. Second, by withholding relevant evidence. And third, by counseling witnesses to give false or misleading statements. Now, let me just ask you gentlemen some questions about these first 3. Do you have any general or specific conclusions about those?
Well, I think just to report the consequence of the division of the committee earlier, the Republicans charge that this must be made more specific because, as an illustration, although it is alleged that the President made false and misleading statements, it does not then go on to say what the statements were, to whom they were allegedly made, or indeed the specific occasions when this presumably occurred. Thus, their point is that this article may be too indefinite to pass muster in an ordinary court, whether as an indictment or as a rough equivalent in some kind of civil proceeding. I think it's exactly at that point where this difference of specificity has nominally divided the House.
But didn't the Democrats make what could be an effective reply to this, namely that they have 38 volumes of evidence which support all of the charges as detailed in the article itself? And these, of course, are available to every House member who will be voting on impeachment.
Paul, I think that's a weak response, if that's the correct understanding of what they've done, because it does not put an accused adequately on notice of the specifics of what he must defend against by referring him to 38 volumes of material. He must then presumably comb through them, decide what it is the prosecution may rely upon, which events, which occasions, and so on. But I think this is a false issue.
Well, then the argument of Mr. Sarbanes was that the impeachment article itself would run to 38 volumes if you got specific.
Well, went beyond that.
It did indeed.
They said that what they would do, when they propose the articles of impeachment, when they go to the House floor, it will be accompanied by the report of the committee, which will not be the 38 volumes. It will be the kind of detailed information that supports these articles. That, of course, that was Sarbanes' answer. That was also Peter Rodino's answer. Of course, there were several other members who were talking about the 38 volumes, but the sponsor and the chairman were saying there will be a written report, as is required by the House. The committee must put that all together.
The difficulty, I believe, lies in the nature of the accusations against the President. The remark by Representative Hogan that there's a mosaic and many tiles. You can't put into the charge that there's a mosaic, this tile and that tile and that tile, seriatim. The problem is, if we analogize this proceeding to law, then those who want to narrow, restrict, and specify the charges will win. If we make it too broad, then it will be too vague and too loose and perhaps insufficiently just to the accused, in this case the president. And the difficulty that the committee is wrestling with is how to stay sufficiently flexible and say a prudent man would conclude that there was an obstruction of justice when you take the whole pattern of events, and yet make that specific enough to have not only the appearance but the substance of equity. And I haven't the faintest idea how they'll solve their problem. I leave it to the rest of you to anticipate. I'll wait for the event.
Thank you. I'll join you in that, sir.
Let's move on now to other charges which are mentioned in the article as drafted and is offered by Democratic Congressman Sarbanes. Fourth, the President is charged with interfering or endeavoring to interfere with investigations by the Justice Department, the FBI, and the Special Watergate Prosecutor. Fifth, approving and condoning the surreptitious payment of money for obtaining silence or influencing witnesses. Do you have any opinions about these two charges as mentioned in the article?
Let me make one suggestion, and then I'll turn it over to the law, and that is condoning and acquiescing do not have a time and a place. And that's part of the difficulty here. The real gravamen of the charge is that the president condoned, or to use James Madison's language, neglected to superintend the conduct of his subordinates, or permitted them to perpetrate with impunity. When you permit and when you fail to superintend, you are condoning or acquiescing, and there isn't a moment in which the condonation took place or the acquiescence
That
occurred.
on or about July 3rd, 1972, he did condone a certain thing,
Right.
or he did fail to superintend or
Rather
supervise.
what happens is you say, well, that might have been an oversight, and in June he perhaps neglected, and by early July, well, he might have forgotten. But as the time goes by, it's a pattern of acquiescence. It's a pattern of sustained permissiveness. And that's what the Democrats and some of the Republican accusers are saying, and it's difficult for that to meet the test of legal specificity, and the proceedings are fumbling and stumbling with this legitimate difficulty.
I think Martin's point is not only well taken, but just beautifully expressed. There is an enormous problem. If the majority of the committee were literally to attempt to plead the evidence, it would truly trivialize the article of impeachment. It is as though you would be repleading the tapes they have, the evidence, the statements, and all the rest, so that you'd have such a superabundance of material. One would be virtually confused by sheer welter. But there are other problems. One of these is that each member of the committee, at least, must be certain to his own conscience that he has in mind at least the general specifics that support these articles. One speaks of interfering or endeavoring to interfere with the conduct of investigations, and it is a fair question for each person to ask himself, well, how did he interfere? When? Where? In what way? With whom, for instance? Now, it may be that different fragments of events are of differential attractiveness to different members of the committee. And we do get into a certain logical impasse here, that you get a majority voting for the proposition, though no majority agrees on how you would translate any particular set of events.
Right. That's to move that one step further, to use a specific example. Let's say that number 4 said that the president interfered with the investigation of the Department of Justice on June 20, 1972, by telling John Mitchell, boom-de-yada, boom, boom, boom. All right. There might be, say, only 1/3 of the committee who feels that that particular act constituted interfering with the Department of Justice.
Exactly.
However, there might be another third who felt that the conversation on June 23rd between boom-de-yop and boom-boom did this, and it goes on and on. So that's the reason from the Democratic side, or the pro-impeachment side, that they want to keep this broad, rather broad language, and while on the Republican side, the anti-impeachment side, they want those specifics, because if they get that specific time, place, then they stand a chance, at least, of diffusing the majority vote.
There's no question that that's right. That poses the strategy very well, but I think for the reassurance of those who watch it, at any rate, it is largely a political difference then, and it is really not a legal difference, for In point of history, the House may, if it wishes, simply impeach the President with no specific grounds at all, and only thereafter may the Senate demand of the House manager is a greater particularization, so that whatever one's feeling about the propriety of it, at least the precedent for proceeding on fairly general terms is reasonably well established.
Paul, before you go on to the next articles or the next specifications within the articles, let me point out to the viewers that the House Judiciary Committee live debate this evening was scheduled to begin at 8 p.m. Eastern Time. We are awaiting that conclusion, that opening. However, we have now been informed that it may be 8:30. As you can see for yourself, the committee room is virtually vacant. It is vacant of committee members, and so as soon as we get closer, as soon as the members start going in, of course, we'll come back to the hearing room. Back to the list, Paul.
I think you're optimistic if you're thinking in terms of 8:30.
Oh, well,
knowing the track record that we've had the last three days. But let's move on. What we're doing, we're going down the specific allegations that are contained in the compromise article charging the President with obstruction of justice. And we have reviewed 5 of the specific allegations, and now we're at 6. This charges the President with endeavoring to misuse the Central Intelligence Agency. Number 7, that information was disseminated from officers of the Justice Department to aid subjects who were being investigated for criminal liability. Well, here we go back to one of the old issues, I think, and that is, was the President responsible for some of the actions of his aides, and did he try to protect his aides, and in so doing, does this constitute an impeachable offense? Bill?
Well, this does divide professionals, but again, I think that in this article the majority has been relatively circumspect and conservative. There is nothing that I see in the article, for instance, that assigns to the President any theory of strict liability. That is to say, that he literally must be made to stand in the impeachment shoes of any agent or employee of his, no matter what the lack of personal fault. No matter that he did not know and that he should not have known, and indeed as soon as he found out, he took immediate recourse. There's no suggestion of strict liability here. At the outside, I think Professor Diamond is quite right. This applies one version of the clause, best represented through the announcement of James Madison, that where the President condones, learns of something, and should affirmatively then have taken some action to set it right, and to aid the investigation, to fire the employee, and fails to do so, and therefore condones it. In that sense, then, he does, at that point, violate his duty faithfully to execute the laws, and he may be accountable exactly on that theory. That is not a very radical theory of the scope of the impeachment clause.
That is not a criminal offense, right?
No.
That's a good distinction to be made in that particular case.
Well, whether it would lapse over to a violation of specifically, Jim, Section 1503 of the obstruction of justice.
I remember it well, right?
It might coincidentally do so, but that would require a more rigorous standard of proof before a federal jury to satisfy certain technical criminal elements. It is not my view that the committee deems itself bound by the accident as to whether or not Congress has previously enacted into law statutes exactly describing...
Get it down to simple terms again. A private citizen, I'm a private citizen, you're a private citizen, you come to me and you say, hey, our friends Billy Bob over here and Sammy Sue have committed perjury, all right? And you don't pick up the phone and call somebody and turn those two guys in.
Yes.
Have you committed an act of obstruction of justice?
No, not in my view. You've not impeded the investigation, you've simply not volunteered to help.
But I have, by not doing anything, I have condoned it, right?
Well, if there's an affirmative duty on you to come forward, which there is not on most citizens.
That's the point.
That
but
is
in the President's case, as you're saying, in the President's case, he has, under his oath of office, the responsibility for upholding the laws. Is that...
Let me put it in plain language. We didn't pick a president.
I thought that's what I was doing.
We didn't. Plainer. Okay. We didn't pick a president or a senator would be only as good as us. We'd have a heck of a poor government if the men we chose were only as good as the choosers. But there is a heavier obligation laid on the elected officer.
But doesn't that go even beyond that, not only in terms of the quality of the man, the
For instance, the same would be true for a police officer, would it not? Doesn't he take an oath of office to do certain things?
Yes, that's a much closer comparison. It really has to do with the official role one has assumed. An officer who failed to bring to the attention of his employed colleagues a probable crime would be in dereliction of duty, and at minimum could be fired. Indeed, it's a nice equivalent, because one will recall that the maximum outcome of an impeachment proceeding is literally to fire the president. It is not to jail or fine him.
Well, to get down to specifics, there are two specific issues involved here. One is the president receiving grand and jury information from Henry Peterson of the Justice Department.
Yes.
And then submitting that information to some of his closest aides. And the other issue, of course, involves the Howard Hunt hush money episode. Now, it is in dispute as to whether the president did order the payment of hush money.
Yes.
But some people contend this is not the basic issue, that the basic issue is that the president went along, that he had knowledge of it.
Well, it may be a bit of each, as I should see it. I mean, there is a question, for instance, as to whether the president necessarily deemed it to be hush money. One can believe that he regarded it as an act of compassion and that it was not to buy off silence. But however one concludes on that, one still has the separate issue, even assuming it was seen by him, not as criminal in purpose and not in order to protect himself, but in compassion for someone who, however outrageously he had behaved himself, had tried to serve the president's interest. Still, to the extent the president has an affirmative duty to see that the laws are faithfully executed and impedes for whatever motive, compassion or otherwise, their due execution, then he may be derelict by that standard of misconduct.
Let us now move on to the final two items in the article of impeachment. Number 8, that the president made false or misleading public statements that were designed to deceive the American people into believing that thorough investigations had been conducted into charges of misconduct at the White House, by the White House, and also at the president's reelection campaign committee. And number 9, that he endeavored to cause defendants and those convicted to expect favored treatment in return for their silence or for their false testimony. What about the legitimacy of these?
Well, Paul, actually, item number 8 was the only one in isolation that gave me problems.
Yes.
Making false and misleading public statements for the purpose of deceiving the people of the United States. Mendacity, lying, is not a crime by itself. But in the totality of all of the rest of this, if it's the intention of the majority to show that this is simply a piece of that mosaic, that is, say, deceiving the public was part of a larger concept of frustrating the processes of justice, so that misleading the public then would serve that ulterior purpose, it would appropriately fit into the general theory.
I had the same difficulty. If we were to get into the business of evaluating false and misleading statements by politicians, let alone ourselves, we're really in very difficult waters. And politicians are sometimes under obligation to speak, if not with forked tongue, then cautiously and with some misdirection, and to do so for the general welfare. So there is something very troubling about making a political crime on the part of the president, this charge of false and misleading statements. But it is true, taken in context with the other 8 specifics, it lends color, it lends weight to the others, and thus may be considered a legitimate charge.
I was struck by the fact, picking up on your point, I was struck up with on the fact this afternoon and during the debate, Congressman Waldy alleging one of the overt acts under this particular thing, a statement that the president made in response to a question at a press conference, and it had that kind of same ring to me. That's an unusual kind of charge, having made a statement at a press conference that was, in his opinion, been alleged was false, and to make it an article of impeachment. But I guess, again, the point that needs to be made is that this, obviously, to make a false statement, you'd have to do it to a grand jury or to an investigative officer to be considered guilty of a crime.
Well, yes. Charles Black, in his recent book, has made a very helpful observation. To a very considerable extent, it is the why that something is done, which may bring to it the taint of criminality and converts it into an impeachable offense. Specifically in this instance, if the committee is persuaded that the reason the public was lied to, if they agreed that they were lied to, that the reason was to make more effective the throttling of the processes of justice, then they've demonstrated that form of criminal purpose, of wrongful purpose. It'd be very different, for instance, than the president lying about where troops are located in wartime. Even though the public may be deceived, so may the enemy. Therefore, the derivation, the inference of purpose, really is a kind of inescapable item of importance in the overall judgment of this matter.
Professor Van Alstyne used the word criminality, and we've all used the word crime or criminality during the day, and it's perfectly correct if it is understood to be political criminality, political crime. The impeachment clause was drawn by the Founding Fathers with great care to exclude criminal prosecution excuse me, and criminal punishment. In England, and this is only one of many examples of the way in which our practice differs radically from the English precedents. And one must never infer from the English precedents what the American intention is. In England, an impeachment could be followed with losing your head, with criminal prosecution. It was a criminal prosecution and had criminal punishment. This was carefully segregated from that, and therefore it is addressed to political crimes, or to quote Alexander Hamilton, crimes committed immediately against the society as a whole. So if we use the word crime, we must shear off from our thinking all that goes with ordinary criminal law.
And that, of course, is the reason that in this article the word policy is used rather than the word conspiracy. In other words, the president is alleged to have adopted a policy and furthered a policy of cover-up, obstruction of justice, and then he committed these acts as a policy rather than a conspiracy, which is considered a criminal law and a legal term. Let's go now to Carolyn Lewis, who has with her Congressman Jerome Waldy of California, man I was just talking about. Carolyn?
Mr. Waldy, what on earth is going on here, and what are the prospects for getting through to a vote tonight?
Well, in answer to the former, I'm not sure. In answer to the latter, as to the prospects of getting through tonight, I think they're dim.
Why do you say that?
Well, I had hoped when we began this morning that we would be ready to vote on at least the first article. But we're so embroiled now in lawyer business rather than the people's business that it's unlikely we'll get to the substance of the purpose for which we've convened today, which is to argue the facts and the evidence. There has been very little of that. There's been an awful lot of lawyer argument about procedures, very little argument about what did the president do and when did he do it. And until we get to that, we're not likely to get to a vote tonight.
I understand that Congressman Wiggins, who's one of the president's staunch supporters, is going to introduce 9 motions to strike. Would you explain to the general public what exactly that means and what it's going to do to these proceedings?
Well, what he's seeking to do by that is to remove from consideration 9 allegations of presidential misconduct. And a motion to strike is the same as a motion to defeat that particular allegation of misconduct. But procedurally, it means he gets 5 minutes for every motion, so does all 37 others get 5 minutes to argue against it. It's a time-consuming device, and I'm quite certain is advanced for that purpose. I think that's part of the strategy that the minority is utilizing at this moment.
Why would they be doing it when they know they're going to be defeated eventually? I mean, what do you think they gain by this tactic?
I think what they're gaining is maybe that they can provoke members of the committee to acts of intolerance, to acts of irritation that will reflect upon the case that will ultimately be voted by the Judiciary Committee. Anytime you can cast any aspersion on the body that comes up with a decision, you thereby have impinged adversely on the decision. So if they can make the Judiciary Committee look bad and its people look bad, they will make its product look bad, they hope, which will be a vote to impeach.
These people these Republicans have been arguing that you are denying to the president due process, that you are not going to give him the full evidence to support your case until you're actually going to trial. Now, how do you counter that argument, Mr. Waldy?
Well, it isn't true, is the best way to counter it. The president has had his attorney present during all the evidence that we've considered for the last 8 weeks, upon which these general allegations are predicated. When we finally do vote a report will be based upon the allegations of impeachment, articles of impeachment, it will go to the House of Representatives and to the President, accompanied by a thick volume of the evidence sustaining the general allegations, and that will be specific evidence, far more specific than they are alleging the articles lack in terms of their present description. So that simply is an argument that is not honestly based in fact.
I think a lot of people are wondering why the chairman of this powerful committee is allowing this kind of delay and to go on. I mean, could you explain what Mr. Rodino is really doing there?
Well, Peter Rodino is an enormously fair individual, and Peter Rodino started this proceeding with an absolute conviction that he would never permit it to be said, if he could avoid it, that the president's rights had been jeopardized. And the easiest way to prompt such a determination that his rights have been jeopardized is to be heavy-handed in his rulings, cutting off debate or rights of the minority. So as a result, the minority frequently is able to abuse that tolerance on the chair. And I find that an attitude of strength and a decision on the chair's part, Mr. Rodino's part, that I fully concur in.
But couldn't this mean you have a lengthy delay, that you don't really get this vote to the floor of the House when you promised it to the leadership?
Yes, it could, but the other alternative would be to be subjected to charges that we did not give the president's men on the committee ample time to make the president's case. And I happen to concur with those who say bend over backward. The case is so weak they need all the time they can get, in my view.
Well, isn't it going to end up being a question of who can survive the other? I mean, you're going to be patient, and they are going to keep hammering away. How's it going to come out in the end, Mr. Walden?
Well, I think ultimately it'll come out as most of the disputes in legislative halls come out. Reasonable men have their moments of unreason and irrationality, and then after they've played that game a bit, they soon come back into more reasonable channels. And I think by tomorrow we'll be settling down and doing that which we came here to do, argue the evidence.
Thank you very much, Mr. Walden. Thank you. Thanks.
All right, we're awaiting the convening of the evening session of the House Judiciary Committee. I must confess at this point, as you can see, they're just behind me here, you can see there are just a few members there. Members of the press and some of the audience are there. Now, I must confess one thing to you, Paul, and I'll confess it to the audience. Before we went on the air tonight, as you'll notice, I opened by saying by the time this evening is out, an article of impeachment may be adopted by the House Judiciary Committee. And I had originally had the word will, and then I said at least that was the prospect and all this sort of thing. And Paul Duke prevailed upon me to change the word will to may. And I'm certainly glad you did that, Paul, because...
It's just my cautious nature.
Yeah, because it looks like, as we've just heard from Congressman Waldy, keep in mind that Congressman Waldy's background, he's been an advocate of impeachment for many, many months. In fact, it was he is the one who introduced that first proposal for impeachment following the firing of Archibald Cox, the special Watergate prosecutor, et cetera. And, but he says it's going to... probably will not have this vote tonight. You were right, Paul. You were right. I should have listened.
I must say that my caution is rooted in some experience from being a reporter at the Capitol. And I remember one bill that was a major bill, and it took a committee 3 months to mark up the bill. And that is to draft the language, to put it in the precise detail that was needed to get it to the floor. So I don't think it's going to take that long to get the impeachment resolution to the House floor, but I don't think that we should deceive ourselves or the public into believing that necessarily this fight inside the Judiciary Committee over how to draft articles of impeachment is going to be resolved that easily. And I think what has happened today may be a tip-off. I would like to ask our two guests, though, who've been sitting here so patiently, lo these many hours during today, and Bill Van Alstyne was here yesterday, of course. The question I'd like to put to you is, as we watch the Judiciary Committee in action, do you feel that that committee has done a basically good job in its approach to the impeachment investigation and the way it has gone about its business? And I ask this in the light of in the light of history, because this committee has not considered an impeachment resolution since 1936. There is not a single member on the committee who was on the committee the last time an impeachment issue was considered.
Yes. Paul, I feel always more comfortable in being critical of Congress. It simply seems academically more in keeping with one's calling. But the fact is that I think the committee has been virtually exemplary. The amount of time that's been devoted to it, and I do agree with Congressman Walde, Rodino's evident determination to suffer any length of delay, to be quite certain that all have had an opportunity to raise every possible point, speaks well of the House on this occasion. In fact, it may very well be their lack of experience which has induced a mood of caution. I think also that the character of counsel whom they have retained has been reflected very well, and that the product is likely to show that. Ordinarily, I do not have a very high esteem of Congress, and indeed I think it has lost power to the President, not so much for constitutional reasons, historically, but because of its own lethargy and ineptitude. But on this occasion, at least, I think the committee has acted quite splendidly.
Let me ask you...
Dr. Diamond wants to answer that, too.
Then I'll come back.
I hadn't really. I just accidentally lowered my hand, but I'll be happy to seize on the opportunity and half agree and half disagree with Professor Van Alstyne. I've been a long-time admirer of Congress, and I have found it my happy duty within the Academy to scold all my colleagues who constantly see Congress perishing on the vine and remind them of its residual strength. And this one observation on the side. Most of the time that people think Congress is flat and not doing its business is because Congress is doing its business energetically, but contrary to the wishes of the people who think Congress is flat on its back. That is to say, it's an ideological difference frequently rather than an objective judgment of Congress's ability.
Well,
I've been delighted at the quality of this committee, at the manifest seriousness and earnestness of its deliberations, at its really fine balance of good, solid partisanship, good, solid constituency concern, and a real grassroots rising up to the gravity of the issues. Not an easy ideological elevation, but an earnest, painful movement up from constituency and wheeling and dealing, which means their results may be solid and not merely gratifying to those who have one or another set of passions.
Well, let me ask you this question, because we have heard this argument many times about Congress losing power to the presidency, and Bill Van Alstyne just expressed that in a certain sense. But it certainly was true, was it not, that in the 19th century, Congress exerted itself much more forcefully than it has lately. And Congress did not wait upon the president, for example, to make his recommendations for legislation. Isn't it true that much of the pioneer legislation, some of the great laws of this country, really originated more with Congress than at the White House? But now one has the impression that members of Congress wait for the president to make his recommendations before they act.
I believe there has been a slight shift, relatively slight. The great problem is that there's been an infinite increase in the quantity of government generally, local, state, and national. And with that infinite increase, a vast amount does come out of the administrative agencies. But when it comes from the administration, that's not coming from the president. That's coming from Congress and president meeting at the administrative agencies. Congress has an input into the executive proposals, and the executive proposes only what it thinks it can get. Moreover, the 19th century was by no means a period of presidential passiveness and congressional supremacy. Late 19th century looked something like that, but not Lincoln, not King Andrew Jackson. One of the great issues in the middle of the century, or the first half of the century, was the Whig complaint that a kind of monarchic government was frequently afoot. So the historical perspective makes our present moment less wretched than we preen ourselves on its being.
Well, a more valid argument may be advanced by those who contend that Congress has not really come into the 20th century in the way that it should, and that it is not always prepared to cope and deal with today's issues. Let's take the defense budget, for example, and I don't want to move too far afield from
Yeah, I was wondering when we were going to get back to impeachment for a minute.
Because we are waiting now for the Judiciary Committee to meet and to begin its night session, but it does appear that we shall have perhaps a long wait. There you see the committee room. You see a few members who have come in and have taken their seats, but by and large, only a few, and Chairman Peter Rodino has not yet arrived.
Paul, before we go to the defense budget, let me ask you gentlemen, what effect do you think television is having on this House Judiciary Committee proceeding up to this point? Good, bad, indifferent, or none?
I think it's having several obvious effects, some of which were pointed out by its own membership this afternoon. To a certain extent, there's no question that some of the debate is stagey, it's unauthentic, to the extent that it's more rhetorical. They're reiterating points that some declare themselves impatiently to have heard many times, the whole idea of being to achieve credibility with the viewing audience. But there's a circularity, there's a feedback that's important. And so on balance, I think it not histrionic, and I think it not improper that there be a certain staging of the whole debate once again. Because precisely to the extent that the point of view being communicated is effective with those who watch, and they in turn at least demonstrate that they are made believers one way or the other. That seems to me a very lucid way in which the process ought in totality to operate. It's quite proper, therefore, and on balance, I think that contrary to the expectation of some, that this would make it just rank melodrama, overall it's been a very elevating experience to have the camera present.
Incidentally, we were told today that the President is not watching the impeachment proceedings. It came up at his news conference, and a reporter asked one of the press aides at the White House, why isn't the President watching the television proceedings? And the aide responded, it is just his habit not to.
What do you think?
That Mr. Nixon apparently just does not watch television that much.
Dr. Diamond, what do you think of the effects of television?
I think it's a very mixed bag. What is interesting is the concrete proof, as Professor Van Alstyne has pointed out during the course of the day, that the televising does affect the behavior and the process. You will remember when the question came up, it was said why the lights won't bother them, the cameras won't bother them, and really the public deserve to hear, and it won't have any effect. It does have a significant effect. Now, whether that effect is good or bad, I really am not sure of. What makes me think it's a good effect is my own delight in being privy to the proceedings. I immensely enjoy the opportunity to follow it and watch it.
Even the give and take on procedural issues?
Oh, especially the give and take on procedural issues, because that's when you have to figure out from the surface down to the roots what's going on. That's when the political game is so fascinating. But what is its effect on the public? Is there a limiting of the representative's function of himself soberly, privately, seriously deciding what's best for the country? Does it hamper that? Does it limit it? Or does he play to the gallery harmfully? Or is it the beginning of a process of public education? Or is it a process of public surfeit? Too doggone much. At some stage in the process of representative democracy, the average person who's got other fish to fry and a living to make and kids to raise, at some stage in the process, the public says, we want to see what our representatives think. We want them to formulate the issue, to firm up a decision, and bring it to us, and we'll decide somehow yea or nay on the basis of what they do. That's happening now. I'm just not sure whether television doesn't do too much of a muchness.
Do you both favor televising the proceedings on the House and Senate floor, assuming that we do get that far?
Yes, I would, for essentially the same reasons I've offered here. This is a matter of sufficient importance, and I think that sobriety is more nearly induced rather than mere posturing encouraged. Thoughtfulness. Too much is at stake here, and I think if there is a net effect, it will be to the good. And that is all to one side of observing, as Dr. Diamond already has, that I have no doubt that in terms of the public's interest and what one learns from the fascination of this give and take in Congress, as it will be in the House and the Senate too, it's a net advantage.
Do you think it has an excuse me, do you think it has an effect also, and going back to a point that Walding made in the interview with Caroline,
that that this proceeding must emerge as a fair proceeding if it is in fact to be accepted, regardless of what the end result is, if it is going to be accepted by the American people, and that the procedural things that Waldy was talking about and that we have seen today, the American public is not that aware of those and not interested in them, and understandably so. But the perception of fairness, or the appearance of fairness, is extremely important, is it not?
Oh yes. On balance, I think that will be a good effect. I think the people who do watch it, and the audience will dwindle, the people who do watch it will see that honorable men are slowly, apparently, coming to the conclusion that the impeachment process must go forward, and that will have a powerful moral authority in the public.
Paul, you've watched the House committees, and the House generally function when the television lights were not on many occasions. How would you judge the effect of television?
Well, I really don't know what the effect will be, Jim, to be honest about it. The House has always been fearful of television. The two bodies are quite different in their approach to television. The Senate has had television, or has permitted cameras into its committee proceedings for 20 years. The House has permitted the cameras in for only the past 3 years, I believe. The leadership on the House side has been much more skeptical about employing television, as you know, than has the Senate leadership. Mike Mansfield, for example, has already made it quite clear that he favors televising a Senate trial should the House impeach the president. On the House side, the Speaker, Carl Albert, has been much more bearish and much more reluctant to do that. I think the fear is that you would have some members on the floor who would engage in speech making for political purposes and so forth. So we really don't know precisely what the effect will be. And now I'm told that Carolyn Lewis is standing by with Congressman Charles Wiggins at the Capitol.
Mr. Wiggins, what exactly are you planning to do tonight?
Endure. Well, at the appropriate time, it would be my intention to seek recognition to offer a motion to strike the first subdivision of the Sarbanes substitute article. My purpose in seeking that time is merely to ask Mr. Sarbanes, who is the author of the substitute, to say who and where and when and in what respect the facts support the general allegation.
But, Mr. Wiggins, surely after all these weeks and all the evidence, you know what the facts are to support these charges, and isn't this really just an effort to delay and obstruct?
Oh, absolutely not. Absolutely not. There are truly, and I don't know how I can convey to you other than what I feel very strongly, there are really quite serious legal questions involved. Now let's go back to that first discussion that has taken the better part of the evening on what was the nature of this policy. That's a very important fact to establish, because you understand all of the alleged misdeeds that Mr. Waldy is pointing to are not the misdeeds of the president, they're someone else. And before any of those misdeeds can be attributed to the president and be considered as evidence in this case, we have to establish the policy, which is another way, I think, of saying the conspiratorial plan. The time that that plan comes into existence is very important in deciding the relevancy of the various acts of others. Well, now, the pleading, the allegation, didn't tell us when. It didn't tell the president when. And after, 2 or 3 hours of debate, I bet you can't tell me when. I don't know. Certainly the evidence is not clear and convincing as to when this plot was hatched.
Don't you think that all of those bits of evidence, those specifics, will come out in the report which will be attached to the articles of impeachment? So aren't you really just quibbling over a phrase that you want it in the articles instead of attached to them?
No. You understand, we have to vote tonight or tomorrow night on facts known and believed by us. We don't vote on concepts and then delegate the staff to fill in all the facts. The members are entitled to vote on the facts tonight or tomorrow, whenever the vote occurs. This business of delegating the responsibility of digging through this evidence and finding facts to the staff is in derogation of our functions.
You don't really have the votes for this, so what do you expect to achieve by all these these long votes? You're going to have 45 minutes for each motion to strike and so on. What's going to happen?
It may not take 45 minutes. I think, if nothing else, it will cause some of the Democrats who feel compelled to impeach, almost without reference to what the evidence is, to reflect on what that evidence is and its quality when we get into the next subdivision. And I trust that you and your listeners will be objective and measure the kind of conduct that they are attributing to the president in justifying the sweeping allegation that he has withheld evidence. Well, we'll see. Wait till they try to prove that fact.
Thank you very much, Mr. Wiggins. Over to you, Jim.
All right, thank you, Carolyn. That was Congressman Wiggins of California, the president's primary defender on the committee. All right, the issue involved in this, the subject of the debate and the vote, if it comes tonight or tomorrow, and the specific charge, the specific article alleging obstruction of justice, was introduced by Paul Sarbanes of Maryland. It was a substitute to the original Democratic proposal that was introduced by Donahue of Massachusetts. Now, in the course of the day today, Sarbanes was the man who had to answer all of the questions, or most of the questions, about the contents of his substitute. So we want to go back and take a look at one of the things he said.
And there I want to make three things very clear. First, the President's counsel has been here throughout the proceedings. All of the factual material that the committee has considered, all of the statements of information, all of the summaries were provided to him on a daily basis, just as they were provided to us. So the contours and the details and the pattern and the interrelationship of the factual matters has been spelled out fully to the President's counsel. Nothing has been concealed from him. Second, this committee, once it makes its decision, will have to make a recommendation to the floor of the House of Representatives, and at that point, what we bring forth will be supported by a report which will have to detail the underpinning for the action that we have taken. So the material will again be spelt out there for the benefit of our colleagues in the House before they make their decision. At this point, or in the House, at neither of those instances is the President yet on trial. He is only on trial when the matter reaches the Senate. And thirdly, when the matter does reach the Senate, the President's counsel is in a position to seek further specification if he deems it's necessary, although it's my conviction that his participation here and the further report that will have to be prepared for the members of the House of Representatives will fully provide him with all of the material necessary to prepare a defense for the trial, which will take place in the other body.
All right, that was Paul Sarbanes of Maryland making a response to this charge that his article of impeachment was too broad, was not specific enough. That was from the session earlier today. All right, we are awaiting the opening of the night session. It was to begin at 8. It is now 8 Eastern Time, and it is now almost 45 minutes late. There you see now Chairman Rodino has entered the room and is now taking his chair. During this 45 minutes, Paul, it's safe to say, would you not agree that they have been caucusing and talking in private and all that sort of thing?
That undoubtedly has been going on. We have had huddles, dinner meetings, private sessions, undoubtedly, involving key Democrats and key Republicans as they try to agree, try to refine compromise language for going ahead and approving an initial article of impeachment, an article that will charge the president with an obstruction of justice. It is also likely that after completing this, that an additional article, or perhaps even 2 articles, will be approved. So when the impeachment resolution is finally drafted and it is finally put together, it will consist, in all likelihood, of 2 or more articles.
We have a caucus going on down there now, as a matter of fact. Rodino there, of course, is in the center with his hand up to his face on the right, far right. Talking now is Railsback of Illinois. Sarbanes is the man there on the left, I believe, or is that Mosvinsky? I'm not sure. There are other members of the committee. There's Father Drinan, of course, who's a Jesuit priest from Massachusetts. Hungate of Missouri. Kastenmeier there. Here we come, Donahue of Massachusetts.
Speaking of Hungate, Jim, and the camera just showed him a moment ago, he's a distinguished, white-haired man. He injected the first humor into the sessions today and evoked a couple of laughters, and maybe he will become the Sam Ervin of the impeachment proceedings.
And was later chastised for it by a Republican Moorhead of California who said that this was not a laughing matter and that he didn't appreciate Congressman Hungate's Missouri-isms or down-home humor.
But I don't think this is all that surprising, the fact that they can't get together on the language of an article. In fact, I rather think that it is to be expected. And I think what today's debate really showed is that the various members may agree on the necessity of an impeachment resolution, but each has his own ideas and his own thoughts and his own concepts about how to go about it, and particularly what the impeachment resolution should include. And so the problem is, how do you get a majority of the 38 members to agree on the specific language? And that's why this could become a time-consuming, drawn-out process. As you indicated just a moment ago, Jim, there was at least a chance earlier in the day, it was believed, that the committee might well approve one article, this article, relating to obstruction of justice today. But now it seems very dim for that to happen.
Particularly with based on what Congressman Wiggins just told Carolyn and the rest of us via Carolyn, which is that he plans to introduce a series of motions to strike. Meaning, when he says strike, he means, as Congressman Waldy explained, to remove the language of the 9 means, is what they're defined. They're alleging the president implemented a policy of obstruction of justice, and then under that there were 9 means that the president allegedly used to implement this policy. And under a motion to strike,
there goes the gavel. Chairman Rodino bringing the committee to order for its 3rd night session this week.
We'll see what the chairman does now on this motion to strike business. That would mean that each paragraph of that 9-count supporting thing.
I think it's interesting about Chairman Rodino, Jim. When the impeachment investigation began, back in February, when the committee really got down to business, Congressman Rodino was afraid to meet the press. He was reluctant to talk to reporters, but now he's a fearless man. He thinks nothing of standing up and holding a news conference before 200 reporters. So he has adjusted to his responsibilities in more ways than one.
You could tell that the other night in his opening speech, much more sure of himself than he was, say, when he opened this whole thing 10 weeks ago, also on television. I remember that when he was much more nervous and halting and blew a few words, but he didn't the other night.
And apparently we are just about
to begin.
Committee
will be in order. I recognize the gentlelady from Texas, Ms. Jordan, for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, this committee has spent 2 days receiving and listening to very eloquent arguments. We talked about the Constitution, and we talked about the serious nature of the impeachment process, and all which was said, we were telling the truth. We believed what we were talking about. And now, Mr. Chairman, this committee is called upon to get to the matter of the consideration of articles of impeachment. It apparently is very difficult for the committee to translate its views of the Constitution into the realities of the impeachment provision. It's understandable that this committee would have procedural difficulties because this is an unfamiliar and strange procedure. But some of the arguments which were offered earlier today by some members of this committee, in my judgment, are phantom arguments, bottomless arguments. Due process. If we have not afforded the President of the United States due process as we have proceeded through this impeachment inquiry, then there is no due process to be found anywhere. Well, what did we do? The Judiciary Committee, under all of the historical precedent available, does not have to allow counsel to the President to participate in its proceedings. But this committee, because of its grace, because it wanted to be fair, because of its interest in due process, allowed, suffered, if you will, counsel to the President to sit in these proceedings every day. He was present. Was he gagged? Was he silent? No, because this Judiciary Committee passed a rule which allowed the President's counsel to speak. Now, one might say, well, certainly that is minimal due process. All I'm saying is that the committee was under no compulsion to do that, but voted to do it. So the President's counsel was here and received every item of information this committee received. The President's counsel suggested witnesses he wanted called and heard by this committee. They were all called. They were all heard. The President's counsel was afforded the right to cross-examine witnesses. Now, I know that our rules finessed the words cross-examined and said question. But those of you who know of the capacities and abilities of Mr. St. Clair would certainly say that he cross-examined witnesses who appeared before this committee. What else did he do? He submitted to this committee a reply brief in addition to making an oral argument in response to all of the material which this committee had received. Now, we've heard a lot today about specificity, about our case being so general that no one would be able to answer it, that the President would not be advised of his rights, and that therefore would not be able to answer or prepare for his defense. Well, Mr. St. Clair felt that the case presented before this committee was specific enough for him to file a reply brief and to engage in oral arguments before this committee. The subpoenas. We were very reluctant to issue a subpoena to the President of the United States. But the President asked us for additional time to respond to our first subpoena. And we said, we want you, Mr. President, to have due process, so additional time is yours. And we gave him that time. Due process tripled, due process quadrupled. We did that. The President knows the case which has been heard before this committee. The President's counsel knows the case which has been heard before this committee. It is a useless argument to say that what we would do is to throw 38 or 39 books at the House and say, you find the offenses with which the President is charged, and say the same thing to the President. We talk about a report, and we say that the report will be filed along with the bill of impeachment, a resolution of impeachment. That report will be filed, and it will contain the rather detailed, specific, particularized information so that no one can question whether the President has been advised of the allegations against him.
Time of the gentlelady has expired.
Thank you.
I recognize the gentleman from Alabama, Mr. Flowers. 5 minutes.
Mr. Chairman, I think the the gentlelady from Texas makes some good points there. I have some concern, Mr. Chairman, that there might be a false impression being communicated here that this is too general, and that we might be engaging too much in our own lawyerly tendencies, and we might convince the people in this audience and in the faraway audience that 38 lawyers on one committee is simply too many lawyers. And I wouldn't necessarily disagree with that. I think one of the unwritten rules of this House and this committee is that you have to be a lawyer to be on the committee, and perhaps just straighten it out, maybe one of us ought to resign our law license so that we give a little better balance to the committee. But failing that, and I don't intend to do that at this point myself, although some of us may need to rely on that in the future more than we do now, I will just say that I'm going to try to speak, at least at this time, for the non-lawyers in the audience. And I'm not as much interested in the law as I am in the facts right now, just the facts, sir. And I'm directing this to you, Mr. Dorr, and other members of the staff that are here before us. At the appropriate time, and I want to ask right now if you're prepared to do this, because I'm interested in it, and I think the American people are interested in it. We have before us, a 2-3 page article of impeachment that the operative paragraph, as I see it, is the second paragraph that begins on June 17th, 1972, and goes down through unlawful covert activities about some 10 or 12 lines later. That's what the real charge is there against the president. But then we have something that comes under the heading, the means used to implement this policy. And we have 9 specific things, rather specific, although they do not relate to dates, times, and places. They are specific charges. You would agree with that, sir. Now, are we prepared, are you prepared, or other members of this committee prepared to itemize specifically the charges that would come under those 9 specific subparagraphs of Article 1 of the proposed Articles of Impeachment?
Mr. Congressman, I am.
Well, I think that is what I'm interested in, and I think that's really, Mr. Chairman, what we need to be talking about here. I think there's some merit to a discussion of some aspects of this, what I'd call the operative paragraph, the words that some people are having some problem with, that are the policy that we say the President made, that we've had a great deal of discussion about. But what we need more than anything else is a discussion of the facts here as they relate to the charges under this Article 1. And, Mr. Chairman, at a later time, and I hope that it will come to me or to others on this panel, that we will be able to discuss with staff here, with the various members of the committee, the specific, provable, factual items of evidence that come under each one of these subparagraph headings of Article 1, and determine for ourselves here, as I think we must, in an obvious, unorchestrated manner, if anybody's been watching our proceedings here, exactly whether the facts fit the charges. And that's the whole issue. And I find that as the more important thing than discussing whether or not the legal language, although that's something we certainly must consider, but I think that's sufficiently stated for me anyway, and it's a question of whether the facts as charged here warrant the impeachment of the President of the United States. I yield to the gentleman.
Thank you, gentlemen, for yielding. If I could just direct this question to counsel, Mr. Dorr, Mr. Jenner, and go back to the law for just a moment, to whether either of you gentlemen could tell me as to whether or not a specific allegation or charge is made by reading Article 1 of the Sarbanes substitute if it were to end after the words, and to conceal the existence of the scope of other unlawful covert activities. In other words, to simply reduce the charge to, on June 17, that agents of the committee to re-elect committed an illegal entry, and then what happened subsequent thereto, that the President, using his powers of his office, did act directly and personally through his subordinates and agents to delay, impede, obstruct the investigation. In your opinion, would that not be sufficient to place the President on notice as to the specific charge against him, and whether or not the other items listed on the 2 pages are really additions which don't have to be there but are put there for the benefit of even placing the President on more notice?
That is my opinion.
The gentleman from Alabama has expired, but counsel will be allowed to answer the question since it's important to the inquiry.
Congressman Cohen, that is my opinion. The second paragraph of the Sarbanes substitute is the operative paragraph. It puts the President on notice that the committee charges, or the article charges, that as President of the United States, he made a decision or adopted a policy that there would be a plan to cover up the Watergate affair, and that in furtherance of that policy, acting personally, individually, and also through his close associates and subordinates who did take certain steps to further this policy. And that allegation is sufficient, in my judgment, to put the President of the United States on notice as to what this committee is considering, what this article charges him with.
Mr. Chairman.
Mr. Fish is recognized for 5 minutes.
Mr. Chairman, at the outset, I want to yield to Mr. Cohen, the gentleman from Maine.
Thank you, gentleman, for yielding. Further along this line, Mr. Dorr, is it my understanding that you would be, and the staff would furnish to the House a complete and full report outlining in detail the specifics to which Ms. Jordan recently alluded to, and also whether or not, in your opinion, Mr. St. Clair would be entitled to file a bill of particulars, at which time you and this committee and the House of Representatives would furnish the specifics to Mr. St. Clair upon that request?
Well, I don't. With respect to the first question, I have no doubt that our report would do exactly that, and precisely that, and specifically that. With respect to the second, what the House might do, the House of Representatives would do with respect to requests by Mr. St. Clair prior to the time that it considered and voted on articles of impeachment would be a matter that would be within the judgment and wisdom of the House, just as the matter of Mr. St. Clair's presence here was a matter within the committee's judgment. It is not a matter of right.
But the report that we would prepare would list each and every item relied upon by this committee in its report to the full House.
Yes, it would.
I yield.
The central issue in this case is to the evidence, the weight we give to the evidence, the strength of the evidence. I hope that in just a couple of questions here addressed to Mr. Jenner that we can move on from this issue. Mr. Jenner, in your opinion, does this bill, this Article 1, the Sarbanes substitute, violate due process notice requirements?
Congressman Fish, it does not. As Mr. Dorr has stated, the first 2 paragraphs of the Sarbanes substitute state in sufficient specificity to meet all due process requirements of notice, that satisfies the Constitution in full.
So it is your view that Article 1 does put the President on the alert as to specific charges?
It does, sir, and the paragraphs following, numbers 1 through whatever the number is,
9,
afford him additional gratuitous notice so that he may be more fully placed on notice than is required.
gentleman from Alabama has expired, but counsel will be allowed to answer the question since it's important to the inquiry.
Congressman Cohen, that is my opinion. The second paragraph of the Sarbanes substitute is the operative paragraph. It puts the President on notice that the committee charges, or the article charges, that as President of the United States, he made a decision or adopted a policy that there would be a plan to cover up the Watergate affair, and that in furtherance of that policy, acting personally, individually, and also through his close associates and subordinates, he did take certain steps to further this policy. And that allegation is sufficient, in my judgment, to put the President of the United States on notice as to what this committee is considering, what this article charges him with.
Mr. Chairman?
Mr. Fish is recognized for 5 minutes.
Mr. Chairman, at the outset, I want to yield to Mr. Cohen, the gentleman from Maine.
Thank you, gentleman, for yielding. Further along this line, Mr. Dorr, is it my understanding that you would be, and the staff would furnish to the House a complete and full report outlining in detail the specifics to which Ms. Jordan recently alluded to, and also whether or not, in your opinion, Mr. St. Clair would be entitled to file a bill of particulars, at which time you and this committee and the House of Representatives would furnish the specifics to Mr. St. Clair upon that request?
Well, I don't, with respect to the first question, I have no doubt that our report would do exactly that, and precisely that, and specifically that. With respect to the second, what the House might do, the House of Representatives would do with respect to a request by Mr. St. Clair prior to the time that it considered and voted on articles of impeachment would be a matter that would be within the judgment and wisdom of the House, just as the matter of Mr. St. Clair's presence here was a matter within the committee's judgment. It is not a matter of right.
But the report that we would prepare would list each and every item relied upon by this committee in its report to the full House.
Yes, it would.
I yield.
Mr. Chairman, I could concur with the gentleman from Alabama that we should move on from this legal question to the central issue in this case is to the evidence, the weight we give to the evidence, the strength of the evidence. I hope that in just a couple of questions here addressed to Mr. Jenner that we can move on from this issue. Mr. Jenner, in your opinion, does this bill, this Article 1, the Sarbanes substitute, violate due process notice requirements?
Congressman Fish, it does not. As Mr. Dorr has stated, the first two paragraphs of the Sarbanes substitute state in sufficient specificity to meet all due process requirements of notice, and it satisfies the Constitution in full.
So it is your view that Article 1 does put the President on the alert as to specific charges?
It does, sir, and the paragraphs following, numbers 1 through whatever the number is,
9 of it,
afford him additional gratuitous notice so that he may be more fully placed on notice than is required under the Due Process Clause of the Fifth Amendment.
Now, finally, Mr. Jenner, as to going beyond the present scope of this article, is it not so that in a sui generis proceeding, such as impeachment, that you do not permit your pleading to strangle yourself with respect to evidence that you may tend?
Congressman Fish, very much so. That is the bane and trouble that prosecutors concern themselves with at all times. That over-specificity with respect to indictments, especially in modern times, and particularly as to a sui generis proceeding, which impeachment is, that they not strangle themselves with respect to admission and evidence of that which is pertinent and relevant to the basic and main issue presented on the pleading.
Thank you very much. Mr. Chair, if I have a moment left, I'll yield to Mr. Dennis.
Gentleman from Indiana.
Mr. Dorr, a moment ago, in answer to the gentleman from Alabama, Mr. Flowers, you said that you were prepared to specify here. And if that is true, I wonder why you don't do so instead of waiting till the report of the House, and whether you think that a committee report can be used for the purposes of an article of impeachment.
Well, Congressman Dennis, the reason that I'm perfectly happy and ready and willing to reply to you here now, it's my judgment that it's not appropriate to make that all of the facts, to plead all of the facts in your article of impeachment. And certainly I feel very confident legally that the report which would go to the members of the House would be adequate constitutionally to give to the House members the underlying factual basis for this article of impeachment.
Let me see if I understand you. Of course, I know you say that the article's good, but are you asserting that if the article should be faulty, that a committee report would make it a good article when it was not?
No, I'm not asserting that, but I'm asserting as positively as I know how that the article is not faulty.
Mr. Chairman, I have an amendment.
The gentleman from Arkansas, Mr. Thornton.
Thank you, Mr. Chairman. It seems to me that we are faced with the problem that confronts drafters of pleadings constantly, and that is the conflict in the requirement of trying to be specific in the details and the need to be clear and concise in stating the nature of the charges which are to be brought. In order to accomplish this, the procedure which is usually followed is to have a clear and concise statement of charges, such as the one before us, and then to supplement that with either a bill of particulars or, as has been discussed by the gentlewoman from Texas, Ms. Jordan, a report which would detail in great particular the specific language which should be used. I see no great difficulty in proceeding that way and would like to join the gentleman from New York, Mr. Fish, in suggesting that perhaps our difference is over procedural matters, are interfering with our approach to the very grave and substantive matters which we must consider. I think it is important for each member of this committee to know the detail of information which does lie behind each of the paragraphs which we have, and our counsel has indicated that he's prepared to give us that information. We've heard during the day today very specific illustrations of the detail which does lie behind some of these charges. And, Mr. Chairman, I just think that we should make every effort to get away from the problem of procedural drafting and move forward to a consideration of the substantive questions which are represented by this document. I yield back the balance of my time.
I recognize the gentlelady from New York, Ms. Holtzman, for 5 minutes.
Thank you very much, Mr. Chairman. I just briefly want to state that the debate here is whether we ought to follow the procedure that was used and developed centuries ago, or whether we, in this impeachment proceeding, will bring ourselves into the latter part of the 20th century where we find ourselves. It's true that the earlier impeachment proceedings pleaded very specific language. It's also true at that time that they were based on the general civil practice which required specific factual pleading. We abandoned that system of specific factual pleading in 1938 in our federal court system, and since that time have been operating on a notice pleading system. which has been held by courts innumerable times to supply defendants with due process of law. And I think that that's the issue here, whether we're going to bring ourselves up to date or whether we're going to discuss really a phony issue involving antique practices. I'd like to address myself, Mr. Chairman, to the substance of the article before us, and in particular the language which says, subsequent to June 17, 1972, Richard M. Nixon, using the powers of his high office, made it his policy to cover up, to conceal and protect those responsible for the Watergate break-in, and to conceal the existence and scope of unlawful covert activities. The question was raised earlier today, when did the President make this his policy? Mr. Walde has been trying to give a chronology starting from at least June 17th, and I'd like to point to the very important conversation that took place on March 21st, 1973. Now, what happened in that conversation? John Dean, counsel to the President, came to President Nixon and said, there's a cancer growing on the presidency. He said that there's been blackmail, there's been perjury, there's been cover-up, there's been obstruction of justice, hush money has been paid to buy silence, clemency has been promised to buy silence. He told this to the President, and he said to the President, I was under pretty clear instructions to investigate this, not to investigate this whole matter during the summer. I worked on a theory of containment. He told the President, I know that Magruder has perjured himself. I know that Porter has perjured himself. He also said to the President, Bob, that is Bob Haldeman, is involved in that, the hush money payments. John is involved in that, John Ehrlichman. I am involved in it. Mitchell is involved in that, and that's an obstruction of justice. And what did the President of the United States say in response? What did he say? He said, John Dean, you had the right plan. Let me say, I have no doubts about the right plan before the election, and you handled it just right. You contained it. And I think in that conversation, the President was approving what John Dean had told him about the perjury, about the blackmail, about the theory of cover-up, about the clemency. And I'd like you to explain to me, those of you who say that the President hasn't approved this and made it his policy, how that isn't so. I yield back the balance of my time.
The gentleman from Utah is recognized for 5 minutes. Mr. Owens.
Mr. Chairman, I'm going to yield my 5 minutes to the gentleman from California to continue that litany of Watergate activities that he was halfway through.
Gentleman from California is recognized for 5 minutes.
We'll continue with this story of intrigue and high drama in high government circles in America. As you recall, we last left our group of people with the President less than a week after the break-in, announcing to the public facts that in fact he knew were not true when he confirmed the statements of Mr. Ziegler and Mr. Mitchell that there were no committee for the re-election of the President people or no White House people involved in that incident when there were, and he knew it. And that was the first publicly surfaced act of cover-up on the part of the President. But very shortly thereafter, the President continued the cover-up, a cover-up that was necessary to protect that which all were most concerned about, the fact that he might lose the election in 1972 if the American people understood that the White House was involved in surreptitious entry and illegal surveillance for political intelligence and all that litany of White House horrors. So on June 23rd, another problem had arisen, and that was to keep those folks quiet who had been arrested, the 5 that had been arrested the night, Saturday night, June 17th, as well as the 2 who were across the street in the room full of electronic surveillance, Hunt and Liddy. It took money. It took money to keep them quiet. And if you didn't pay them money, they would tell. And if they told, everything would fall apart and the election of the president might be jeopardized. The first $10,000 of money we saw was delivered the night of the burglary, when Mr. Hunt went back to the White House, if you will, into his safe and took out $10,000 in cash, the only deal in cash in this operation, and delivered it on behalf of the burglars to keep them quiet. Then Dean is operating to bring about the cover-up, not to investigate, not to report, but to implement the cover-up. And Dean goes to John Mitchell of the Committee for the Re-election of the President in the period June 23rd, June 26th, somewhere in that area. He says, Mr. Mitchell, how about you folks putting up the money to bail these people out and to pay their attorney's fees? And Mitchell says, I don't want anything of it. That's your problem. It's you young fellows over in the White House that brought this idiot scheme to the fore by your plumbers, by your Hunt and your Liddy, by your break-in of the fielding office. It was not the Committee for Re-election of the President. It was Haldeman and Ehrlichman operating on behalf of the President, and the Committee for the Re-election of the President won't finance any more of your cover-up. So then Dean goes to the CIA, if you will, and he says to the CIA, look, isn't there some way you fellas, you don't have to account to Congress or to anybody, and they don't for anything, but particularly they don't for money. Can't you fellows in the CIA put up enough money to take care of the fellows that were working on behalf of the President? He said it was a national security mission. And the CIA gets all turned on usually for national security missions, but they didn't in this case. And they said, no, we're not going to put up money for burglars, no matter for whom they were working, and they didn't. So then he went back to Ehrlichman in the White House and he says, I really need money desperately. These fellows are about to blow. And he says, I need to talk to someone who can raise big money, and he went and was referred to the President's personal lawyer, Mr. Kalmbach, and his President's personal fundraiser. Now, surely it stretches credibility beyond endurance to believe that the President's personal lawyer and the President's personal fundraiser would be enlisted in this illegal scheme of raising money without having first gotten approval from the President. And I believe the inferences are abundantly clear that the President granted approval on the part of Ehrlichman to refer Dean to Kalmbach. Kalmbach came in that night, the 28th of June. Mind you, 17th of June is when the break-in happened. 11 days later, that night, he came in and raised $75,000 by nightfall and got that into the hands of the people that were buying the silence of the burglars. Now, that takes you up to the end of June, when the next act in our drama unfolds. June 30th, they call in John Mitchell and they say, John, we've got to get you out of the limelight because the press asks you questions because you're the chairman of my re-election campaign. And you know too much, John, and John knew everything. There wasn't anything John Mitchell did not know at that point about the break-in of the Democratic National Committee. And so they concocted a story, and it was concocted. We have the information on that conversation. And that story was that John and Martha were having trouble, which they probably were, and therefore that would be the excuse by which he would allege the necessity of resignation. But it was, mind you, and so portrayed as an excuse.
The time of the gentleman from Utah has expired. No, the gentleman is not recognized at this time. The gentleman from Iowa, Mr. Mizvinsky, is recognized for 5 minutes.
I'll yield 3 minutes of my time to the gentleman from California to continue his able presentation.
Well, I do want to make clear about John and Martha. I don't think we ought to leave this story.
Gentleman from California for 3 minutes.
The reason I do that is because there's no question, and the public knew it, that John Mitchell and Mrs. Mitchell were having some difficulties. Mrs. Mitchell, in fact, told him that if he didn't leave public office, she would leave him. But that was the excuse given, and in the conversation when they discussed this, they all agreed that was the excuse, because the public would understand that, and as the President said, anybody that would dare criticize a man for leaving this office because of his wife's demands, well, they just won't do that. He put it in more blunt terms. But what they really wanted to do was to get John Mitchell out of the public eye. That was cover-up. Now, I just think, you see, that through June 30th, there was just no question that there was a policy which was to protect the election of the President by concealing the involvement of White House and Committee for the Re-election people in the burglary of Watergate, because once their involvement had become known, they would go back to the Plumbers' activities involving that break-in of the psychiatrists for Dr. Ellsberg, or for Ellsberg, Dr. Fielding's office. They would go back to the forging of those cables designed to implicate John F. Kennedy in the assassination of Diem in South Vietnam. They would go back to the investigations of Senator Kennedy. They would go back to all kinds of very ugly things that were always described, mind you, as national security. That's the other key phrase you find through the cover-up scheme. When you want to keep something covered, when you don't want people to inquire, you put a label of national security on it. And they always talked about Hunt's activities being national security. Nobody's ever pointed out to one single thing Hunt has ever done that had anything to do with national security. Forging cables surely is not national security. Breaking into psychiatrists' offices isn't national security, as John Ehrlichman can clearly tell you. None of the things described by the Special Investigation Unit were really in the implementation of national security. What this plan was, right up through June 30th, was to cover up, conceal, and to keep it contained. From June 30 on, the plan evolved into much more dramatic terms, where John Dean's efforts relative to the FBI, relative to containment by coaching witnesses, relative to really raising big money to pay off the burglars. And that
has consumed 3 minutes.
Well, just let me leave the last line for the next chapter. We will go into at the next meeting the question of picking up money with gloves on because you don't want fingerprints when you're going to deliver it for a compassionate purpose.
Gentleman from Iowa has 1 minute and 45 seconds remaining.
Thank you, Mr. Chairman. I'll be very brief. I think what's interesting is we're having now the layout of the evidence. And when we listened to the debate this afternoon, I think a lot of the public may have wondered actually what's going on here, because we're supposed to be considering an article on impeachment, and it says here whether Richard Nixon has prevented, obstructed, and impeded the administration of justice. Somehow it seems that some of my colleagues have been more concerned about making a crusade out of the word specificity, as common as possibly the word Watergate. And I think it's demeaning really to the President to think that he can't understand the meaning of what's in this Sarbanes substitute. I think it's been spelled out quite well, and I think we understand the tactics as really being diversionary. And I just want to say to my colleagues, the evidence that the gentleman from California and others have pointed out is overwhelming. And I also want to say that the evidence will not go away.
The gentleman yield.
Gentleman has 10 seconds remaining.
I shall yield back the balance of my time.
The gentleman from New Jersey seeking recognition.
I am here.
Now, the gentleman from New Jersey, Mr. Sandman.
Mr. Chairman, I have an amendment in the nature of a motion to strike paragraph 1.
Gentlemen, an amendment at the clerk's desk.
Yes, sir. There are 8 amendments, and mine is number 1.
There is an amendment at the desk, Mr. Chairman.
The clerk read the amendment. Has the amendment been distributed?
Mr. Chairman, the amendment has been distributed, I understand, but it did not contain Mr. Sandman's name. Amendment by Mr. Sandman. Strike subparagraph 1 of the Sarbanes substitute.
The gentleman is recognized for 5 minutes.
I hope that we don't have to carry this on through all of these paragraphs, all 9. But it seems as though this is what we have to do to get some kind of a ruling on a law about which there should be no question. Now, at the outset, of course, my objection to paragraph 1 is that it is indefinite, as is the preamble and the first paragraph. And for this reason, it is not a legitimate article of impeachment. I may say at the outset I had wondered, after I had heard the 9 witnesses before our committee, on who the prosecutor would use as witnesses when this measure would ever get to the United States Senate, if it ever got there. And tonight I think I found out that you apparently intend to use the gentleman from California, and using him as a witness is going to be about as legal as using the evidence that he's trying to make people believe tonight. Now, back to this particular item. So much has been said about the parallel that the special prosecutor has in his job as compared to what we are doing here in our job. Now, this is an amazing set of circumstance. The special prosecutor looking into exactly the same case, but of course his a little different because crime is being charged there and impeachment on our score instead. But the special prosecutor, with a handful of people and only a fraction of the time that we've consumed, has been able to produce a theory of the case. The special prosecutor, in exactly the same case, has presented exact, precise articles of indictment. Now, why can't we do the same thing? With 105 employees, of which about half of those are lawyers. Why can't we do the same thing? It would be so easy. Why are we arguing about all of this? Everybody knows it's the only legitimate way to do this. It's a simple way. Reference to bills of particulars, reference to any other item is not the same as making the original document specific. A simple parking ticket has to be specific. It has to say what you did that violated the law. It's got to have the license of your car. It's got to have the date that you did it. You want to replace that and say that doesn't have to apply to the president? Why, this is ridiculous. And this is an altogether new ball game. You can talk about all the days and months that we've been here and St. Clair has been here, but that changes once you adopt one article of impeachment. That's a new ball game, because then it goes to the House of Representatives to decide whether or not a trial should be held in the Senate. And you know, I think the House of Representatives is entitled to a little bit of information. I think that it's altogether fitting and proper to tell them specifically what you're going to prove. I don't think they should have to listen to their TV all night tonight and find out the next chapter of Mr. Waldy's summation. I don't think that's the way this case should be tried. He cannot replace witnesses that you're unwilling to call. You cannot replace him for Mr. Hunt that you didn't want the public to hear? This is what the case is all about. Let's itemize this thing now. The House is going into a long debate. 435 people are going to have something to say about this. And they should not have to wait until the same measure gets to the United States Senate when Mr. St. Clair, for the first time, according to learned counsel, will have the right to ask for a bill of particulars. The House of Representatives doesn't have to ask for a bill of particulars. They are entitled to the particulars from the first day on. You know it, and I know it, and let's do it. This is what we should be talking about now. Now, I would like to ask counsel this simple question. You have given some pretty good, wide-searching opinions tonight, especially on paragraph 1, where you have given your blanket endorsement to that paragraph, replete with generalities, as being sufficient. I will ask you one simple question. The special prosecutor is working on exactly the same case. In fact, you want his evidence. You want his tapes. Would this be sufficient for the special prosecutor? Would it?
If this were, Mr. Sandman, if this were a conspiracy case, a criminal conspiracy case, in addition to the first paragraph, there would be a requirement under the criminal law that one overt act be done by one or more of the co-conspirators pursuant to the agreement. But the essence of a conspiracy case is an agreement. That's the essence of the conspiracy case. And the essence of this case is the President's policy. And the essence of a conspiracy case is that something is done in furtherance of the conspiracy.
Pardon me, I'm not trying to interrupt. I'm not interested in the difference between conspiracy. We are both working on the same case. I'm talking about being specific. Is the language, according to your opinion, in paragraph 1, which you said is sufficient for this case, is it also sufficient for any kind of case that the special prosecutor would bring?
Yes, I believe it is.
Oh, this is sufficient for indictment? His is an indictment.
If you bring it, you have one overt act, you have to allege one overt act.
I recognize the gentleman from Illinois, Mr. Railsback. 5 minutes.
Thank you, Mr. Chairman. Mr. Dorr, in response to a question put to you by Congressman Flowers, you indicated that it was the intention of the staff in its report to specifically document with evidence and with references to the particular subparagraphs of each article. Is that correct?
That's correct.
Will that documentary statement be submitted to us for our consideration, each individual?
Well, that's the judgment of the committee, Congressman.
Would it, if it goes into, I take it it's going to go into the report, and I take it that we have a right to either provide separate views or dissenting views or minority views?
I'm certain there's no question about that. I just
object that since this is not a matter for council to decide, this is a question of policy that has been pursued by the House of Representatives, and every member has a right to submit additional views. The views would not be the views of the staff. The views would be the views of the committee. The committee would report, and not the council. Council would not be writing the report. The report would be written by the committee.
I hope that didn't come out of my time, but I thank you for the explanation.
The gentleman is recognized for extra time.
Let me just say, Mr. Chairman, that I personally, at this point in time, think that perhaps it is a good idea to have a motion to strike on each of those counts, so those of us that are concerned about the various allegations have a right to submit our beliefs and our concerns. And this particular paragraph, which is item 1 in the Sarbanes, having to do with false and misleading information, happens to be, as everyone knows, one of my major areas of concern. In drafting your report, it would seem to me that you would want to consider a conversation that took place on March 27th, 1973, when the President instructed Ehrlichman to meet with Attorney General Kleindienst and tell him that, quote, Dean was not involved, had no prior knowledge, that neither Haldeman, Ehrlichman, or Colson had prior knowledge, but that there was a serious question being raised about Mitchell. It's my belief that this is the time they were trying to set Mitchell up. On the following day, Ehrlichman telephoned Kleindienst and executed the President's instructions. He relayed the President's assurance that there was no White House involvement in the break-in, but that said serious questions were being raised with regard to Mitchell. This happened following the famous March 21st conversation when John Dean went into some detail to involve Ehrlichman, Haldeman, himself, Magruder, and Porter. Then I think I would go to the series of events that took place in mid-April, which was after John Dean decided to blow the whistle on April 8th, followed by Magruder on April 13th, followed by LaRue on, I think, the 14th when he said the jig was up, and then finally Silbert called Henry Peterson. Peterson, in turn, got in touch with the Attorney General Kleindienst. Kleindienst, in turn, with the President, and meetings were arranged between Henry Peterson and the President. The President met with Henry Peterson on April 16th, 1973, from 1:39 to 3:25. At this meeting, the President promised to treat as confidential any information disclosed by Peterson to the President. This was at a time that Kleindienst had decided to recuse himself. In other words, because of his close association with John Mitchell and others, he decided it was not proper for him to lead the Watergate investigation, and this job was assigned to Henry Peterson. The President emphasized to Peterson that you're talking only to me, and there's not going to be anybody else on the White House staff. In other words, I'm acting consul and everything else. The President suggested that the only explanation might be Dick Moore. When Peterson expressed some reservation about information being disclosed to Moore, the President said, let's just better keep it with me. At that meeting, Peterson supplied the President with a memorandum, which he had requested on April 15th, the day before, summarizing the existing evidence that implicated Haldeman, Ehrlichman, and Strawn. Then there was a telephone conversation later that same day, April 16th. And in my opinion, this is even more clear. The President, when talking to Peterson, asked him if there were any new developments that he should know about. And he reassured Peterson, quote, of course, as you know, anything you tell me, as I think I told you earlier, will not be passed on because I know the rules of the grand jury. Peterson then recounted to the President the developments of that day in the Watergate investigation. The following morning, on April 17th, the President met with Haldeman, somebody who had been implicated both by Dean on March 21st and also implicated by Henry Peterson. Early in the meeting, the President relayed Dean's disclosures, which had been given to him by Henry Peterson, the special prosecutor. The President also told Haldeman that the money issue was critical. Another thing, and I quote, another thing, if you could get John and yourself, referring to John Ehrlichman, in my opinion, to sit down and do some hard thinking about what kind of strategy you are going to have with the money. You know what I mean.
Time of the gentleman from Illinois has expired. The gentleman from Alabama.
Chairman, I would yield my time to the gentleman from Illinois if he needs any more time there.
I appreciate.
The gentleman from Illinois is recognized for the. Does he yield in 5 minutes?
I'd yield 3 minutes to the gentleman from Illinois, and I want to reserve 2 minutes to ask some questions of counsel.
Gentleman is recognized for 3 minutes.
I thank the gentleman for yielding. In addition to that particular statement by the President, then there was some material deleted, and then the conversation picked up and it went to Calmback. And in this particular case, the transcript shows, this is the President's own edited transcript, shows that the President instructed Haldeman to call Calmback to attempt to learn what Dean and Calmback were going to say Dean had told Callenbach regarding the purposes of the fundraising. In addition, the President instructed Haldeman, well, be sure that Callenbach is at least aware of this, that LaRue has talked very freely. This is the man, these statements that involve Henry Peterson were between the President and the man that was really in charge of the Watergate investigation. Then on April 20, I believe it was 25th and 26th, the President instructed John Haldeman, a man who had been implicated by John Dean on March 21st, to get a hold of certain tape conversations that took place in February and in March, and Haldeman carried out his responsibilities and reported to the President. On April 26th, he met with the President for 5 hours and reported to the President of the United States about what he had heard on those tapes. This committee has subpoenaed that 5-hour tape conversation, and this is one of the tapes that we have not been able to get our hands on. Then on, I think it was April 27th, the President again met with Henry Peterson. Henry Peterson at this point indicated that Dean's attorneys were threatening to implicate the White House. The President assumed that it meant him as well. And that's when he referred, and this is also in the edited transcripts, the President said the only thing he could be referring to is that famous March 21st conversation, and he did not tell Henry Peterson that he had had Haldeman listening to the tape. He didn't tell him there was a tape, and this was just the day before. But what did he do? He told him that they had talked about hush money, $120,000, and I think that his final quote was that he had turned it off totally. Mr. Dorr, if you want to get into false and misleading statements, I can't think of a better place to begin, and I feel so strongly about this particular aspect of the whole Watergate incident that I would just refer your attention to those conversations.
I would ask counsel if this is the kind of evidence that counsel would have put under this subheading. Is this the kind of evidence that falls into this place in the article?
This is the proof, yes, that we would offer.
Do you have any further items that Mr. Railsback has not mentioned?
Well, we have the item that Congressman Waldy mentioned about the President's statement on June 22nd, following the statement by John Mitchell on the 20th of June. And
to whom was that statement made?
To whom was what statement made?
The June 22nd statement.
It was made in reply to a question at a press conference.
Well, that wouldn't fall under this heading, though. False and misleading statements.
That's true. Excuse me.
Well, I ask again: are there any further items?
Yes, there is. There is one other statement. That was, well, I believe that this one falls under the next paragraph because this relates to information to the President with respect to a statement that one of his subordinates made to officials of the Department of Justice.
Well, the items Mr. Railsback mentioned, which he centers on the dealings with Assistant Attorney General Peterson, it's your purpose then that these items of information would fall under the first subparagraph there. Is that correct?
That is correct. And I would also say, Mr. Congressman, that the statements were made by Gordon Strawn to the FBI, to the Department of Justice in connection with their investigation in furtherance of the plan.
Mr. Strawn was Mr. Haldeman's assistant.
Yes, would be some of the proof under this paragraph.
Thank you. I yield to the gentleman from Maine.
The time of the gentleman from Alabama has expired. I recognize the gentleman from Michigan, Mr. Conyers, for 5 minutes.
I rise in opposition to this motion to strike, and I think we've had a good number of hours here on the debate about whether these pleadings are detailed enough. I think we've examined counsel searchingly. We've exchanged our views. I'm going to call for the previous question, I think the time to, unless there are other members that feel very strongly about this, I see, well, then I'll withhold the previous question, but it seems to me that it's about time for us to consider the first vote of these proceedings. I don't know how many hours we're going to have to spend to determine whether or not we're going to observe the notice pleading of the federal rules that have been in existence throughout the country since 1938. Now, if we're going to insist upon drawing an impeachment proceeding based on the last one from 1868, I think that after we've examined the counsel, we've established the facts, we've made it very, very definite now that there are two views here, and I presume that there's nothing left to do but for us to vote this out. Now, might I inquire, Mr. Chairman, is it possible for us to begin to consider setting some kind of time to close debate to vote on these? I understand there are a number of these motions to strike reaching to some 9 of the sections within the Sarbanes substitute, and I'm very anxious that we resolve this after we've examined it. We've been examining it for several hours. Yes, I'll yield to my friend from New York.
I thank the gentleman for yielding, because the author of the motion to strike gives me a little problem in that he never directed himself as to whether or not he is saying that the President did not give false and misleading statements. I don't know whether the motion to strike is merely a parliamentary maneuver, but if it is a question that the gentleman has as to which authorized officers, employees of the United States that the President lied to, then we are prepared to tell you the names and the dates of what federal officials the President lied to. If you're having problem with the language as to whether it was a Capitol policeman or whether it was someone that worked in the printing office, if it's a language problem you have, then I can understand why you raised the motion to strike. But if you're talking about the Attorney General, the Acting Attorney General, if you're talking about anybody that was involved, Silbert's office, if you're talking about grand jury testimony, if you're talking about anything to prevent his close associates from getting indicted, then the President lied. And we can only refer to the President's statements as to what he said. What he said to Mr. Haldeman to tell him that everybody that Dean said was not involved, he said, say they're not involved. I mean, if they were involved. He said, lie and tell them something different, so that if the motion to strike is just to take time, then of course, I can understand the gentleman from New Jersey's dilemma. It is a bad night. If, on the other hand, the gentleman really wants to find the names of the people that the President lied to, counsel can give you the names, and then we can move on to your next motion to strike.
Would you be kind enough to yield?
For yielding. It's not my time, but
well, whoever's time it is, you mentioned my name. Can I answer?
I have the time, and I would like to say that it's very, very clear to us that there are two views. They've been thoroughly debated. Some of us would like to keep our pleadings consistent with the 20th century. Others of us would prefer them, for reasons real or imagined, to keep them back into the Johnson
gentleman from Michigan yield so that I can answer the gentleman from New York?
Yes, I'd be happy to yield.
All right, it's going to be very short, really. I objected because I had to object, because I have never been permitted, under the procedure that we're following, to get some kind of a ruling as to what the law is here. I submit, and it's undisputed to me, and I don't care what anybody else says. The thing here is very clear. It should be specific. Now, you have all this information that you can give to people. Why can't you at least give simple sentences that are concise and do it the right way?
I'm not going to yield any further
question.
To the gentleman.
Speak, Charles. Speak, Charles, speak.
Mr. Chairman.
Committee will be in order in believe that it's in order at this time to state that the view of one member does not express what is actually the law or the policy of this committee, the House of Representatives. I would hope that the members would recognize that the chair presides and the chair has attempted to be fair in recognizing each member, and at such time as the chair recognizes those members, I think that those members should speak out. And until then, I would hope that we would keep order and we would be true to the trust that we have, and I don't mean to lecture in any way, but I think that this is serious enough that indulging in parliamentary maneuvers to delay a decision on this very important question only, I think, serves to tell the people that we're afraid to meet the issue. And I would hope that we do have, as we said we have, the courage of our convictions. And to the gentleman from New Jersey directly, Mr. Sandman, I would state that while Mr. Dorr may not have expressly stated what the policy is in setting forth specifications, I don't believe that the gentleman at this time is prepared to state that he is going to say what the Constitution is when the Constitution for so many years has spoken clearly and the presidents have spoken clearly on the matter of what is established policy. And I think that if we get on with the business of the day, and whereas there have been questions raised as to what the facts are, there are men on this side and on the side of the minority who are prepared to speak to the facts. And I think that that's what we ought to be doing.
Mr. Chairman, do I have any time remaining?
No, but I'm prepared to ask what members would like to be recognized on the amendment offered by the gentleman from New Jersey, Mr. Sandman. It's the chair's assumption that everyone wants to speak on the amendment.
Good. What about a motion to table?
There are 20 members who seek recognition, and I hope the chair would state that we can, and I think that with 40 minutes of time, which would give 2 minutes to each member, I think if the chair feels that that ought to be sufficient time, unless some member is ready to object, then I... Objection?
I move it.
Well, the chair is prepared to recognize the members 5 minutes each, if that's what they seek to do. Yes, that is the rule. I'll recognize those members who have spoken, of course, on the motion to strike will not be recognized. They have had their time. I recognize Mr. Wiggins for 5 minutes.
Thank you, Mr. Chairman, for recognizing me. I think it's not inappropriate, Mr. Chairman and ladies and gentlemen of the committee, to once again put this matter back in focus. We started many hours ago with agreement that the indictment in this case, the articles, must be sufficiently certain to put the respondent, the President of the United States, on notice of the charges against him so that he could have an opportunity to prepare an adequate defense. This is not a novel notion, Mr. Chairman. The Constitution of the United States requires it. And all members surely agree with that as a correct statement of constitutional law. Well, faced with that, Mr. Chairman, we started a long time ago to try to decide the question of this matter of policy. You recall that the operative language in Article 1 says that the President made it a matter of his policy. And the question naturally occurred, when did that policy come into effect? We debated it, perhaps we're still debating it, for several hours. And I submit, Mr. Chairman, that there is no consensus in this committee now that there is clear and convincing evidence as to when in the world that policy came into effect. It is still an ambiguous, confused situation, and yet we have passed it. We now have moved to sub 1. That subparagraph states the following: making false or misleading statements to lawfully authorized investigative officers and employees of the United States. The person allegedly making those statements is the President of the United States. Now, Mr. Chairman, we can duck the issue now, but everybody here knows that if we adopt such imprecise language, that there will come a time when a bill of particulars is demanded. And we're going to have to flesh out this allegation with such rather simple questions as what statements are we talking about? In what form were the statements made? Who are the investigating officers, and were they acting in their capacity as investigating officers when they received the statements in whatever form we are talking about? That's a rather important consideration, Mr. Chairman, in view of a recent decision by Judge Gazelle, a rather famous trial judge in this city, because in interpreting a section of the Penal Code involving the making of false and misleading statements to lawfully authorized investigative officers, he said they had to be under oath, and they had to be transcribed. Now, that seems to be the rule with respect to everybody else, but we know that in this case, there are no such transcribed under oath statements by the President of the United States to any official who was then and there acting in an investigative capacity. Many of these statements are allegedly made to Mr. Peterson, but Mr. Peterson told us, and this is his word, that when he talked to the President, he was not acting as an investigative official, but was reporting to the President of the United States. In due course, if anyone doubts that, I'll refer you to the transcript. But it's possible, Mr. Chairman, that some false statements may have been made. My friend Mr. Railsback is concerned that the President did not accurately state his knowledge when he reported the state of Dean's involvement and Haldeman's involvement and Ehrlichman's involvement on the 27th of March. Well, I want you to listen to a few words in terms of whether or not that conclusion by my friend here is justified. On the 21st day of March, Mr. Dean said this to the President, and you'll remember these words: I honestly believe that no one over here knew, meaning about Watergate. I know that as God as my maker, he said, I had no knowledge that they were going to do this. And on the 27th day of March, this is what the President said as representative of his knowledge at that time. I have not really had from Mitchell, but I have had from Haldeman, I have had from Ehrlichman, I have had from Colson cold, flat denials. I have asked each of you to tell me, and also Dean. Now, the President, therefore, has not lied on this thing. The question is, did he do so? Notwithstanding that statement made in confidence by the President on the 27th day of March, a day that disturbs my friend, in confidence at a time when he had no notion at all that those remarks would ever see the light of day. I'm also concerned, Mr. Chairman, about this almost scurrilous charge that the President of the United States lied to the American people, not incidentally to an investigator, lied to the American people as a result of a press conference. This has been characterized by my friend Mr. Waldy in his continuing fable in this case, and I don't mean that too derogatory, Jerry. I think you're rather exaggerating as to the facts. But this is what happened on the 22nd of June and is the basis of the allegation that the President then and there entered into a corrupt conspiracy to obstruct justice. It was a press conference. It's very short. A question was asked of the President. This is the question. Mr. O'Brien has said that the people who bugged his headquarters had a direct link to the White House. Have you any sort of investigation made to determine whether this is true? The President said, Mr. Ziegler and also Mr. Mitchell, speaking for the campaign committee.
Time of the gentleman. California has expired. I recognize the gentleman from California, Mr. Waldy.
Mr. Chairman, I yield 30 seconds to my good friend and my able colleague, Mr. Wiggins, to complete the statement of the President at the press conference.
Thank you, Mr. Waldy. I'll pick up with the President's answer. Mr. Ziegler and also Mr. Mitchell, speaking for the campaign committee, have responded to questions on this, meaning the Watergate break-in and White House involvement, on this in great detail. They have stated my position and have also stated the facts accurately. That's what bothers my friend. This kind of activity, as Mr. Ziegler has indicated, has no place whatever in our electoral process or in our governmental process. And as Mr. Ziegler has stated, the White House has had no involvement whatever in this particular incident. Well, now I've completed it, but I think I ought to observe that Mr. Liddy and Mr. Hunt, those involved, were not in the White House.
How about observing that on your time?
I shall.
I want to, Mr. Chairman, continue with my interrupted narrative, and not because I think the points I'm making are necessarily the most important points of this case, but I think an understanding of the skeleton outlines of the case is necessary. I've covered June 17th, the date of the burglary, through June 30th, the resignation of John Mitchell. And now I want to cover July 1st through September 15th, which is the summer and early fall of that year, the next phase of the cover-up. During that period of time, these events occurred which bear upon the conclusion as to what did the President know and when did he know it and what did he do. On July 5th, 5 days after the former Attorney General, the campaign manager of the President, Mr. Mitchell, had resigned his chairmanship, he was interviewed by the Federal Bureau of Investigation, and he denied knowledge of any information on the break-in. He later said, well, he had been told a few things, but he really didn't believe they were probably true. We know that isn't so. He knew a great deal, and he misrepresented his information to the Federal Bureau of Investigation. On July 19th and 20th, Mr. Porter and Mr. Magruder falsely told FBI agents, these are gentlemen employed by the committee to re-elect the President, that funds that had been paid Liddy, one of the indicted Watergate burglars, who was employed as general counsel by the Committee for Re-election of the President and had been formerly employed by the White House involved in the Plumbers Group, that the funds paid Mr. Liddy were for legal political intelligence gathering and not for illicit electronic surveillance or surreptitious entry. He lied when he told the FBI agents that. On August 10th, Mr. Porter perjured himself by lying before the grand jury on the same story. On August 18th, Mr. Magruder testified falsely to the grand jury. On August 28th, Mr. Krogh, who was the head of the plumbers, this group that was so involved in surreptitious entry throughout the Nixon administration, testified falsely as to the activities of Mr. Liddy and Mr. Hunt when they were employees of the White House before Watergate. And on August 29th, the President made another misstatement to the nation when he said that he had had a Dean report which had been a complete investigation of Watergate and there was no White House personnel involved. In fact, there was no Dean report, and there clearly was no investigation because Dean's obligation and assignment was to contain, not to investigate, but to cover, not to disclose. And the President knew that. He had never met Dean on August 29 when he told the nation to lull them into complacency that he was attempting to get to the bottom of this problem. He never told them that he had never met this gentleman that had conducted this so-called report, and that in fact he had never received the report because there was no report, never has been, and to this day there is not a Dean report. Then on September 12th, Mr. Magruder testified falsely about the purpose of a meeting with Mitchell, Magruder, Dean, and Liddy, in which the genesis of the group that broke into the Watergate was first described, and political intelligence with surreptitious entry and bugging was discussed. And then finally on September 15th, the first phase was successfully accomplished of containment. They held the risk and the exposure to the 5 burglars that were arrested on the premises and to Hunt and Liddy. The risk and the exposure was contained. And the President on September 15th, that very day, met Mr. Dean for the first time and was complimentary to him, complimented him on doing such a good job in containing this risk to just those 7 people. It did not get beyond those 5 burglars and Mr. Hunt and Liddy, and that was an enormous accomplishment. And the President's language and Mr. Dean's language is instructive. The President said, well, you had quite a day today, didn't you? You got Watergate on the way.
Time of the gentleman has expired. Recognize the gentleman from Illinois, Mr. McClory.
Thank you, Mr. Chairman. I think in the context of this article that the paragraph 1 is inadequate. This article is in the nature of a criminal indictment. It has it in essence is a criminal conspiracy which is being charged under the designation of a policy. It also, of course, includes the charge of obstruction of justice and other criminal offense. And it seems to me that in that respect, it should be specific. From the standpoint of the proposed Article 2 that I expect us to consider later, and relating primarily to the President's obligation, his constitutional responsibility to see to the faithful execution of the laws, it seems to me that such an allegation might take on a different posture. And therefore, I'm going to join in the motion to strike this language in this article, notwithstanding that I may find that this language is appropriate in another article which we may consider. Now, I'd be happy this time to yield the balance of my time to the gentleman from, any gentleman who'd like me to yield to him, the gentleman from Indiana, Mr. Dennis.
Mr. Chairman, I have some time of my own, I think, but I'm grateful to my friend from Illinois to adding to it. Mr. Chairman, I would suggest that the distance we're in danger of departing from the law and the Constitution and descending into impeachment politics here this evening is possibly illustrated best by some of the rather startling propositions I've heard advanced during the course of the debate from people whom I really don't think ordinarily would have advanced them. For instance, it's been suggested in effect that statements in a committee report can be used to cure an article of impeachment which is fatally defective because it's too indefinite and vague. At one point in the debate, the statement was made that you didn't really need to worry much about the rules of evidence because they didn't apply in a trial before the United States Senate with the Chief Justice presiding. Then we've heard several times, in effect, that due process of law is outmoded. We're now in the 20th century. You got notice pleading. Now, everybody knows that, or I thought everybody knew, that an impeachment proceeding is at least quasi-criminal. I didn't know that was a matter of dispute. It's condign punishment. And as Mr. Jenner and I agreed here a while back, Rule 7 of the criminal rules still applies. And it says the indictment or the information shall be a plain, concise, and definite written statement of the essential facts constituting the offense charged. Now, that's not notice pleading. There's nothing outmoded about it. You're entitled. Anybody's entitled. I know a little bit about a few things, and one of them is criminal law. And you're entitled to be notified of the defense charge. And you're entitled to be notified in the charge. You want some 20th century up-to-date law, let me give you a little more. Whoever commits an action which the law declares to be punishable or which is deserving of punishment according to the fundamental idea of a penal law and the sound perception of the people shall be punished. If no determinate penal law is directly applicable to the action, it shall be punished according to the law, the basic idea of which fits it best. Doesn't that sound a lot like some of the propositions we've heard advanced around here today? And it's good 20th century law. It's part of the Nazi penal code from Hitler's Germany. Now, you know, really, we didn't have to be arguing this all day and all night. This is a very, very simple proposition. All you have to do, not plead 12 books of evidence, you just say, making false and misleading statements to lawfully authorized intelligence or investigative officers in that on a such and such day he said the following to so and so. Now, Mr. Railsback's given us a long laundry list. He says, I think they're disputable. Mr. Wiggins has disputed a couple of them very well. When the time comes, that can be done. But why don't we list them? And since we aren't going to list them, and since obviously, for some reason, we better just strike this thing out as the gentleman suggests. So I support the motion.
The gentleman has 5 more minutes. The gentleman has his own 5 minutes.
Well, in that case, Mr. Chairman, you almost scared me to death, but I'm glad to know that I've still got 5 more minutes, and I'll take a little more time. You ought to specify here. But as I was about to say, since we obviously are not going to specify, in spite of the great knowledge of these gentlemen and their stated readiness to specify, I'm going to leave it the way it is. It doesn't say anything. And according to their theory, the operative part's up above here in paragraph 2, and you don't need it anyway. So out it ought to go. This is a good motion under the circumstances. Now, Mr. Chairman, I'll yield a couple of minutes of my time to the gentleman from California, Mr. Wiggins, and reserve the balance for the moment.
Thank my colleague for yielding.
Gentleman has 4 minutes remaining.
I just want to conclude 2 points that I did not conclude when I had the time. That press conference has been criticized as a statement by the President of the United States lying to the American people. because he said there was no White House involvement. Now, the only involvement at that time known to the President, possibly attributable to the White House, was Mr. Hunt. We all understand that Mr. Liddy did not work for the White House, and the facts are that Mr. Hunt did not work for the White House either. Now, I know that there has been some dispute in the evidence as to that, but the weight of the evidence, and if we're going to go by any standard of clear and convincing, the clear and convincing evidence is that he in fact worked for the committee to re-elect. I want to pass from that to one final observation which disturbs my friend from Illinois. Unfortunately, he's not here, but he contended that Mr. Ehrlichman lied to the Attorney General about the lack of involvement of Mr. Dean and Mr. Haldeman and himself when he reported to the Attorney General in a telephone conversation on the 28th. I have before me exactly what he said to the Attorney General, and he said it in the presence of the President of the United States. This is what Mr. Ehrlichman said. Okay, now, the President said for me to say this to you. The best information he had, and it is that neither Dean, nor Haldeman, nor Colson, nor I, nor anybody in the White House had any prior knowledge of the burglary. He said that he's counting on you to provide him with any information to the contrary if it ever turns up, and you just contact him direct. Now, as far as the committee to re-elect is concerned, he said that serious questions are being raised with regard to Mitchell, and he would likewise want you to communicate to him any evidence or inferences from evidence on that subject. Now the question is, did he lie to Mr. Kleinding when he said that? You recall what I testified to just a few moments ago when the President said that he had cold, flat denials from these people that they were not involved, and that Dean told him, as God as his witness, he was not involved. That's precisely the information the President relayed to Mr. Kleinding, the Attorney General, and I ask you, did the President lie on that occasion? Did he even mislead on that occasion? The answer is no, he did not. I'll yield. It's not my time to yield. The time is yours, Mr. Dennis. No, that's all the points I want to make.
Mr. Chairman, I reserve my time.
The gentleman will either use his time now or cannot reserve his time. He has 1 minute remaining.
Well, I'll yield Mr. Cohen half of my minute.
Thank you, gentlemen, for yielding.
Mr. Cohen is recognized for 30 seconds.
I'd like to address a question to the gentleman from California about the President's statements to the Assistant Attorney General, Mr. Peterson, and ask his opinion as to whether or not, after having read all of the transcripts and all of the information presented by this committee, as to whether or not the President was correctly stating the facts when he told Mr. Peterson to stay away from the Ellsberg matter, the break-in, because that was a matter of national security.
Without equivocation, that was indeed a national security matter, and the overwhelming evidence is that this entire operation had national security overtones.
The matter for which Mr. Colson has pled guilty.
I don't yield it anymore. I'll say, if the gentleman thinks those are false, write them in here, and we'll find out.
The gentleman does.
Time of the gentleman from Indiana has expired. The gentleman from Maryland, Mr. Sarbanes, is recognized for 5 minutes.
Mr. Chairman, I had not intended to speak because the hour is getting late, and I think it's necessary for this committee to move on and begin to consider these amendments, and that we not delay inordinately in beginning to reach a resolution of this very grave matter. But some things have been stated that really have just almost forced me to try to respond. I agree with the gentleman from Indiana when he says it's very important not to perhaps in our excitement and concern, to stray from a careful statement of what it is we're trying to express in this matter. And I see he's left the room, and I regret that, but I intend to go on and make the points. Now, the gentleman from Indiana stated that earlier this evening it was said that due process of law was outmoded. No one said that here. The gentlelady from Texas made a very eloquent statement, not only for the need for due process, but why it had been met, why the standards that this committee had followed had met the very highest test of due process. Secondly, the gentleman said that it had been stated in the course of the discussion here that a defective article can be cured by a committee report. No one said that. No one said that. What was said was that the article was not defective, that the article was valid, that this was a good article. In fact, it was stated in response to a question from the gentleman from Maine that the article went further than was necessary in providing additional notice material for the President, and that the report would then supplement the article. So that was not stated in the course of this discussion. Then it was asserted that someone in the course of this discussion said that the rules of evidence do not apply in the Senate. That was not asserted. What was stated was that in the previous proceedings, the Chief Justice has ruled on questions of evidence and that the Senate has the authority to overrule him, and that the Senate does not necessarily have to follow the same strict rules of evidence that would apply in a court of law. The Senate is sitting in an impeachment trial and is seeking the truth, seeking to determine what is best for the country. So I suggest that none of those sweeping statements were made. And while a debate is important, I think it's critical not to misstate what has come earlier. We can differ, but I think we ought to recognize what has previously been said. Now let me address myself to one other point that was made with respect to the President's statement on the 22nd of June. In that statement, the President said that he endorsed what John Mitchell had earlier stated. And John Mitchell had earlier stated that there was no involvement either at the committee to re-elect or of anyone else involved. That was Mitchell's statement. The President endorsed the truth of that statement, and that was read, of course, by the gentleman from California. Now, the gentleman from California also referred to Mr. Hunt and said that Mr. Hunt had no connection, although it had been asserted. The fact of the matter is that a very good case can be made that Mr. Hunt indeed still had a continuing connection with the White House. That is in dispute, but look at what happened subsequent to that date. Hunt's employment records at the White House were falsified in order to indicate through a memo, in order to indicate that Hunt had left the employment on the 31st of March and was not still a consultant to the White House on the 17th of June. Telephone books used in the White House and the Executive Office building as of immediately after the 17th of June, which contained in them Howard Hunt's name and his telephone number, were immediately recalled, brought back from all offices, and that page with Hunt's name and number on it was removed from that book and another page substituted. Hunt's safe in an office in the Executive Office building of which he had made use was drilled into, and the contents of that safe were removed. And finally, Hunt was given instructions to leave the country, which were subsequently countermanded, but Hunt was given instructions to leave the country. Now, all four of these things happened immediately afterwards. Now, the gentleman from California can contend that he had no connection, but I suggest to him that there are facts to the contrary which indicate that he may well have had a connection. And in any event, it seems to me important in that instance and in the earlier matters that these things be stated precisely and accurately so that the differences that are between us are accurately perceived by the people.
The time of the gentleman from Maryland has expired. Mr. Hogan.
Thank you, Mr. Chairman. I think that while we were on our good behavior yesterday, we are back to the normal procedures that we've been engaged in behind closed doors for the last several weeks. which ought to effectively explode the myth that there's been a totally nonpartisan air to all these hearings. And I think that's unfortunate. I was not aware when we started the television of these proceedings that we were intending to duplicate the 10 weeks of evidentiary hearings that we had. I do think that we have in many ways done a disservice to ourselves and the American people today. We have members relating narratives that are embellished and filtered through the prism of their own partisan bias, and we have them and others call it evidence. It's not evidence. Mr. Waldy's narrative, while it might be suitable for a scandal magazine or a speech to his constituents, I think it's totally inappropriate here. His statements have had inaccuracies, embellishments, frivolities, irrelevancies, and allegations that are not substantiated by the evidence. We should address ourselves in these proceedings, it seems to me, to the factual evidence which is supportive of the articles of impeachment which we are debating. We don't need humor. Our role is not here to entertain the American people, but to address ourselves to the constitutional responsibilities that we told everyone last night we were so awed with. Now, I opposed the motion to strike, and we've been belaboring the same point so many times over and over, where Mr. Wiggins continues to call what we're about an indictment. It is not an indictment. We are not involved in a criminal procedure, and we should recognize that and stop deluding ourselves. I'm disappointed in some of my colleagues. When Mr. Waldy talks about Mitchell lied and Krogh and Magruder and Porter perjured themselves, they are not the subjects of this impeachment. When he says the president knew full well that White House people were involved before a certain point in time, this is not supported in the record. When Congressman Drinan says that Stans was interviewed in his office and not before the grand jury, and he called this a compromising procedure, that's not the case. And the Justice Department and Mr. Stans are not the subject of this impeachment. It is not even unique or unusual for people of prominence to be interviewed outside the grand jury. And I remind the gentleman from Massachusetts that another distinguished gentleman whom I revere from his home state, former Speaker John McCormick, was not required to go before the grand jury when the investigation and prosecution of his own staff aides was involved. He testified before the Department of Justice as Mr. Stans did. I will not yield at this point. And my good friend and colleague from Maryland, while he is generally very calm and dispassionate and logical, and I think has done an outstanding job today in defending his substitute, even he has fallen into this trap. We all feel so strongly about these things, we have a hard time keeping our natural propensities in check. He was reading from the transcript where he made a parenthetical remark where he got to the point where the president says to Dean, "Well, you had quite a day today, didn't you? You got Watergate on the way, huh?" And then Dean says, "Quite a 3 months." And then he made a parenthetical remark and said, "That, incidentally, wasn't in the White House transcript." Now, the implication of that is that there was deception on the part of the White House in leaving that statement out. During the interim of the recess, I had checked to see what Mr. Jaworski's transcript, the special Watergate prosecutor, had. And for Dean's statement there, they have inaudible 3 months, which is not what we have in ours. The next sentence we have, "How did it all end up?" And Mr. Jaworski's transcript says, "How did this all end up?" Now, these are not consequential, but when we give the implication that the White House, without any substantiated proof, has tried to fabricate the transcripts, when we ourselves have transcripts that are not the same as Mr. Jaworski's or the White House, I think we're just confusing the issue for ourselves and the American people. I hope that when we return tomorrow, we will all try to rediscipline ourselves and focus in on the articles themselves, which are under debate, and not try to propagandize this, because I think by doing so, we're doing a disservice to these proceedings. And now I'll yield to the gentleman from Massachusetts.
Thank you very much for yielding. in early August 1972, the President himself asked Mr. Ehrlichman to arrange that Mr. Stans not be compelled to go before the grand jury. What I said about Mr. Stans is totally irrelevant to this inquiry because it was the President of the United States himself who asked that Mr. Stans be given this unusual situation. I yield back to Mr. Hogan. Thank you.
The point that I'm trying to make, and I would again remind the gentleman from Massachusetts, that there is nothing unique or unusual about that. It is totally proper for a man of Mr. Stans' prominence and the position he played at that time to testify under oath, as he did, before in the offices of the Department of Justice. He was put under oath. And there is not anything more improper about that than there was for exactly the same procedure that was done for former Speaker McCormick of the Gentleman's State. And I yield to the gentleman from Mississippi.
Since we are going to talk about the facts, I'd like to make this one point before we go any further. I think Mr. Flowers brought it out and it's been passed over. All of us have been speaking to this press conference of the 22nd, talking about the President's public statement. Mr. Wiggins spoke to it, Mr. Sarbanes. I think the important point is that this first section says making false and misleading statements to lawfully authorized investigative officers and employees of the United States. I think Mr. Doar said that this particular date and statement would not be applicable to that section. Is that correct, Mr. Doar? So the point is the very first argument made in support of this section, in fact, is not applicable. Thank you for yielding.
All right. Recognize the gentleman from California, Mr. Danielson. 5 minutes.
Thank you, Mr. Chairman. We've been re-arguing evidence and facts all day, and the evidence closed on Wednesday of last week. I suggest that we get back to discussing the pleadings. Number two, I wish to make it clear in the record that I do not concur with the opinion of my colleague from California, Mr. Wiggins, on constitutional law as it applies to impeachment proceedings. I yield to my colleague from California, Mr. Edwards.
Take long. This is a very simple Section 1, making false or misleading statements to lawfully authorized investigative officers and employees of the United States. The gentleman from Illinois, Mr. Railsback, has provided us definite information, time, chapter and verse, and in depth, some very definite testimony about where the President made the false statements to a lawfully authorized investigative officer, the head of the criminal division of the Department of Justice, Mr. Henry Peterson, and in addition to that, false statements made by the President to Attorney General Kleindienst. Mr. Wiggins says this doesn't count because Judge Gesell made some sort of a ruling the other day in a criminal proceeding, and I'm sure Mr. Wiggins really didn't mean that to apply to this case. We are certainly not dealing in a criminal proceeding. I really don't know what more, Mr. Chairman, we're supposed to do with this modest section. It seems to me that we have provided the information, the evidence to comply with it, and I think we ought to move along.
Which is cut out for us to vote on some articles of impeachment. I submit that we should quit setting up straw men and knocking them down, and I yield back to the chair the balance of my time.
Recognize the gentleman from Maine, Mr. Cohen.
Thank you, Mr. Chairman. I didn't realize I was seeking recognition, but I'm glad to accept it. I would simply like to follow up on a point just made by the gentleman from California, Mr. Edwards, in terms of what the duty of the President of the United States is and what the nature of these proceedings are. Because we've heard this time after time, all day long, placed in the category of a criminal proceeding. It seems to me, last evening, yesterday, we talked
of 3 months. And then he made a parenthetical remark and said that, incidentally, wasn't in the White House transcript. Now, the implication of that is that there was deception on the part of the White House in leaving that statement out. During the interim of the recess, I had checked to see what Mr. Jaworski's transcript, the special Watergate prosecutor, had. And for Dean's statement there, they have inaudible 3 months, which is not what we have in ours. The next sentence we have, how did it all end up? And Mr. Jaworski's transcript says, how did this all end up? Now, these are not consequential, but when we give the implication that the White House, without any substantiated proof, has tried to fabricate the transcripts, when we ourselves have transcripts that are not the same as Mr. Jaworski's or the White House, I think we're just confusing the issue for ourselves and the American people. I hope that when we return tomorrow, we will all try to rediscipline ourselves and focus in on the articles themselves, which are under debate, and not try to propagandize this, because I think by doing so, we're doing a disservice to these proceedings. And now I'll yield to the gentleman from Massachusetts.
Thank you very much for yielding. In early August 1972, the President himself asked Mr. Ehrlichman to arrange that Mr. Stans not be compelled to go before the grand jury. What I said about Mr. Stans is totally irrelevant to this inquiry, because it was the President of the United States himself who asked that Mr. Stans be given this unusual situation. I yield back to Mr. Hogan. Thank you.
The point that I'm trying to make, and I would again remind the gentleman from Massachusetts, that there is nothing unique or unusual about that. It is totally proper for a man of Mr. Stans' prominence and the position he played at that time to testify under oath, as he did, before in the offices of the Department of Justice. He was put under oath. And there is not anything more improper about that than there was for exactly the same procedure that was done for former Speaker McCormick of the Gentleman's State. And I yield to the gentleman from Mississippi.
Since we are going to talk about the facts, I'd like to make this one point before we go any further. I think Mr. Flowers brought it out and it's been passed over. All of us have been speaking to this press conference of the 22nd, talking about the President's public statement. Mr. Wiggins spoke to it, Mr. Sarbanes. I think the important point is that this first section says making false and misleading statements to lawfully authorized investigative officers and employees of the United States. I think Mr. Doar said that this particular date and statement would not be applicable to that section. Is that correct, Mr. Doar? So the point is, the very first argument made in support of this section, in fact, is not applicable. Thank you for yielding.
All right. Recognize the gentleman from California, Mr. Danielson. 5 minutes.
Thank you, Mr. Chairman. We've been re-arguing evidence and facts all day, and the evidence closed on Wednesday of last week. I suggest that we get back to discussing the pleadings. Number 2, I wish to make it clear in the record that I do not concur with the opinion of my colleague from California, Mr. Wiggins, on constitutional law as it applies to impeachment proceedings. I yield to my colleague from California, Mr. Edwards.
Take long. This is a very simple Section 1, making false or misleading statements to lawfully authorized investigative officers and employees of the United States. The gentleman from Illinois, Mr. Railsback, has provided us definite information, time, chapter and verse, and in depth, some very definite testimony about where the President made the false statements to a lawfully authorized investigative officer, the head of the criminal division of the Department of Justice, Mr. Henry Peterson, and in addition to that, false statements made by the President to Attorney General Kleindienst. Mr. Wiggins says this doesn't count because Judge Gesell made some sort of a ruling the other day in a criminal proceeding, and I'm sure Mr. Wiggins really didn't mean that to apply to this case. We are certainly not dealing in a criminal proceeding. I really don't know what more, Mr. Chairman, we're supposed to do with this modest section. It seems to me that we have provided the information, the evidence to comply with it, and I think we ought to move along.
Which is cut out for us to vote on some articles of impeachment. I submit that we should quit setting up straw men and knocking them down, and I yield back to the chair the balance of my time.
Recognize the gentleman from Maine, Mr. Cohen.
Thank you, Mr. Chairman. I didn't realize I was seeking recognition, but I'm glad to accept it. I would simply like to follow up on a point just made by the gentleman from California, Mr. Edwards, in terms of what the duty of the President of the United States is and what the nature of these proceedings are. Because we've heard this time after time, all day long, placed in the category of a criminal proceeding. It seems to me, last evening, yesterday, we talked many hours very eloquently, about the sacred obligation of our positions, the sacred trust that each and every one of us hold, and the sacred trust that the President holds. And whenever we talk about that position of trust, I'm always reminded about the magnificent words of Justice Cardozo when he talked about the duty of a trustee, the duties of fiduciaries, being something higher than the morals of a marketplace, the punctilio of an honor the most sensitive. And that's the standard we should be looking at here, the punctilio of an honor the most sensitive. So it seems to me rather incredulous when I hear some of my colleagues suggest that only if the President raises his hand and swears on a Bible before a court should he be held to a standard of misleading investigators or the American public, only then after he has sworn on a Bible. Under oath before a formal proceeding, I think we demand much, much more than that from our elected leaders. So I yield back the balance of my time.
The gentleman from Virginia, Mr. Butler, sought recognition.
I'll yield to Mr. Butler if I have any time remaining.
The gentleman has time on his own.
Well, Mr. Chairman, when you asked that question, I was just seeking to protect my right to speak, and so I have nothing further to contribute except that I would yield to the gentleman from Salt Lake City.
Thank you. I thank the gentleman.
From Utah, Mr. Owens.
I thank the gentleman from Roanoke. I did seek the opportunity to ask one question of my colleague and seatmate here in reference to the conversation that we were having as regards to the President's request to Mr. Ehrlichman to see that Mr. Stans was not interviewed before the grand jury but was interviewed outside, and exchange the colloquy that he had with the gentleman from Massachusetts. While it is true that that Mr. Peterson testified before this committee that it is not unusual and not ordinarily improper to make such a request for a so-called very important person. In this case, after Mr. Dean and Mr. Ehrlichman had contacted Mr. Peterson, and Mr. Peterson had refused to make that exception for Mr. Stans, Ehrlichman called Mr. Kleindienst, and bear in mind that all this was done on the direct instruction of the President. Mr. Ehrlichman then called Mr. Kleindienst, the Attorney General, and according to Mr. Kleindienst, he told Ehrlichman that he, Mr. Ehrlichman, was very lucky that Peterson had not made an obstruction of justice complaint. And so in this circumstance, you have a situation where, pursuant to the President's instruction, you have the Attorney General saying to Mr. Ehrlichman that he had done something improper, obviously, and had come very close to being charged with an obstruction of justice complaint. Now, something strange happened after that, the details of which are not in evidence before the committee, because ultimately, in fact, Mr. Stans was interviewed outside the grand jury. But this, I think, lends some weight to the charge that perhaps, pursuant to the President's direct instructions, there was improper activity on the part of his two chief lieutenants acting in this area, Mr. Ehrlichman and Mr. Dean, at least according to the administration's own Attorney General.
Would the gentleman yield for a moment?
That was a rebuttal.
Time of the gentleman from Virginia has expired.
Mr. Chairman.
The gentleman from New York, Mr. Rangel, is recognized for 5 minutes.
I yield 1 second to the good father.
Just to complete this colloquy, I think it should be noted that Mr. Peterson himself speaks this way, and I quote from the hearings of his conversation to this committee. I think it is fair to say that the first concession was made concerning Mr. Stans, and that the decision was made by Mr. Kleindienst after a call to me from Mr. Ehrlichman, which got rather heated. Thank you for yielding.
Thank you, Father. Mr. Chairman, it's pretty clear to me that Mr. Sandman has pretty much made up his mind as it relates to articles of impeachment. But I do deem it a little unfair to use parliamentary procedures when, in fact, his motion to strike deals with each and every article that is outlined in Article 1 of our impeachment articles. It seems to me that he's made an admission to this committee that he was moving to strike paragraph 1 of the Sarbanes substitute, not because he did not believe that the President had made false or misleading statements to lawfully authorized investigative officers, but because it was his personal belief that this type of information should be included in the articles of impeachment. Well, if Mr. Sandman is going to take this route because of his personal belief as to how the article should be drafted, he has at the desk 9 amendments. If the chair continues to be as generous in his rulings to give 5 minutes to each member to discuss these blanket motions to strike as suggested by Mr. Sandman, then it would have consumed 27 hours of this committee's time to deal merely with Mr. Sandman's parliamentary questions. There are more than enough people ready to deal with some of the problems we have with the President. It's difficult to think in all of the criminal terms suggested by Mr. Dennis, because Mr. Dennis would forget the fact that the President is an unindicted co-conspirator. If you want to deal with the criminal law, there's plenty of opportunity to deal with that. Unfortunately, in our Constitution, the burden falls on us because the President can't be indicted. If indeed the writers of the Constitution want to use the criminal law, they would have not have given the President that protection as to not be indicted. It is a little surprising, however, where the President says that the Watergate grand jury has all of the information it needs to indict the guilty and exonerate the innocent, and then when he comes close to it, Mr. St. Clair said he didn't have enough evidence. Nevertheless, if you really want to deal with the false and misleading statements, then I ask my colleague from Maryland, why don't you walk with me through the President's steps, walk with me using his language as he went to bed the night of March 21st and talked to himself on a dictaphone, and this was March 21st, 1973. You don't have to pick these things at random. They're all over. And then on March 27, the words that he says to Ehrlichman as to what to tell the Attorney General, it is false, misleading, and expletive deleted. Now, what did the President say to himself? The President dictated his recollections of the day. He said Magruder will bring Haldeman down. This is the language that he heard from Dean. If Hunt wasn't paid, he would say things that would be very detrimental to Colson and Ehrlichman. That Mitchell had been present when Liddy offered his political intelligence proposal, that Colson with Hunt and Liddy was in his office. That he had called up Magruder. That Colson had pushed too hard. That Ehrlichman sent Hunt and his crew out to check into Ellsberg's psychiatric problem, and Krogh was in a straight position of perjury. This is not what he's saying is true. This is what he is saying that Dean told him. And Strawn had been a courageous fellow through all of this, and that Strawn certainly had knowledge of the information of the matter, and that he was going to call Mitchell. Now, he calls Mitchell, and of course, that's when they talk about stonewalling it. Now, I just want to say that with all of this information, with Dean talking about the cancer, and no one takes issue with the facts that the President is talking, we heard the conversation, and I will yield if I have time. What bothers me is March 27th, where the President is talking to Mr. Haldeman, and he wants to get all the information that he can from the grand jury. And he tells John Haldeman to ask Kleindienst. He said, put it on the basis that it's John Mitchell that wants the information from the grand jury. And so everyone can't say it's the White House raised hell about it, because we're not raising hell. Just tell him that he owes it to Mitchell. Now, here's the last part, and I'll yield. He says, I think you've got to tell him, look, Dick, that's Dick Kleindienst. Let me tell you, Dean was not involved. Well, the president said on March 21st to himself that Dean had confessed.
Will the gentleman yield?
Wait a minute now. The president said, and it is the president's word, that Dean felt he was criminally liable for his action and taking care of defendants. March 21st, Nixon talking to Nixon. March 27th, Nixon talking to Ehrlichman. He says, tell him, look, Dick, Dean was not involved. Now, this is not taking anything out of context, and then the president goes on to say to tell Kleindienst that nobody in the White House involved.
I ask unanimous...
Time of the gentleman has expired.
I ask unanimous consent that the gentleman be given another 30 seconds so he can yield 15 of it to me.
As long as...
Without objection, it is so ordered.
Will the gentleman yield?
I yield.
The objection comes too late.
The gentleman misunderstood my criticism, if it is criticism. I'd be happy to walk hand by hand with him through the evidence and pluck out the things that are germane to our articles of impeachment, but I think we should reject those that are not. That was the only point I was trying to make.
Well, the gentleman agree that the gentleman from New Jersey is not concerned with the facts that you and I agree the American people should know.
I will let the gentleman from New Jersey speak for himself, but I abhor the Strawn the commendatory things about Strawn. In fact, I was responsible for putting into the Sarbanes substitute the language about rewarding those who had committed perjury. Giving a $36,000 job to Magruder after he was known to have committed perjury is even more damaging. And I want all those things to be brought out and specified. But I also think we should reject the things that are not germane.
The time has expired. The gentleman... the gentleman, Mr. Maine.
I thank the chairman for yielding, and I want to thank him also for his patience tonight, and to assure the chairman that I am not trying to delay these proceedings, but ask for this time because I am very genuinely concerned whether the person charged here with very serious offenses, who happens to be the President of the United States, is really given adequate and fair notice of the nature of this charge, which, as has been stated a number of times in this particular subparagraph, is that he either personally or through subordinates and agents made false or misleading statements to authorized investigative officers and employees of the United States. Now, Mr. Railsback, my good friend from Illinois, has rattled off a great many instances which he believes would come within this category. And the gentleman from New York, Mr. Rangel, has said such instances are all over the place. But it seems to me that that is the very point, that the President and his attorneys should not have to look all over the place in preparing their defense. I cannot see how it can be of any possible prejudice to the House of Representatives in an impeachment proceeding to set out fairly and specifically when these instances occurred. If the gentleman from Illinois is correct in his recital, and I believe Mr. Dorr indicated that he thought he was, it would seem to me that no harm could possibly be done by setting those out.
There are, after all, many authorized investigative officers. I think that the FBI agents, and I believe Mr. Dorr mentioned that there were some FBI agents to whom such statements are alleged to have been made, certainly it would be no great task or unreasonable burden for the staff in preparing these articles to set out the names of those agents. So the defense won't have to sift through every single interview with every agent that took place. And the point has already been made that there are even more employees of the United States than there are authorized investigative officers. The President happens to have a number of agents and subordinates. Many statements have been made which some of my colleagues here tonight feel were false or misleading. But if only particular statements are those on which you rely, I fail to see how it would not be proper, why it would not be required by fair play and due process to set these matters out in detail in these articles so that the American people, as well as the President and his attorneys, will know just what it is that they're up against. And I'd like to ask Mr. Dorr, if I may, Mr. Chairman, what harm would come from setting out in subparagraph 1, I believe it is, at least the one that is the subject matter of this motion, what harm would it do to the impeachment case for you to set out the names of the agents and subordinates of the President, the specific occasions on which you allege that he made these misleading statements, and to whom he made them? Why should there be mystery about it? Why should there be speculation or guesswork about it? Why would this prejudice the House of Representatives? It does seem to me that it very definitely will prejudice the President, that he shouldn't just have to rely on some I apologize, I do not wish to say offhand statement by the gentleman from Illinois, because it was obviously carefully prepared, but given in a necessarily very hurried manner. Isn't this a matter of enough importance so that you should prepare it specifically and in a manner that the defense and the American people can fully understand?
Well, I think in order to answer that, you have to admit that you have to balance. On the one hand, that you have to give the President fair notice. On the other hand, you have to move along and avoid dilatory tactics. And it seems to me that experience has shown throughout the last 200 years of our country that the way to fairly present these matters is to present in the pleadings short, concise, simple statement of the ultimate facts that you base your articles on, and then give to the person charged full opportunity in the pretrial and the discovery stage to learn all the facts about the case. That if you get arguing about the pleadings, the paper, experience has shown that you run into a considerable amount of delay and dilatory arguments that are really, experience has shown in the judicial processes, are unnecessary. So that you can't, I really do think, Mr. Congressman, that to set this all out in a pleading, in an article, would cause harm. Not in the sense of depriving the President of knowing every single thing that he's entitled to know, the nature of the charges, but rather that it will just build and feed and fester into more and more delay of ultimately getting to have this case finally decided, one way or the other?
Well, I assure the gentleman I share the concern about delay, but I'm afraid we're inviting and causing delay by the filing of a bill of particulars if this statement is not sufficient.
Time has expired. The gentleman from Wisconsin, Mr. Froelich.
Need any more time?
No, I thank you.
Thank you, Mr. Chairman. I think that what we're going through here today is, I recall the statement I believe the Vice President made. Impeachment is what this committee says it is, or what this House says it is. Now, many people have disputed that, including some members of this committee. We started out in this process, as it was pointed out, we could not, as a committee, come to a conclusion as what was an impeachable offense by definition. We never decided by a committee what the level of proof, the burden of proof should be for us, whether it should be clear and convincing, as many of us agreed to, or whether it should be beyond a reasonable doubt, as some of the individuals thought. We never settled that. And so now we're here we finally got the articles, the proposed articles before us. And why have we spent this whole day arguing over the articles? Because they were not specific. Because many of the individuals on this committee did not know what the proposers of this articles was going to use to back it up. And so we've argued for a full day. Now, had the committee staff, which I understand is physically and emotionally drained, had the staff had the time to properly sit down and prepare the details, they could have backed up with a statement the specifics for each one of these subparagraphs. We could have made the decision as a committee whether they should have been included or not included. But you see, we're here with an article presented when the debate started on Wednesday night. And we've been going for the television cameras morning, afternoon, and evening ever since. The staff people have been going. The committee has been going. There has not been time to detail the specifics of these charges, either in the charges or in supplementary material. And we can't stop to take the time. We told the American people the importance, the awesomeness of this task, and now we're under the gun. We can't stop and take the time to write the specifics to everyone's satisfaction. Now, not everyone on this committee is going to agree, but it seems to me that we needed to take the time to put the specifics in detail behind each one of these articles to at least the satisfaction of the staff and the people proposing the articles, so then we could say, based upon this information, yes, I will vote for it, or no, I won't. But you're asking the committee members to really buy a pig in the poke. Many of us have tended to lean toward an article of impeachment and obstruction of justice. We think it needs to be spelled out. Now, the motion from the gentleman from New Jersey is not dilatory. It's not made to delay. It's made to explain to the American people the specifics behind each one of these subparagraphs. And in talking to the gentleman from Alabama, he said, we need this, to me earlier this evening. And I think we need it, and the American people need it. Now, the best way to get it is not to spend another day fighting over the next 8 articles, or asking the staff to explain the next 8 articles, or trying to explain them shooting from our hip. But it's to take the time. And 1 day or 2 days after 8 months is not going to make the difference. Seems to me we need to take the time to give the staff the opportunity to work with the proposers to detail the specific items behind the charges. And then we can sit down and say yes or no.
Would my friend yield, my friend from Wisconsin yield?
Yes, I yield.
I think he's made an excellent statement that I did talk to him earlier, and I think it is highly important that we proceed in some manner to elicit the specific facts that go with the specific charges. And I think that this is one process of doing it. a motion to strike a specific section of it, and then discuss it in detail. And I would certainly agree that although it might be per se dilatory, it's also per se very helpful in adducing the evidence that stands with each one of the charges. And I appreciate the gentleman yielding, and I appreciate his statement.
We started, Mr. Chairman, at 11 o'clock this morning. The most important vote that the members on this committee will ever cast in their life is a vote for impeachment. And we're dragging them through 12 hours today, more than that yesterday, months of this, and to take some time to think, we're not allowed to. We've got to rush forward. We've got to have this on the floor. I think that's a mistake, Mr. Chairman.
Time of the gentleman has expired. The gentleman from Ohio, Mr. Seiberling, is recognized.
Thank you,
for 5
Mr.
minutes.
Chairman. I'll try not to take 5 minutes. I think the gentleman from Wisconsin has made a constructive suggestion, if I understand it correctly. As I understand it, you are not demanding that the articles necessarily spell out all of the specific details, but that we have before us, in considering these subparagraphs, the evidentiary facts outlined in some way so that we can see what the staff thinks are the things, at least some of the things that they feel support them. Is that correct?
Yes.
I think that's a very excellent suggestion. I would like to just comment on one other matter. I think that these 12 hours have not been wasted. I think if we can arrive at some consensus as to how to proceed along lines like this, we are not wasting our time. I do feel that time is very pressing. The country has grave problems which are being impeded, the handling of which are being impeded by the uncertainty caused by the impeachment situation. And we owe it to the country to move ahead. I'd also like to just make one other comment, and then I'm going to yield to the gentleman from Missouri. And that is that we could have spent days and days wrangling over the specifics of a very detailed article of impeachment here, much more than we have in discussing the principles of what should be the article of impeachment. And I think that the staff and the people who drew this up have really approached it in the right way and can give proper notice to the President. I yield to the gentleman from Missouri.
I thank the gentleman for yielding, and I was interested in the remarks of the gentleman from Iowa, Mr. Maine, and who is an experienced trial attorney. I would inquire of him if we're not facing the problem of where we have a pleading drawn that somebody was hit on such and such a day in such and such street and he's hurt, and you file a motion to make it more definite and certain, and the man comes in and says, well, his head and his scalp was bruised and contused and abused, and his ears and his eyes, and then he tells you so much that you don't know any more when you get done than you did when you started. I'm sure the gentleman has had that sort of experience in the trial practice, and is not what we're doing trying to strike some middle ground on this.
Well, if the gentleman...
If he will yield on the gentleman from Ohio's time.
May I say that I received a telegram tonight from a prominent businessman in Green Bay, Wisconsin, which I believe is in the gentleman's district, saying that he thinks that this proceeding is going in a very, very fine way, and I think the gentleman from Wisconsin is helping contribute to that. I yield. Who was it?
I wanted to yield the gentleman from Iowa, if you would, please, Mr. Maine.
Well, it would be my experience, if the gentleman from Missouri will yield, that we would at least state the name and the date and the nature of a misstatement, not in an accident case, which this is not, but in a case involving misstatements or alleged fraud or anything involving dishonesty, as is the thrust of this subparagraph.
If the gentleman,
I think it would be
I'd like to yield to the
defective.
gentleman from Illinois, Mr. Railsback, if the gentleman from Iowa is finished.
I'm complete.
I want to thank the gentleman for yielding, and very briefly just say that I was impressed also with the statement of Mr. Freelick, and I want, if we're going to be prepared to present a bill of particulars to the other body, for the life of me, I wonder why we can't have our own bill of particulars to take to the House. And if we call it a bill of particulars, or if we call it some kind of supporting evidence, but I think we definitely do. I think many of us feel we do need something. Perhaps it could be in the nature of a bill of particulars.
Well, as long as it is tentative, because new evidence may well be discovered before we get to the point of the trial in the Senate.
It could be tentative. It could be tentative, but I think it would help our colleagues, and I really think it would help us.
Thank you.
Fired. I recognize the gentleman from California, Mr. Moorhead.
Mr. Chairman, the struggle against reason and reality insofar as making the charges specific is something that I can't understand from the explanations that have been given. Because if it is possible to make up a bill of particulars, and that won't delay the proceedings, I can't understand how it would delay the proceedings to put it into the pleadings. One thing that I think that is most important, and that is that the members of the committee, when they vote on each one of the charges, be able to see the thing that backs up that particular charge that is made against the president, and from that evidence and from those particulars to reason with themselves as to whether they want to make that a charge for removing the President of the United States from his office. And I think that we have to consider that on each one of these things that comes up. I'm sure that from the debate that's taken place here tonight, largely between the two gentlemen from California, Mr. Waldy and Mr. Wiggins, it must be apparent that the facts are confusing. That if you want to take a particular point of view or the other, you can prove almost anything, especially if you're willing to take hearsay evidence and some of the other irrelevant evidence that has been offered here before this committee. It's important that the evidence that is to back up any charge must be strong and persuasive and of the kind that is admissible in court. And we, as members of this committee, have a right to see to it that the specifics that are available are sufficient to support any charge that has been made. One thing that has come up continually, and I think I ought to comment on it, and that is concerning Mr. Dean's position as having been ordered or not ordered by the President to make an investigation. There is no question but what in the White House, Mr. Dean was the person that all the members of the White House staff looked to for information and took their information to concerning anything connected with Watergate. Mr. Colson testified to that in testifying before the committee here a few days ago. It can't be any surprise either to the members of this committee to know that the President felt that Mr. Dean had a mission in going up to Camp David and preparing a report, because in the tape that we heard that was presented to us by the committee, the President may not have ordered Dean to make a report when he was at Camp David, but he suggested to him that if he went to Camp David, it might be a good opportunity for him to think about a report that he might make back to the President. We're arguing with semantics when we try to make that a major issue in this impeachment hearing. One last comment that I'd like to make, and that is in connection with all of the evidence that we have had and the things that we have heard. A few good rifle shots at a good solid target would be a lot more effective than the shotgun blasts at thin air that we have had in these hearings. I yield to the gentleman from Indiana.
Yes, perhaps to my friend from California, that one of the reasons there's such an unwillingness to be specific may be that some of the specifics that they would rely on if they pled them just wouldn't pan out as true. Mr. Wiggins has already mentioned this, but one of the points that has been suggested here is that on the 27th of March, the President instructed Ehrlichman to tell Attorney General Kleindienst that Dean was not involved and that that's false. Well, here's what he said. He said, "Look, Dick," this is what he's saying to Ehrlichman, what he should say to Kleindienst, "let me tell you, Dean was not involved, had no prior knowledge." Now, they're talking about prior knowledge of the Watergate break-in, and there is no hard evidence that Dean had prior knowledge of the Watergate break-in. They're not talking about the cover-up, and that is proved when you go over further and read what Ehrlichman actually did tell Kleindienst. He said, "The President said for me to say this to you, that the best information he had and has is that neither Dean nor I nor anybody in the White House had any prior knowledge of this burglary." Now, that's all they're talking about, and it's a very, very thin suggestion that there's anything false in that.
Would the gentleman yield on...
It isn't false, by the way,
would
to
the
the
gentleman
evidence.
yield? I think we can have a
yield
meeting.
Back to my friend.
Would the gentleman yield?
The gentleman from California has expired. The gentleman from New Jersey, Mr. Mariziti.
I thank you, Mr. Chairman, for recognizing me and for your patience in the proceedings tonight. I support the motion to strike this section. We've heard the statement made today that we don't want to strangle the pleadings with the facts, and I certainly agree with that statement. But I think, Mr. Chairman, that we ought at this time to make a very technical distinction that we as lawyers understand between evidence and facts. On the one hand, proof, and allegations on the other hand. We're not talking here about proof, evidence, facts. We're talking about allegations. Now, what is an allegation? It is simply a precise statement of the charge. The evidence and the facts constitute the proof. Now, we're not asking for the inclusion of the evidence and the facts. You certainly don't want that in a pleading. But you want the allegations, very simply, as has been stated here by many members, the time, the place, and in this particular instance, the statements that were alleged to have been made. That's very simple. What statements were alleged to have been made? And to whom and where? Now, the recitation here in this hearing tonight, in this room tonight, is not the answer. The recitation of facts and alleged facts, and I must say, in many instances, opinion by the gentleman from California, Mr. Waldy, which recitation is replete with conclusions of his own, is certainly not the answer. The allegations should be included in the articles of impeachment. We're not seeking an explanation of the allegations orally. They must be in the articles of impeachment for two reasons: so that we know what we're voting on, and so that the respondent knows what he must answer. Now, some reference has been made to the committee report. Now, this has been referred to by the chairman and by Mr. Dorr. But the committee report, the report that's to be written, is not the answer. The report is not a part of the articles of impeachment. Now, if Mr. Dorr is going to get the allegations and the facts and other matters that he wants to put in a report, that's fine. But let's have the allegations now, as the gentleman from Wisconsin has suggested. Let's have them when they're ready, and whatever time it takes, we should take. And certainly, it's only a matter of a day or two. And then we can vote. on the articles with the allegations, and Mr. Dorr and the staff and the members can work on and put in the report whatever is to be put in the report. Now, the gentlewoman from Texas, in regard to an analysis of due process, has said that due process has been given to the President in the proceedings that we've had here during the last months. Some will dispute this allegation, but nevertheless, let's assume that that was the case. But are we going to stop? Are we going to stop due process at this point, the most crucial point, when we are drafting and voting on the articles of impeachment? Mr. Chairman, I submit to you that due process at this point of our proceedings requires that the articles of impeachment contain the specific allegations. Mr. Chairman, therefore I say to you that in the absence of these specific allegations, I have, in this section that we're dealing with, I have no alternative but to vote in support of the motion of the gentleman from New Jersey, Mr. Sandman. Thank you, Mr. Chairman.
I recognize the gentleman from Mississippi, whom I overlooked, Mr. Lott.
Thank you, Mr. Chairman. I know the hour is late, and I'll be brief. I would like to associate myself with the remarks of Mr. Maine and also speak briefly in support of the motion to strike by Mr. Sandman. I think that he probably did not intend necessarily to offer motions to strike on each amendment, but I think it's been clearly demonstrated here by what has been said that we do have a need to see what the specifics are so that we can debate and agree, if possible, on what specifics will be included in the articles. Now, we've already pointed out earlier that there was a mistake on the first allegation in support of this section. And I have another one that I could speak to with regard to the President giving false and misleading statements to Peterson on March 21. But I think enough has been said about this. I think now that the point has been made very clearly by the last few speakers on both sides of the aisle that we do need to find some way to come up with the particulars. And I urge the committee to go ahead and get on with this vote on the motion to strike and make some determination as to what we can do or some way that we can find to be more particular so that we can debate the real issues, the real facts that we've been asking for an opportunity to discuss. Thank you, Mr. Chairman.
I recognize the gentleman from Ohio, Mr. Lotta.
Thank you, Mr. Chairman. As a reward for your patience, I shall not take my full 5 minutes. I take this time to ask a couple of questions, Mr. Dorr. If we do not strike this item, is your intention then to leave it in these general terms and to go to the statements of information for the details?
I'm sorry, I didn't understand the question.
Is it your intention, if the article, the item is not stricken as proposed by Mr. Sandman, is it your intention then to go to the statements of information for the details that will have to be spelled out specifically to charge the President?
No, Mr. Ladd, it would not be my intention to do that.
Where would you get the information?
You would have the statements in a report that would go along with the article to the floor, and in the report you would be keyed to the summary of information that you were furnished last week, and that in turn would also be keyed back to the statements of information. But what you would have, as I would vision it, you would have a report that was maybe 15, 20 pages long that would summarize these facts, these ultimate facts and relevant facts, and that would be keyed for if someone wanted further information to the summary of information. It was about 150 pages long and had it all keyed to the statement of information where you could see the documentary, the evidence, the testimony, if you needed to see that.
Well, where would the President have to go to find out the charges being made against him specifically?
Well, the President would have the article or articles of impeachment, which would be general, the President would have the report of the committee, the President would have the summary of information, and the President would have the statements of information.
He would have to go to all of those.
Well, it isn't a question of reading them all. They would all be keyed so that you could get from one to the other very easily. It's not a difficult job of getting in and out of this material if you have a proper index.
So what you're saying then, you're going to have a report in addition to the statements of information?
Well, there would be a committee report. That's my understanding what the chairman has said.
And you wouldn't be incorporating all 38 or 39 statements of information in that report?
No.
But the President would still have to go to those statements of information to get the details of the charges being made against him specifically.
Well, not the details of the charges, but if he had...
Well, let's get the specifics.
No, the specifics would be in the... there would be more specifics in the report. You could be more specific if you look at the summary of information that we furnished last week.
Well, then the question is, how would the President know the charges being made against him if we left this charge making false or misleading statements to lawfully authorized investigative officers and employees of the United States? Now, you just outline how he would know what those charges are so he could defend himself against them.
Well,
you would go then to the report from this document.
He would go to the report. And if the report, then he would look at the summary of information. That's the document that we furnished in one notebook.
Right.
And then in the one notebook, that's keyed to the statement of information. And you could go to that and look at the actual testimony, for example, or the statement that a particular person made, or the press release, or whatever else was relevant on that subject. And that is not unusual with respect to modern civil or criminal practice.
It might not be unusual, but in cases, in criminal courts these days, we don't have 38 or 39 volumes of statements of information. And I would just like the American people to know what we're talking about. This is the other one. I don't believe they need any more time, Mr. Chairman.
The gentlelady from New York is recognized for 5 minutes.
Chairman, I'd like to speak in opposition to the motion to strike, and I'm absolutely overwhelmed by the evidence with respect to this, and I think it has to be seen in context. When I spoke earlier, I said that John Dean had confessed to the President on March 21st that all kinds of people in his administration had been guilty of criminal acts. And not only did the President say to Dean that your involvement in this, your obstruction of justice, that was the right plan, but the President didn't pick up the phone and call the Attorney General Kleindienst or call FBI Director Gray to say sad and criminal things are going on in my administration and I want to put an end to it. He didn't call Kleindienst on the 21st. He called Kleindienst on the 22nd and he said, yes, you better call Baker, Senator Baker at the Senate Watergate Committee, and babysit with him in like 10 minutes. And then on the 27th of March, even though the President is burdened with this overwhelming information, this cancer that's growing in, he tells Ehrlichman, he says to him the following: have a session with him, i.e. Kleindienst, about how much you want to tell him about everything. Ehrlichman, President, I think you've got to say, look, Dick, let me tell you, Dean was not involved, had no prior knowledge, Haldeman had no prior knowledge, Ehrlichman had none, and Colson had none. But what was the President told by Dean? He was told that Haldeman had been told about the first 2 Liddy bugging plans, that in fact Haldeman had ordered Liddy to move the capability from Muskie to McGovern headquarters before the break-in. The President was told that Strawn knew, and the President was told that Colson called Magruder to tell him to get going on the Hunt and Liddy plan. And the President is telling Ehrlichman not to tell Kleindienst about all of this information and the criminal liability, but he's telling Ehrlichman to tell Kleindienst nobody is involved and nobody has prior knowledge. Is this the kind of conduct we expect from our President? Is this the kind of concern that he has for the enforcement of the laws? Let's look at his conversations with Peterson in April. He says to Peterson on April 27th, and he's describing this March 21st conversation, he says about the Hunt blackmail payment. He said to Peterson, "And believe me, nothing was approved. I mean, as far as I am concerned, I turned it off totally." And if we recall the language that the President used on March 21st at the end of his conversation, his very own words, he said to Dean, "That's why for your immediate thing you've got no choice with Hunt, but the 100 or 20 or whatever it is, right? Well, for Christ's sakes, get it in a way that, And then he goes on and he said to Peterson, well, he says, when I was talking to Dean about this blackmail money or this $1 million, I said to Dean, you couldn't put it through a Cuban committee, could you? Well, the President never said that to Dean. He never said anything like that. What in fact he said to Dean was how to make up an alibi on the Cuban money. The President's own words, quote, "As far as what happened up to this time," and that's referring to all the hush money payments, "our cover there is just going to be the Cuban committee did this for them up through the election." Dean, that isn't, of course, quite the way it happened. President, I know, but it's the way it's going to happen. Where do we see the President of the United States in his conversations either with Mr. Kleindienst or Mr. Peterson making any attempt to deal with the criminal liability of the people around him and get rid of the cancer not only in his White House but in our country? And that's what we're talking about here, Mr. Chairman, and I urge that this motion to strike be defeated.
The time of the gentlelady has expired. The gentleman from Utah is recognized for 5 minutes. Mr. Owens.
Mr. Chairman, I rise in opposition to the motion to strike. And I'd like to refer back to the statements earlier of the gentleman from California, Mr. Wiggins, who in debating this same motion, which is to strike subsection 1 of this article to the effect that the President has made false and misleading statements to investigative officers and others. Mr. Wiggins again spoke of the celebrated June 22nd statement by the President at his press conference to the effect that there was no White House and no committee for the re-election of the President involvement in the burglary which had taken place 5 days earlier. And he said that there is no clear and convincing evidence as to when this policy of obstruction of the investigation, which is at the heart of the Sarbanes substitute, that there is no clear and convincing evidence as to when the policy came into effect. And I would like to state, and then take you through several items of evidence which all members are aware of, that policy clearly came into effect sometime between the 17th of June and this statement by the President on the 22nd of June. Now, I think the strongest case can be made from inferences and from a reasonable application of what all congressmen know is the procedure in all of our offices. All the President's men, in essence, are aware, from evidence that the members are aware of, were aware prior to June 22nd and several days prior, as a matter of fact, that Mr. Hunt then technically on the rolls at the White House, had been involved in the burglary, and that Mr. Liddy, then and who was continuing to serve as chief counsel to the Committee for the Re-election of the President, everyone knew that those two men had been involved in the burglary prior to this time. And we know in our offices, I would say to the members of the committee, that we follow those things. And it is impossible to believe that the President could have been aware of the burglary, which we know he was, and have been aware that it could have involved people in his campaign committee or in the White House, and not to have asked questions. But out of the President's own words, we know that by June 22nd he was aware of Mr. Hunt's and Mr. Liddy's involvement. That Mr. Colson's testimony to this committee clearly indicated that on the 19th, 2 days after the burglary, that he had a conversation with the President. The President's response was to throw, as reported to Mr. Colson, was to have thrown an ashtray across the room in disgust when he learned that the Committee for the Re-election of the President was involved in that burglary. And we have the President's own memo to himself, as has been called earlier, on the night of June 20th, when he indicates that in a conversation with Mr. Mitchell had informed him that personnel from the committee had been involved in the burglary. And we know from the President's statement of May 22nd, 1973, in reference back to the days immediately following the Watergate burglary, when he says within a few days the name of Mr. Hunt had surfaced in connection with the investigation, and he uses that in reference to the time that the CIA involvement became known to him, which clearly indicates and is tied in prior to June 22nd. So clearly the President has indicated in the evidence available to this committee, and it's got to be clear and convincing, that he did know that Mr. Hunt had been involved, then technically on the rolls of the White House, and that Mr. Liddy, still chief counsel to the Committee for the Re-election of the President, had been involved. Both members had been involved, and yet with that background and with that in his conscience, with that in his mind, the President then went before the American public the night of June 22nd and said in response to a question, Mr. Ziegler and also Mr. Mitchell, speaking for the campaign committee, have responded to questions on this, the Watergate burglary, in great detail. They have stated my position and have also stated the facts accurately. This kind of activity, as Mr. Ziegler has indicated, has no place whatever in our electoral process or in our governmental process. And as Mr. Ziegler has stated, the White House has had no involvement whatever in this particular incident. Mr. Chairman, I yield back the balance of my time.
Mr. Chairman, I move the previous question.
Texas, Mr. Brooks moves the previous question, and the question is on the motion to strike paragraph 1 the Sarbanes substitute. All those in favor of voting for the motion to strike, please say aye. Aye. All those opposed?
No.
The noes appear to have it. The gentleman from New Jersey demands a roll call vote, and the clerk will call the roll. All those in favor of the motion to strike, please say aye. All those opposed, no. Clerk will call the roll.
Mr. Donahue?
No.
Mr. Brooks?
No.
Mr. Kastenmeier?
No.
Mr. Edwards?
No.
Mr. Hungate?
No.
Mr. Conyers?
No.
Mr. Eilberg?
No.
Mr. Walde?
No.
Mr. Flowers?
No.
Mr. Mann?
No.
Mr. Sarbanes?
No.
Mr. Seiberling?
No.
Mr. Danielson?
No.
Mr. Drinan?
No.
Mr. Rangel?
No.
Miss Jordan?
No.
Mr. Thornton?
No.
Ms. Holtzman?
No.
Mr. Owens?
No.
Mr. Mezvinsky?
No.
Mr. Hutchinson?
Aye.
Mr. McClory?
Aye.
Mr. Smith?
No.
Mr. Sandman?
Aye.
Mr. Railsback?
No.
Mr. Wiggins?
Aye.
Mr. Dennis.
Aye.
Mr. Fish.
No.
Mr. Maine.
Aye.
Mr. Hogan. Mr. Butler.
No.
Mr. Cohen.
No.
Mr. Lott.
Aye.
Mr. Fraley.
Aye.
Mr. Moorhead.
Aye.
Mr. Mariziti.
Aye.
Mr. Latta.
Aye.
Mr. Rodino.
No.
Mr. Chairman,
Clerk will report.
11 members have voted aye, 27 have voted no.
And the motion is not agreed to. And the committee will recess until 12 tomorrow noon.
And there you have the first crucial test on the articles of impeachment. By a vote of 27 to 11, the coalition of majority Democrats and some Republicans who favor an impeachment resolution, the coalition has stuck together to beat back an attempt by a Republican minority to change the initial article of impeachment, an article charging the president with obstruction of justice. The specific vote concerned an attempt by the minority to strike the first basic allegation against the president, that he had made false or misleading statements to lawfully authorized investigative officers and employees of the United States. This would indicate, on the basis of this vote, this would indicate that this article ultimately will be approved by the committee. And from there, that the committee will go on to approve a resolution of impeachment that may well include not just one article, but 2 or more articles. It was significant on this vote. The vote again was 27 to 11. It was significant that 6 Republicans broke ranks to join all 21 Democrats to provide the better than 2-to-1 margin to assure the defeat of the Republican motion. Well, Jim, it's been a long day for the committee. They began this morning an hour late at noon. They had a lunch break. They went very late in the afternoon. They quit for dinner. They came back. They have had a long evening. Now, as Chairman Rodino announced just a moment ago, they will meet again tomorrow. It seems obvious that we're going to be in for more test votes tomorrow. I think it became clear today that the Republicans who are defending the president are going to use as many maneuvers, as many motions as they possibly can to delay the proceedings, to try to hold off the resolution of impeachment, to prevent it from going to the floor. But I think we would have to conclude on the basis of what has happened tonight that they are fighting a losing battle.
And that's, of course, the key question that will probably be resolved overnight before they reconvene at noon tomorrow, Paul, is whether or not the Republicans will stick with the strategy and go on a motion to strike each one of the other 8 charges under the overall article of impeachment, Article 1, which charges that the president committed acts of obstruction of justice in the Watergate cover-up. There have been indications from Mr. Sandman that he might do that. There were indications from Mr. Wiggins that he might do that. Now, the question now is whether, as a result of this 27 to 11 vote, well, they'll pursue that or not, or whether they'll feel that they have made their point, with their point being, which we need to restate, their point being that the articles of impeachment as drawn in the substitute, which is what is pending now, proposed by Paul Sarbanes, Democrat of Maryland, whether or not the articles themselves are specific enough. And as we've just seen, the 27 members of the committee decided yes, they were indeed, and so we'll see what happens tomorrow.
Carolyn Lewis, who has been on the scene at the Judiciary Committee, is standing by outside the committee room. Carolyn?
What you've seen here, I think, during the day, Paul and Jim, is really a demonstration of congressional niceties and mysteries and procedure. Chairman Rodino is absolutely determined not only to be fair, but to appear to be fair, and that's why he is not cracking down on the Republicans and trying to cut off all of this long dialogue that we've had inside the committee all during these long hours. He is determined to go by the rules, and the rules say that there can be 5 minutes for each member for each amendment. And as Mr. Rangel pointed out, that means it could be a total of 27 hours of debate on these striking motions, all ending probably with the same kind of vote that we had tonight, 27-11. So it is, as you said, up to the Republicans to decide whether or not they're going to proceed. I think the real danger here is that you may strip away some of the support in the final amendment, in the final vote. But it seems that basically they were holding fast, except for Mr. Freilich. If you look at the final vote, some of the people who were raising some questions about the issue actually decided that they would vote not to strike. So it looks like they're holding fast in spite of that debate. I think the Republicans may weaken. I think they may get tired. Chairman Rodino is really counting on that. I don't know when he's going to decide to move in and cut off the debate. But the way it looks right now, it's something like a Bach fugue, point and counterpoint. The Republicans get a point, the Democrats get a point, and what we have is really what we have right now, a standoff. Back to you, Jim.
Carolyn, would you agree that what we have now is a delicate balance? Somewhere along the way, the Republicans will have to make a decision as to when they have made their point and the thing may backfire on them, versus Chairman Rodino having to make a decision as to when he has given them their fair shake, and maybe he can get away, say, with cutting them off. And that delicate balance is going to have to be resolved tomorrow, before tomorrow, or once they get started again tomorrow.
They may caucus in the morning. You have to pin your faith on the old compromise procedure in Congress, and they may decide to caucus in the morning before noon and come back refreshed and sort of facing the facts that they really are simply wasting time with this procedure. But a lot depends on whether the Republicans are making points, political points, when they're talking to the public, whether they're making political points when they're talking to the House members who are going to have to vote on impeachment. After all, this gives them a platform to say, the president is not getting a fair shake, the president is not getting due process. And if that appears to be working, they may continue to hold up the procedure. They may decide that they're going to continue with this delaying process because they're getting their message across.
Carolyn, one thing did seem to be significant in the voting, and that is that six of the Republicans did join the Democrats on this specific issue, which certainly makes it clear now that at least 6 and possibly other Republicans, or at least one other Republican, will be ready to vote for a resolution of impeachment.
I think that's true, Paul. I think this is probably, well, it's the first vote, and it probably is a test vote on impeachment. And I think the votes in the final analysis on the articles of impeachment will be something like this one, 27-11, maybe give or take 1 or 2 on either side. But that's a pretty solid vote in favor of impeachment.
All right, thank you, Carolyn. Let's go now to our 2 guests for the day and the evening. Bill Van Alstyne, Professor of Law at Duke University, and Martin Diamond, Professor of Political Science at Northern Illinois University. Gentlemen, I want to ask you a question that was raised by one of the members themselves.
Jim, the control room is advising me in my ear that Carolyn has now buttonholed Congressman Sandman, who, of course, figured very prominently in today's debate as one of the staunch defenders of the president. Carolyn, come back.
Mr. Sandman, are you going to keep up this tactic? Are you going to take that 27 hours? How do you look at it right now at this late hour?
Well, I don't intend to continue this on each of the 9 points in the first article, but I, in all honesty, must tell you I'm sure that others will. The point that I made was one on a strict interpretation of the law as I understand the law, and I am not willing to yield to the rulings that have been made here tonight, which I believe are not accurate. I just can't imagine why they've gone to such great extremes to resist making the charges specific. I know why, as a lawyer, they're doing it, sure. So does anybody else that wants to put 2 and 2 together. And it's very simple. They've got 40 books, but they have no witnesses, you see, and they've got an extremely soft case. And the idea here is that they would lose point after point once they get into specifics. What they've tried to do here is make very general statements so that they can wander all over the lot, which would allow Congressman Waldy, for example, to go into his storytelling. And that's the way they choose to prove their case, and that is not legal evidence.
Mr. Sandman, but you obviously, from this test vote, don't have the votes to carry on any of these 9 points. Why press on when you know you've already lost?
Well, I told you, I'm not... the part of the argument that I was interested in has been presented today. I presented my argument, which I feel is a strong argument. This argument we will continue on the House floor, not here. When I get on the House floor and I raise this objection, the chairman will not be able to say, but Congressman, why didn't you raise this objection during the hearing? He can't say that.
But you've raised it once. Why continue to raise it 8 more times?
Well,
that's what I'm trying to find out.
I just said to you, I do not intend to raise that point again. I do not intend to make motions to strike myself. I said that. I said, in all honesty, I must tell you that I believe others are going to dispute the horrible accumulation of facts as they try to do here, which are completely out of continuity, double meaning and whatnot. Those who oppose impeachment cannot let those kind of stories go by unchallenged. And for this reason, it appears to me that you're headed for 27 more hours of debate as you saw tonight. You're going to have about 3 hours on each of these articles, as I see it, and you're going to consume the rest of the time voting. It's that simple.
So you don't think we're going to have a final vote on the article of impeachment by tomorrow night, judging by what your colleagues are planning?
No, as I see it now, to conclude this tomorrow, at any time tomorrow, if we went straight through in a 24-hour session, you still wouldn't do it. There's very strong feeling here that these people are unwilling to do anything. They're sweeping the Fifth Amendment right under the rug, and our purpose is to protect it.
Thank you very much, Mr. Sandman. Thank you.
Well, Mr. Sandman certainly answered our question, at least at this point in time, to use a phrase from a prior open judicial hearing before the Senate Watergate Committee. But anyhow, what I was going to say is he answered the question. Yes, indeed. At this point, at least, there is an intention to go through the other 8 specifications under Article 1, much like they did this one tonight. Now, back to my question that I was about to ask our 2 guests, Bill Van Alstyne of Duke University and Martin Diamond of Northern Illinois University. Gentlemen, the question was raised by a member of the committee, and the question was this: has this 11 hours today been wasted?
Oh, no, I think not. As a matter of fact, Mr. Sandman knows what the Republicans will be about, but I do not know of any new objection that can be raised with regard to this article. In fact, I would privately view this vote as exactly the signal vote on the totality of the article. In fact, and I would be surprised, moreover, even if the numbers were to change, because it does seem to me the 11 hours have been enormously useful in fleshing out all plausible objections of a highly legal and even quasi-legal character. Their sheer reiteration may have some public effect in the kind of Chinese water drop torture theory of public education, but I can't imagine that any point could be raised with regard to the next 8 subparts that was not explored here. So it does seem to me that it has been effectively resolved, however the committee now behaves itself.
Well, what you're saying, really, Bill, is that there is a coalition now in the committee which is formed, and it now appears that that coalition can stand firm, that it can beat back the attempts by the President's defenders to reform this article of impeachment.
Oh, yes, I think so.
Yes, but that still doesn't close the issue. It's clear, it seems to me, from the vote that there are 26, 27, or perhaps even more who want some kind of article of impeachment. And what they did now was to turn back the motion to strike, which would have been the victory of the anti-impeachment forces. Now, that was done definitely. But what will be the final shape of this article is, in my judgment, as yet in doubt. Congressman Flowers is not yet satisfied about the question of specificity. Congressman Railsback is not yet satisfied. During the course of the discussion, there was movement responsive to the demand for further specification.
But I think we should point out that on this crucial vote, both Congressman Flowers and Congressman Railsback voted with the pro-impeachment forces.
Without question. They voted not to abandon the article.
Well,
but that doesn't mean they will not tomorrow turn up with emendations of the article or additions to it, reading in a report, reading in a summary, reading in an index, this or that to it. I believe that further conciliatory efforts, partially in the direction of further specification, both for satisfying their opponents, possibly winning one or two other Republican votes, and for public competition for sentiment on the issue, will result tomorrow.
I think not. In fact, I shall be very surprised if that's what the coalition does. It's certainly contrary to the professional advice they're receiving from John Doerr and the embarrassment he regards it would cause to the prosecution in the course of the House and Senate consideration. It seems to me what they have decided essentially is this, that to their satisfaction there is clear and convincing evidence which would convince reasonable persons that in this respect the President did in fact make false and misleading statements to lawfully authorized investigative officers. Now that's not very specific because the particular conversations, the particular officers are not here set forth. That's to be done. Doerr has satisfied them that due process will be served when he is willing subsequently in the report and then with cross-index references to make that specification. Each of the others, it seems to me, lays in exactly the same framework of understanding. Now, to be sure, the members of the coalition have avoided their mutual embarrassment because not all will agree on any particular set of conversations. Yet it seems to me that problem will replicate itself in each subsequent stage. Thus, they have held together exactly in taking this general stance, and I cannot imagine that they would have reason now to back away and suddenly to particularize more than they agreed to do in this occasion.
You still disagree, Martin?
But I'll swallow my prediction. I eat them every day.
Well, they're also running through toward the end. There was an indication that, for instance, on the part of Railsback, yes, let's have a bill of particulars now. But then remember that was followed by the interplay between Latta and Doerr, which Republican Latta, defender of the president, asking John Doerr how the president would find out exactly what the charges are against him, and Doerr explained this procedure. And the question now, I guess, well, we could say from the vote at least on this particular specification of the article that apparently would be enough, but we shall see. I would like to get back to my original question, which was what about this total 11 hours, this total day in terms of a process of impeachment and in terms of watching a process unfold and that sort of thing. Martin Diamond, what are your overall comments
about
it?
Well, I think in all such proceedings, it takes time for the lines to be drawn and for the issues to sift themselves out. And what fascinated me was the way a procedural issue became the focus or the crucible for the substantive issues. That always happens. Always it's some question of who will make the motion or what the language will be. Some procedural matter becomes the crunch, the place where the substantive issue comes to a head. And what happened during the day today, it seems to me, was the following. Those most firmly committed to impeachment, who are quite convinced and have been apparently convinced for some time, believe that Nixon is unqualifiedly guilty on all counts alleged in the 38 volumes that they've got accumulated. They number, it seems, something like 11 or 12. And it must be remembered that these are quite liberal Democrats, and there is an unusually high proportion of them on this committee. Then there are 8 or 9 apparently hardline opponents of impeachment, and their strategy is to disbelieve every allegation, deny that there is any guilt on the part of the president, but freely acknowledging it on the part of his subordinates. And their strategy is to assimilate everything to criminal proceedings. And there's something amusing in trying to get all the niceties of criminal law in defense of the president. But in the middle are 15 or 18 members of the committee, both liberals and conservatives, but who seem in the middle, leaning strongly to impeachment, but looking for some way to reach the political judgment of impeachment that will have every characteristic of fairness that will be capable of persuading the American people that their representatives are right in removing their president.
I'd like to thank you both for being with us tonight, Bill Van Alstyne and Martin Diamond, for offering us your opinions and your wisdom. Now back to Carolyn Lewis at the Capitol.
Well, we're here, and it's the witching hour, and we will be back tomorrow. Mr. Rodino has said we're going to start again at noon. We can expect more hassling, more of the same, more efforts to strike, more procedural debates. But maybe, if we're very, very lucky, someone will relent on one side or the other, and we might possibly, just possibly, late in the day, get to a final vote on the first article of impeachment. Back to you, Paul and Jim.
Well, one of the factors that has certainly been proved by today's debate, as we said just a moment ago, is that there now is clearly a coalition for impeachment, and this has been shown by the voting. And Jim is now at our tote board to give us some more detail.
Yeah, I would just think if we need to make any changes, Paul, from what we had when we began, this board, as you'll recall, is arranged according to the probable vote on the Article 1, which charges the President, alleges the President committed obstruction of justice in the Watergate cover-up. Based on our figures, when we had these, or definite votes, were 23 definite ayes, 11 definite noes. Mr. Freilich of Wisconsin, a Republican, undecided in his own category, and two maybes leaning toward impeachment, or leaning toward the obstruction of justice count. Now we can if we want to extrapolate the vote we just had, the 27-11 vote, I would think then it would be very proper to move Tom Railsback, Republican of Illinois, into this I category, Hamilton Fish, Republican from New York State, into the I category, put Mr. Freilich up here, and everything is neat and tidy. Right, into the, and we take the maybe ayes away, and the board is neat and tidy, and that's probably about all it is at this late hour. Paul?
Well, I could just add one thing, Jim, to what you said, and that is that Congressman Freilich, the Republican, has indicated that he may be ready to vote for one article of impeachment, and of course we could get an additional article that will be to his satisfaction.
Well, that's true. Maybe we ought to at least give him an inch on either way before we put him in there. But at least on this specific vote, he is there.
All right, that wraps it up for tonight. There was a critical vote in which the pro-impeachment forces won in a test that prevented any kind of striking of language in the first article on impeachment. This concludes our live coverage. We'll be back on some of these stations tomorrow morning and again tomorrow night if there is live coverage. We'd like to remind you now to stay tuned for our videotape replay. I'm Paul Duke for Jim Lara. Good night.
This is PBS, the Public Broadcasting Service.
Sir Arthur Conan Doyle, I do believe. So sorry to have kept you waiting. Do please sit down. Thank you. And how's the great man?
I beg your pardon?
Mr. Sherlock Holmes.
Oh.
In good health, I trust. Likely to be on the scent again shortly. I suppose I should congratulate you on the ingenuity and cunning of your plots, even if they sometimes show up we professionals in a rather dim light.
Seems there's been an appalling miscarriage of justice.
Do you think he's innocent?
Well, somebody does, because he's just been released.
What reason was given?
None. Now, that's what intrigues me. The young lad sent for my help. I got onto the Home Office. They refused to answer.
When do I see you again, Mr. Holmes?
Oh, in a day or two. It won't take long.
Well, you will keep me informed.
Well, of course I will. You shall be Watson.
The ATP Summer Tennis Tour will attract world-famous players competing for top prize money. Stan Smith, Arthur Ashe, Marty Reeson, Chris Evert, Yvonne Goolagong, Rod Laver, and beyond board are just a few of the players you'll see in major tournaments, like the Canadian Open from Toronto, the U.S. Clay Court Championships from Indianapolis, and the U.S. Professional Championships from Boston. All great tennis, all on this station, all summer long.
disturb it is to destroy it.
I wonder if I understood the gentleman correctly, in that I understood him to say that if we specify these acts in our accusatory pleading, the evidence to be adduced at the trial is restricted to those items which we have...
Of course, and that's the whole purpose. And what you want to do is give a man no chance to know what he meets and then bring in anything you happen to think of. And it's not constitutional, and it's not fair, and just because you're a congressional committee, you can't just tear the Constitution up and throw it away.
From Washington, NPAC brings you videotaped gavel-to-gavel coverage of the House Judiciary Committee proceedings. Tonight, the impeachment debate, July 26, 1974. Here is NPAC correspondent Jim Lehrer.
Good evening for Paul Duke and myself. The House Judiciary Committee spent 4 daylight hours leading up to its first test vote tonight on articles of impeachment. And in the beginning this morning, it began by arguing over and then voting down a motion to delay the proceedings pending the results, as based on the results of the Supreme Court decision on the Watergate tapes. This was voted down, and then the committee turned to its major business. Article 1, a proposed charge of obstruction of justice against President Nixon.
And it became clear as the committee began its debate today that the Republican defenders of the president would fight every half-inch of the way, employing a variety of parliamentary and debating devices in an attempt to delay the impeachment process, in effect to try to hold off an impeachment resolution from reaching the House floor. But it became equally clear that those supporting impeachment had welded a strong majority and could continue to hold that majority, despite the Republican objections that were voiced from time to time about the language employed in the first article of impeachment, the article that charges the president with an obstruction of justice. I think it was interesting today, Jim, that for the first time we saw the committee in action as a congressional committee can really be, and that is we saw wrangling, we saw acrimony, we saw members clashing with one another.
And we saw the basic issue joined in this daylight debate, the daylight session, which was the Republican position was that the wording of the articles of impeachment as proposed by Paul Sarbanes and supported by a majority of the committee were not specific enough. And that was countered, of course, by, that's the Republican charge, and that was countered by the basic majority rejoinder, which was that the article of impeachment should be general, and then there would be other things attached to it, through summaries, through everything. But that basic argument follows throughout the day and throughout the night, and you will see the beginnings of it and go right on through to the dinner break.
And now our colleague, Carolyn Lewis, who has been the on-the-scene reporter for the deliberations, is standing.